Welcome in, everybody, on this Thursday, January, 22nd. We are now on day 7 of the Brendan Banfield murder trial out of Fairfax County. I'm Annie Yu.
And I'm Katie Lasso.
You're joining us on our Plus station, our streaming WSA 9 Plus station. So thank you so much for joining us. And we've been continually joining you day to day, bringing you legal analysis from Frank Salvedo and Tom, talking about this very complex, disturbing case out of Fairfax County. Let's quickly bring folks up to speed. Brendan Banfield, prosecutors are accusing Brendan Banfield, a former IRS agent, of orchestrating this very elaborate scheme to kill his wife Christine and a stranger, Joseph Ryan. The prosecutors laid out their case last week in week 1, and now we're on to the defense. But in the midst of all this, very important key here is Juliana Magalhães, the au pair to the family who worked for them.
Right. And she has taken a plea deal, and part of that plea deal, she was required to testify for the prosecution, and we heard that testimony last week. She is subject to recall, so could we hear her again? That's a very good question that we're all waiting to see. And, you know, part of her plea agreement was to testify. She will get time served, so she would be released after this if she follows through on her deal with the prosecution.
Right. As far as Brendan Banfield goes, as we wait for the courts to get started, let's just go over some of the charges he's facing. 4 counts of aggravated murder, and also 1 count of using a firearm to commit a felony, 2 counts of child abuse, because remember, their 4-year-old daughter, or then 4-year-old daughter, was in the basement during this time, and 1 count of child cruelty. So obviously very serious charges. And as you mentioned, Juliana had already admitted guilt upon her arrest and agreed to a plea deal, which would mean time served and likely to be sent back to her home country of Brazil.
Right. She'll get that time served, so she would likely be released and then sent back to Brazil.
Right. So. Courts are expected to get underway at 9:30 today versus the usual 10 a.m. Because of the impending snow that we are getting here in the DMV. So the judge called it yesterday, wants to get ahead of all of the snow events going into next week, which is week 3. And so we're just waiting for the proceedings to begin. Do you want to go over some of the things that we saw yesterday unfold?
Yeah, and just so everyone at home knows, we will be on the air till approximately 5:30 tonight. That's when court is supposed to get out. Usually they get out at 5, but again, that extension from the judge because of this possible snow. And there's also the question of if there will be court tomorrow. The judge had requested the jury to come to court on Friday, but of course they may have other stuff going on. They were only obligated to be here Monday through Thursday. So we will see what happens as soon as court starts. We should get
and we'll keep you posted.
An idea there. But yeah, yesterday the defense, they got off to a strong start. They called 5 witnesses. We heard from 2 of the police officers who were the first people to arrive at the scene. One we had actually heard from the prosecution, and that was Officer Zachary Beckner with the Fairfax County Police Department. He was one of the first officers on scene. They played his body camera footage, and I want you to listen, if you can, to some of the moments that were really questioned by the defense and the prosecution. We've heard them repeatedly. This part about about Brendan Banfield being allowed to wash his hands. Take a listen.
We have tissues here. You want to wash your hands? Probably feel better after that. Soap right here.
Officer, is this the situation that the Commonwealth asked you about when you were originally on the stand?
About him washing his hands?
Washing the hands.
Correct.
Yes. And you weren't advised by anybody in your chain of command to not allow washing hands or anything like that?
At that point in time, no, sir.
I'm sorry?
At that point in time, no, sir.
Okay.
Those were the moments that a nurse appears to ask Brendan Banfield if he wants to wash his hands. And, you know, that's been a big topic of discussion because everyone wants to know, why would you let Brendan Banfield wash his hands? And by doing so, they were not able to collect blood samples. His hands were covered in blood.
But in the bigger picture, speaking to that, what does Frank Salvedo, our legal analyst, think about that? Is that a critical piece in this?
Yeah, he still stands behind the fact that he believes Juliana Peres Magalhães' testimony is going to be the biggest piece of evidence here. He said it's important. It really depends what the jurors are taking away from it, but he didn't believe it was, you know, a key piece of evidence here, as big of a deal as we might be making it, and as it seems like the defense and the prosecution are making it.
And I mean, he did have blood on his hands. the forensics analysts that they brought in really seemed to dissect the clothes and the blood splatter in the room. It'll be interesting to see what the jury members take away from all of that blood stain analysis. Clearly in that video, as we heard the footage, you could see Brendan Banfield visibly upset and sad. Crying, wiping away tears.
Yes, we saw a lot of that during when the body camera footage was being played, specifically when he found out his wife died, when he was, praying with the chaplain. We want you to take a listen to the moments Brendan found out that his wife did not survive while he was in the hospital hoping to see her.
Your wife has died. So sorry.
Where's the daughter?
Where's what?
She's still at the scene, sir. She's with the other officers.
And you heard that last part there. He was asking, where's my daughter? And we know that she was at the scene at that moment, but then she and Juliana Peres Magalhães were both taken to headquarters to have a conversation with investigators.
Yes. Meanwhile, Brendan is at the hospital with Officer Beckner, one of the first arriving officers on the scene, and we hear the nurse informing, or a hospital official informing Brendan of what's happened. And we also learn through that audio the hospital officials saying that Christine had enormous wounds.
Right. Yeah, there was a moment where you hear this conversation back and forth between, you're right, we don't know if it was a nurse or who it was from the hospital, but this conversation of she had enormous wounds, and he says, I was trying to hold her neck, and the person is saying, there's nothing you could have done. These wounds were so bad that she was not going to survive that.
She had an incredible amount of blood loss.
Right.
And if you remember Christine's father, Gary, who had taken the stand the day before, he did share Christine had a blood disorder or
some sort of medical issue with her blood, but then also bruising, and I'm curious to see if that comes back up at any point. I'm not clear on where that will go. He was the last witness called by the prosecution.
And speaking of Christine's father taking the stand, I think a lot of us were surprised at just how quick it was, and I was, again, expecting a very emotional testimony. I wanted to learn more about how this incident impacted the family, what the marriage looked like, this dynamic relationship between Brendan and Christine, and more about the intimate details of their lives. But we did not get that. Instead, we just learned more about just Christine not, being sort of not really sort of reluctant to engage in like rough sports or not the athletic type.
Injury prone.
Right. Suggesting that she was perhaps not into the, sex fantasy that the
narrative
concocted.
Yeah, I think that was interesting. Frank kind of speculated, as he said, he was like, I don't know what's in their minds when they're having these conversations and the prosecution is asking these questions, but he was like, my best guess is that they're trying to allude to the fact that she wouldn't have been into the type of things that the defense is trying to say she was a part of, that she was the one to have this conversation with Joseph Ryan and bring him to the home. So it was interesting to hear his testimony. But yeah, back in that video though, you hear Brenden at one point say Christine's parents are on their way to the hospital. So just a ton of emotion in that hospital room. And the second person to testify after Officer Beckner was another officer who was also there. He was at the scene with Officer Beckner, and he went with them to the hospital. So that was kind of a similar testimony. They played some of his body camera footage as well. Now, none of that body camera footage was shown to the room because of how graphic it was. I mean, we're seeing the moments that the officers walk into that home.
Yeah, just a horrific scene. We also heard from a private investigator, Harry Lidsky. What did Harry have to share?
Yeah, he was actually an interesting person because they were kind of bouncing back and forth between him and Detective Miller. So his testimony, he was a private investigator, and he was called to the stand after Detective Brendan Miller, and his purpose in being called was to kind of analyze Detective Brendan Miller. So Brendan Miller is a former forensic investigator for Fairfax County Police Department. He's still with the department, but in a different capacity. And the defense has been trying to say that he was transferred from his position because his views on what the devices, who the devices were in the hands of, didn't line up with the prosecution's story. We actually do have some of that conversation. If we can play that for you, the conversation between Brendan Miller and the defense attorney.
What were your conclusions in your executive summary that you wrote before her recant?
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner,
Christine Banfield.
All right, and those documents you just saw there at the end, those were his summary notes that were shared with the jurors. I do want to mention, though, that the prosecution then got up on the stand, and we actually have that conversation as well, if we can play that for you real quickly, and then we can discuss. But it's her response to the defense conversation with Detective Brendan Miller.
Were you able to put someone concretely behind the screen?
At times, yes.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
All right, powerful moments there,
Yes.
kind of going back and forth of, you know, the final answer being, yeah, I don't actually know who was there. So interesting to see that. You know, we're expecting some more witnesses from the defense. Curious to see who comes out there.
A long list that he provided. Also, what I found interesting was at the start of the day yesterday, John Carroll, Brendan's attorney, started the day off with asking the judge to drop the charges. This was the second time he had asked.
Right, he did it the night before.
Sure, yeah. And so my question is, according to Frank, is this standard operating procedure? Did he have grounds to even make that request? In his opinion?
Yeah, so Frank said it is pretty standard that he would do that. You know, the prosecution had just finished when he initially made the motion to strike, and his key points were that the prosecution didn't call any homicide detectives, any detectives who were involved in the case. Again, he's alluding to the fact that the detectives were transferred when the prosecution's story was not matching with what the detectives were saying.
The prosecutors did not make their case.
Right. So a couple of different things there. He was also saying that at one point he was saying Juliana lied on the stand, and he was saying this is preventing my client from getting a fair trial. He says you have a witness up there who's making up a story. Her story has changed so many times, and saying, how can you trust this woman? And the judge said, you know, I don't see any fault in her testimony.
Dismiss the motion.
Yeah, she dismissed the motion, and then you heard the prosecution get up there and say, hey, just because the defense attorney doesn't like what she's saying doesn't make it a lie. So I do think, you know, we already saw that conversation happen twice. The judge dismissed it both times, and it's important to note the jurors were not in the room when those conversations
They were not in the room
happening.
when that conversation took place. It'll be interesting to see how the day starts today. That's how we started yesterday with the jury members out of the room, and John Carroll, Brendan's attorney, asking for the charges to be dropped. So I'm curious as to how the day will unfold today. We heard from 5 witnesses yesterday from the defense. Any idea on who we might hear from today?
You know, I think the first conversation when we go in there is going to be about this, you know, storm that's coming our way. I think that'll be the first thing that's decided. You know, we don't know how many witnesses John Carroll has left. He said 4 to 5. He's already hit 5. So I'm curious to see who he does call next. Is it going to be more investigators? Possibly. You know, Frank and I were talking yesterday. Do we think he's going to go back to the emotional? He started out emotional. Will he end with emotion? Or was that his emotion? That part in the beginning where you're listening to the body camera footage, you're seeing his client crying. It does look like they are about to start. So we're going to take you inside the courtroom right now.
stuff we did yesterday, may we approach?
Okay, sure. All right. Are we ready for the jury then?
Yes, ma'am.
Okay. Thank you. All right, good morning, ladies and gentlemen. It's my understanding from Deputy Johnson that all of you are available for tomorrow. Is that correct for testimony? All right, perfect. All right, your next witness,
Officer Kasanova?
Officer Casanova.
Are you making this argument about the Juliana?
Your Honor, can the main screen be released if it isn't already?
It is, there's nobody.
Okay, thank you.
It's fine.
Now I feel like I have to do it.
Please stand up, raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
Morning, Officer Casanova.
Morning.
I'm just going to ask you a few questions, but the first question is I wanted you to identify the picture that's in front of you. Do you see a picture?
I have a blank screen.
Okay.
Now I have a picture.
Okay. Is there any way, based upon just that snapshot of your body cam video, as to whether this is your video?
I can't say for certain.
Okay, let me move forward. And just stop me if you see anything that makes it clear it's you.
This does appear to be my video. I recognize my watch.
Okay. Sir, I'm going to go ahead and play this video.
We have to identify it.
Oh, sorry, Your Honor, that would be identified as Defense Exhibit 86, I believe.
I have an 86.
87.
87. Do you wish to have it in evidence?
Yes, Your Honor.
Any objection?
Yes, Your Honor, which approach?
Okay. So 87 will be introduced into evidence without audio. Does this need,
And sir, can you,
I'm sorry, does this need to be under seal? I don't know what it has on it.
I don't believe it does, Judge.
He does not go upstairs.
Correct.
Judge, I hate taking the risk, but I do not believe that Officer Kasanova goes upstairs in the house. I believe that he remains on the first level.
Is that correct, Officer Casanova?
I never entered the house.
Never entered the house.
Perfect.
Okay, so.
Judge, maybe
so-
we just approach about one other thing that I might see on there.
We're going to enter it without audio, and we're going to make it under seal for the moment. Okay, thank you.
Sir, can you please state your name and spell your name for the court reporter?
Sure, I'm Robert Casanova, Casanova.
And you've indicated that this is your video based on your watch.
Yes,
Okay, and we're going to watch this without sound,
okay.
okay? And from time to time, I might stop it and ask you a question. Okay?
Yes, sir.
Thank you. Sir, we pause for a second there. Is that you arriving at the house?
Yes, sir.
Okay. At 8:56?
If I can ask the court to clarify for the record, counsel referenced 8:56. That would be the marker on the video, not the time of day.
Right, the time of day actually says 8:14.
It was 8:56. I was showing the marker on the video, Judge.
Just the marker.
Reference for the officer.
Right, and the time on the video of the actual time would be 8:14. Okay.
Thank you.
Officer, at this point, as you're walking toward the house, were you given any direction as to what your duties were going to be at the scene?
Not at this point. I just asked Officer Batani, sitting on the sidewalk there, if he needed any help. And then I think that's Officer Hernandez, I asked him if he had crime scene tape, and he advised he was going to get it.
Okay. At this point, had you been given any instruction as to what you should do?
Yes, my supervisor had asked me to take over from, at the time, Sergeant in Training Bell.
Okay. Sir, is this the end of your contact with Juliana Peres Magalhães?
I believe I check on her a couple times, but for the most part, yes.
Okay, in the car?
Yes.
Sir, ultimately, when she left the scene, was it in your cruiser or in the cruiser that she's sitting in right now?
I'm not sure which cruiser she was in, but it was not mine.
Okay, you know that it wasn't you.
Yes.
What, other than checking on her, were you given any other duties while there?
I'm sorry, can you repeat the question?
Other than checking on her, which you've testified to, were there any other duties that you began after she was in the car?
Yes, after a short while, I took over traffic control duties, restricting vehicle access to the roadway.
Your Honor, this is 2545, and that's, those are all my questions for this officer.
All right, so just to be clear, then you would just want 87 in evidence up to 2545, correct?
Yes.
All right, and that'll stay under seal then, okay. All right, thank you. Cross-examination? All right.
No
Is this
questions.
Is this witness subject to recall?
No, Your Honor.
All right, you're free to go, sir, thank you.
Thank you.
Your next witness?
Your Honor, may I just check with Detective
Sure.
Byerson? There's Sergeant Brian Ames.
Sergeant Ames?
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
Good morning, Sergeant Ames.
Good morning, sir.
And are you a sergeant?
I am.
Okay. Where are you currently, what's your current station?
I'm in the IAB, sir.
Okay.
Internal Affairs Bureau.
And during the period of time, February 24th, 2023, through the end of 2024, where were you assigned?
I was assigned to DFS in November 2024 to February 2025. Before that, I was a street supervisor.
Okay. Sir, I'm going to have you take a look at some exhibits. Here, and I'm going to use the
Okay.
overhead if I can.
It's fine, we'll switch over to that. You just have to hit the button on the top. Okay.
Sir, can you see that document?
I can, sir.
Let me just straighten it out. Are you familiar with that document?
Sure, yes, sir.
Okay. I'm specifically looking at, and I'll just put my pen in there, at this particular area. Is that something that you authored?
I did, sir.
And so the sign out is Ames. That's you?
That is me.
And this is your title here.
Yes, sir.
Now, what is it that you're doing here with regard to this communication?
Your Honor, I'm going to object to the witness reading from the item. It hasn't been identified or offered in evidence.
I don't think the question was to read it.
No, it was not to
Okay,
read it.
all right, I'll overrule the objection at this point.
What were you doing? This appears to be an email thread. What were you doing?
Looking at the email, it looks like I received something from Lieutenant Giaio, and I was sending it out amongst the people who work for me. It looks like I CC'd my captain.
Judge, I am going to object. He's reading from the letter. If his recollection of this email is such that he can testify to its contents, then certainly.
So it'd be a foundation objection.
Yes,
Sustain that objection.
And sir, this is an email that you authored and you sent on to your colleagues. Is that correct?
That is correct.
Okay. Your Honor, I move this in as a Commonwealth's Exhibit number 88.
Any objection to that?
No.
Okay, 88 in evidence, and we can
Now, I would
publish
just
it
like
to the
to
jury.
ask you another question. The people that you were saying you were writing to were people that were within your section, is that correct?
It looks like I CC'd my commanders and two of the detectives that work for me.
Okay, and the two detectives are both named Brendan Miller?
Yes, sir.
And is one of those detectives the digital forensics analyst for this case?
Yes, sir.
Okay, and he's obviously in your section. And is this officer in your chain of command?
No, sir.
Okay, what?
Your Honor, counsel's making reference. He said this officer. I'm not sure who he's speaking
If you
about.
could, just
I
for
was
records.
just pointing, yes. I won't point, sir. David Giaio, it says Lieutenant David Giaio.
He was not in my division.
Okay, and yet he's communicating you regarding, what is it he's communicating about?
An executive summary?
Okay, is that Brendan Miller's executive summary? Do you recall?
I don't recall, but looking at this, I would have to say.
Judge, I'm going to object to any further answer. He does not recall.
No, overruled. You can finish answering, that's fine.
You can finish answering, you were saying, but looking at this.
It appears to be an executive summary.
Okay, now, was there a particular executive summary that Brendan Miller completed that was at issue while you were there in cyber security?
There was no executive summary issued while I was there. I was only there for 4 months, sir.
Okay. Was there, were you aware of any disputes with the executive summary, either within your division or another division?
I know that executive summaries are written on every case.
How about this case? How much contact did you have with this case during your time there?
With this case, not very much contact at all, sir.
Okay, and so what we're seeing is this extent of your contact?
Pretty much, sir.
Okay. Sir, I'm going to take 87 off, and I'm going to have you look at,
Judge, I believe that was 88.
I'm sorry?
Is that correct? He referenced 87.
Oh, sorry.
That was
Did I
88.
say-
You just did 88, yes.
okay, then that was 88 that I took off.
Right.
I'm going to identify what will be marked as Defense Exhibit 89. Can you see that email?
I can't.
Okay, and is that appear to be an email that you forwarded on?
It is.
Actually, you know what, I'll just let you tell me what it is.
It looks like Lieutenant Giaio forwarded a proffer to me,
Okay,
and then I forwarded on to my detectives and CC'd my supervisors.
okay, and you said a proffer, or are there two proffers there?
I don't know. Normally the system works where you get two different angles. I can't recall
Okay,
if that's one or two.
so you never examined those proffers?
No, I'm sure I clicked on them before a meeting, but I don't recall if it's two separate parts or if it's just two angles.
Okay, and where you sign off as Ames, that's you, correct?
Yes, sir.
And Sergeant Brian Ames, all of the things relating to that were correct as of the time of this writing on
Yes, sir.
November 8th, 2024?
Yes, sir.
And you're CCing, I assume, superiors?
Chain of command, yes, sir.
Chain of command, okay. And Brendan Miller and Brendan Miller are the two people that this is directed to?
Yes, sir.
Okay, now they're in your chain of command. Would that be an order that you're providing them? Here, I move this in as Commonwealth's Exhibit 89,
Any objection?
No.
All right, 89 evidence.
if we can have that published.
I mean, yes, I guess since I'm their supervisor, if I send them that, I guess it could be perceived as a command, but that's not really the way it works. It's their detectives looking at a case.
Okay, so let me ask you a question about that. By saying their detectives looking at a case, you're saying you leave the detectives alone to do their thing?
I'm saying that I had 4 months there. I wasn't really caught up to speed on digital forensics. That's not my specialty. Like I haven't been trained in that.
Okay, so you're a supervisor for the people that are trained and as
I am.
experts? Okay, and as a sergeant in your chain of command, are you being ordered to do something by the lieutenant from homicide?
I think I'm being asked to look at this, like this is the way information sharing would happen, is we're not homicide detectives over in that squad. We're kind of, we're a support unit over there, so that's how the information would come in.
Okay. So if I understand you correctly, cyber investigator, Criminal Investigations Cyber and Forensics Bureau is a support bureau for homicide?
Well, specifically to digital forensics is a support bureau for all the other bureaus when they have digital evidence.
Okay, and is it common for the lieutenants from other bureaus to communicate with you in this way, to have your detectives do things?
No, there's a lot of back and forth. Like I kind of, when I was in that position, I kind of feel the calls, send stuff up the chain of command, figure out what the detectives think are best for the case, stuff like that.
Okay, so you're going up the chain of command. Is it something related to the communications that you're receiving, or is that something that you would do with every communication?
Since I was a newer sergeant at the time, it was my understanding the expectation out of my command was to link them into pretty much everything that I was doing.
Okay, in the form of, in the immediate moment you received an email?
If I was doing ESRs, like they got them, if we had a case that was unusual, or if we had anything, like I said, I was a newer sergeant. It was my understanding, the expectation on me was to forward stuff up my chain of command. That is correct.
Okay, so this is commonplace, what these emails show?
I would say at that point, when I was in DFS, with me being newer, I looped them in on a lot of stuff.
Okay, thank you. Your Honor, I've moved 89.
89 is in evidence.
Okay. Sir, I'm going to have you look at what will be marked as Defense Exhibit 90. Do you recognize that? I know you send a million emails
Yeah,
a day,
I
but do
send
you
an awful lot.
recognize this particular one?
Yes, this is my email, sir.
Okay, and this, and I'm pointing with my pen, appears to be you, that's the way you would sign off?
Yes.
And this would be all of the information that's accurate as to where you were working at the time?
Yes, sir.
And what about this up here? What was that? Do you have any idea?
I don't know without seeing it. I mean, based on the context here, it looks like it's a timeline
Okay.
from Lieutenant Giaio
Okay.
related to the proffer.
Do you know, and let me just call your attention to, and this is 89, correct?
That's 90.
90. Your Honor, I moved this in as Exhibit 90.
Any objection?
No, ma'am.
90 in evidence and published?
Sir, I'm going to put 89 there next to it.
Okay, not published? 89. Oh, he's put 89, okay.
I didn't ask you about, with regard to 89. Do you know what that is?
I mean, given the context of this, it appears that it's a timeline related to this case.
Okay. And I'm going to have you look back at 88. Do you know what the attachment was on 88? And when I say do you know, I'm asking, did you open it or did you look at it or anything like that?
I mean, I'm sure I looked at it, but if you're asking me right now if I know what that is exactly, all I can say is I can assume that it's an executive summary that has to do with this case.
Okay, thank you very much. Now, on 88, you've added Brendan Miller's, I guess, B1 and B3 they're called?
Yes, sir.
Okay. On 89, you added Brendan Miller, and then CC'd your command staff?
Yes.
on 90, I don't see Brendan Miller. Would that have been forwarded to them, or is this just specifically for your command staff?
That's just for my command staff.
Okay. And so there wouldn't be an additional email to show what you sent to Brendan Miller and Brendan Miller?
I don't believe so, given the context of this. I don't believe I forwarded that, but I don't know.
This appears to be dated November 7th, 2024. Is that correct?
Yes, sir.
And let me go back to 89. This was dated November 8th, 2024, correct?
Yes, sir.
And number 88, is dated November 8th, 2024 as well, correct?
Yes, sir.
Now I'm going to Sir, do you see that on your screen?
Yes, sir.
Okay, and same questions. Is this how you sign out?
It is, sir.
Okay, and this information is all correct?
No, that is, maybe I didn't change my, signature line at that point.
Okay.
I don't know exactly when my first day was up there,
Okay.
but that was my previous position.
Okay, and that's your email, correct? You authored that email?
It is.
Okay. And in this, just to point out a few things, November 8th, 2024, and it's to your command staff, not to the Brendan Miller and Brendan Miller. And there's an attachment, and that's the same, appears to be the same attachment as number 88. Is that I can show you 88 again if you'd like.
I mean, it appears the same, but I couldn't tell you what it is.
And this email is from Lieutenant.
I'm going to object to the leading.
Who's this email from?
I object to leading, and I object to the continued characterization of the items in the email that the witness has indicated he does not recognize and cannot tell the court or the jury what they are.
I understand. As to leading, I'll sustain leading.
Who's this email from?
Appears to be Lieutenant Giaio, sir.
Okay, and nothing's changed about his position or your position since we looked at 88, 89, 90?
I'm not sure why my title line is like that. I don't know. I believe at this point I'm in DFS, given the fact that I'm writing emails to that chain of command. I don't know why my subject line is different.
That's fine. As long as you can identify that as your email, that's fine.
That is my email.
Your Honor, I'd move this in as Defendant's Exhibit 91.
Any objection?
Yes, Judge, I'd object. It contains statements made by a party not testifying. It would be hearsay.
All right.
Your
I
Honor,
assume that's a hearsay objection?
Yes.
Okay.
Your Honor, I would just identify that for now.
Just identify, you don't want to put it in evidence?
I won't put it into evidence. I'll put it into evidence when I call the next
Okay,
witness.
so 91 is not in evidence. Okay, next question.
Now, Sergeant Ames, in your training as an investigator, are you the type of investigator that follows the evidence, or are you the type of investigator that follows a theory before the evidence is developed?
Me as an investigator, I go with evidence.
Okay. As an investigator, when you question individuals that may be suspected of a crime, do you let them just tell you the story without challenge?
Objection is to leading.
All right, sustain as to leading, if you want.
What, if anything, do you do when you question a suspect in terms of their story?
I mean, I have a conversation with them, sir.
Okay. And if the conversation isn't consistent with the evidence that you have, how do you handle that?
I mean, if I have the opportunity, I clarify it.
Okay. And in clarifying, what is it exactly that you're doing when you have a dispute with, or conflict with what you know versus what the person's saying?
Can you ask that again, sir?
When you have a situation as an investigator that you're trained to be, and the facts as you know them are different than what the person is saying to you in the story or whatever conversation you're having, how do you handle that?
I mean, if I have the opportunity, I follow up and ask questions that I need to know the answers to.
Okay. And would there be any reason that you wouldn't have the opportunity if you're talking to them?
No, I mean, defendants, if you're talking about a suspect of a crime, I mean, they don't have to tell you. You can ask the questions, they don't have to tell you if that's what you're asking.
Well, I'm just asking, say, let's assume that nobody's claiming the Fifth Amendment. There's just a statement based upon what the evidence you know. What I'm trying to get at is how do you get to the evidence to determine if what you know is correct through the person that you suspect is the criminal?
If you're asking what I do, I generally ask questions till I understand.
Okay. And in terms of the types of questions, how do you do that, or how were you trained to do that?
Judge, I'd object to relevance at this point. I'm not sure where we're going with this witness.
I think it's relevant to the investigations that would go on in any case, in any criminal case.
I'll sustain the objection as to relevance to this case.
In that situation that we were just talking about, would you challenge an individual or not challenge an individual?
Same objection, Judge, relevance.
I'll sustain the objection.
Okay, I'll move on, Judge. You've seen Defense Exhibit 88, 89, 90 have been moved into evidence.
Yes.
91 has been identified by you, sir. Were there any other additional communications, either telephone or meetings, relating to the subject matter of these three exhibits that you know of?
This has been so long ago now, I don't know.
Okay.
I mean, there quite possibly could be another email or text. I don't know.
Okay, I'm just asking if you know of something. I'm not asking for you to speculate.
I don't know.
During the time frame you were there, I think you said February 25 was when you left?
I believe it was February 25.
Okay. Had Brendan Miller, the digital forensics detective in this case, had he been transferred at that point?
I think he transferred either right before or right after I left.
Okay. Did you have any role in his transfer, whether administrative or making the decision?
No, not making the decision. I think my role was figure out where Miller wanted to go initially and just be a first-line supervisor for him.
Okay. And would that include, would that first-line supervisor role, would you have a lot of contact with him?
I mean, I had contact with him every day.
Okay. And would the contact that you had with him be related to the Banfield case?
If things came up, yes, I would have contact with him about the Banfield case, but it wasn't, it's not like I'm doing forensics or anything. If questions come up, I generally shoot an email at my chain of command or stuff like that.
Okay.
I mean, I'm not advising him how to go through data or anything like that. It's, my job was, you know, I had other things that I was doing, budgets and distributing cases, new cases coming in.
Okay. Did you have anything, were you a decision maker in his transfer?
No.
Do you have any idea why he was transferred?
I wasn't brought into those conversations. I pretty much was told that the decision had been made, I wasn't involved in those.
Okay. And was there anything that you were told about the decision that was made?
Not that I can remember. I mean, there was, right, it's a police department. There's rumors going around, but I don't know what would make the difference. I don't know where the rumors would stop and what, I don't think I was told specifically why he was being transferred.
Okay, well, I don't want to put you in that spot, so if you don't know. Were you aware of how the experience that Brendan Miller had? The one that was transferred?
I knew that he was I can't think of the terminology, certified, yes, I know that Miller is experienced.
Okay. And he'd been there for how long, do you think, prior to you leaving, or prior to him being transferred?
I don't know.
Okay. In terms of your making the decisions of assignment of cases, where would he be in the decision process for you?
I don't know what you're asking, sir.
Would he be one of the more experienced ones that you would assign to, or one of the less experienced ones?
The other Miller was kind of the person who I bounced what we were going to do. He was the other Miller was the more senior Miller on the squad, so I bounced most of my decisions off of him.
Okay, and then he'd assist you with that?
He would, yes, he would assist me in that.
And do you know how long he had been in the digital forensic section?
No.
Okay.
I know it was a while, but I don't know.
Okay. Judge, I don't have any further questions.
All right, cross-examination.
I'm going to leave 91 there, if that's okay.
Oh, that's fine.
Good morning. How are you?
Good morning, ma'am. How you doing?
All right. So just so we're clear, you weren't in digital forensics very long, correct?
I was not.
Okay. And you didn't get involved in any of the actual digital forensics involved in this case, correct?
No, ma'am.
Okay. And you weren't involved in Detective Miller's transfer?
No, ma'am.
And you weren't involved in Detective Miller's work on this case, correct?
No, ma'am.
Okay. These emails you've been shown, you just passed them on, is that correct?
That is correct.
They didn't require any specific action of you, correct?
No, ma'am.
Okay, and those requests were to examine the evidence in this case in the context of new evidence that had been received. Isn't that correct?
That's correct.
Okay. Did you change, distort, or hide any evidence in this case?
No, ma'am.
Did you direct anyone to change, distort, or hide any evidence in this case?
No, ma'am.
Thank you. Nothing further.
All right, any redirect?
Sir, I appreciate your answers. Did you feel as though anyone was suggesting that you distorted, changed, or did anything to evidence based upon these emails?
No.
Okay. Thank you. I don't have any further questions.
Is he subject to recall?
No, Your Honor.
No, ma'am.
All right, you're free to go, sir. Thank you. Have a
Thank
good
you.
day.
You
Your
have
next
a good day.
witness?
Leah Smith.
Excuse me?
Detective Leah Smith.
Detective Smith?
Raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
Good morning, Detective
Good morning.
Smith. Can you please state your name and spell it for the court reporter?
Leah Smith, Leah Smith.
And what division in the Fairfax County Police are you currently in?
Homicide.
Okay. And were you in homicide during the time of February 24th, 2023?
I was.
Okay. So you're familiar with this case, and the Banfield case, and the Juliana Peres Magalhães case?
I am.
Okay. And as a homicide detective, you're trained in certain investigatory techniques, correct?
Yes.
What are those, if you could just tell the ladies and gentlemen of the jury?
So we are gatherers of facts. We will respond to scenes, talk with patrol officers who have already arrived. They'll give us a briefing of the case. We'll identify people that we need to talk to, places we need to go, and gather other information and track down what information we have gotten, and if we need surveillance video, or go to stores and track back movements, identify people to talk to. We'll canvass a neighborhood. We'll talk with crime scene to figure out what needs to be done in their capacity and how that will work in our capacity. We will just gather all the information that we can and put together, to the best of our ability, what happened in a particular incident.
And how do the theories of cases emanate from an investigation?
So the best course of action when you're investigating a case is to collect facts and information. You don't have theories to begin with. You have an open mind going into it because you don't know what happened. And then you try to gather all of the information so that it gives you a clearer picture as to what happened.
And in terms of gathering the information in order to get a clearer picture for, I guess, the entire squad, what mechanisms do you utilize in order to make sure everybody's on the same page?
We discuss what we've done, who we've talked to, what information we have gathered or captured. If crime scene will let us know what they have. We usually have a detective who is with crime scene as they're doing their work, and they'll pass on information. If we have other entities doing work on our behalf or assisting us in any way, they'll provide information, and then that will be discussed amongst the squad so that we all have a full picture of what we know.
So beginning with February 24th, 2023, had you developed any theories on that day based upon what you saw at the crime scene?
No.
Okay. Give the ladies and gentlemen of the jury as to kind of what the timeline is for any theories that you may have had.
Personally?
Yes, as an investigator.
So I did not, and don't have or don't create theories as I'm investigating a case until I have all of the evidence that we can collect. And even then, a theory of the case and how it's going to be presented in court is really something the Commonwealth's attorney is going to do. They're the ones who are going to present it. So we will give them all of the facts and all of the information that we have, and whatever theory that's going to come from that is something that they're going to present to it. We do make a determination if there is probable cause to get warrants for somebody in a case. So in this particular case, I did not have a conclusion until we had all of the evidence in the room.
Okay.
The blood evidence and all of that stuff, that was really understood.
And, okay. What was the time frame on it, acquiring all of that information in order to potentially have theories? If you were
Those pieces came in toward the very end of the investigation.
Okay.
A full understanding of the sequence of events that we could tell and understand in the room that came toward the very end.
Okay. But in terms of the hard evidence that's done, like DNA, fingerprints, digital forensics, when is the evidence available in order to arrive at conclusions or rule things out or any of those sorts of things?
That's a sliding situation. So things are submitted to the lab, and you might get information and lab sheets back in different times. It's not all given to us at once. And so having that portion of the investigation, you might submit something and then realize that you need to submit more things, or the lab will only take a certain number of things, and then you do a second submission. So then your lab sheets will come in as they come in, kind of in a longer time period.
And the decision process amongst the homicide investigators, is that just within the room of homicide, the actual investigators?
Let
me see if I can articulate that a little better. You've just described the gathering of evidence and the discussions. Would that be with the homicide detectives, or who else would be included in that?
It could be anybody who's involved in the investigation. We do briefings with all the entities that are part of it. So it could be computer forensics, it could be crime scene. Our supervisors are there. If we're having, so it could be different meetings over the time period of the investigations. There might be different people who are present during those discussions.
And is it, would you describe the homicide group as being the investigators and the supervisors in another way?
The homicide detectives are the investigators, yes.
Okay, and just so it's clear for the jury, the chain of command going up, the supervisors, they're not investigators, correct?
They are not investigators, they are supervisors.
Okay. Did there come a time when supervisors were suggesting theories to the homicide investigators in this case?
So we had a briefing within the first week of the incident where we were discussing everything that everybody had done and the information that was collected. And our supervisor at the time told us there were 2 theories in the case and we needed to get behind the right one.
Who was the supervisor?
Lieutenant Smug,
Okay. Who was in the room?
the homicide investigators, the detectives.
Okay, were there any other people?
I don't recall if there were victim services or advocates or our crime analyst or others who might be there during a briefing when we have just had an incident.
Was one of those theories catfishing?
It wasn't stated what the theory was. It just said there were 2 theories and you need to get behind the right one.
Okay, at some point, in order to get behind it, you had to know what it was. When did you find out?
I'm not sure who said exactly that it was catfishing, that was what it was. That's just what I had begun to understand and hear from other people.
Now, did you or any of your, well, actually, I can only ask you, what, if anything, did you do, given what you've just testified to the ladies and gentlemen of the jury about your methodology, what, if anything, did you do or say after hearing that?
I told Lieutenant Smuck in the room full of investigators that at this point in time, nobody should have a theory in the case, that we are still at the very beginning and we should only be investigating and gathering facts and information.
And how was that received?
There was no response.
And did this meeting end? Did the conflict between your statement and the theory that was sitting out there continue in conflict after this meeting? Like in future meetings?
I would say that the investigators on this case knew to investigate with an open mind, even though that might not be along the lines of what the supervisors might have wanted us to look at, how the case to investigate a particular line.
Okay. And did there ever come a time, I know you said at the end of the case that the catfish theory went away.
Objection leading, objection, facts not in evidence.
As to leading, I'll sustain. As to leading.
When, if at all, did the theory of catfishing go away from this case?
I don't know.
Was that then, well, did it ever go away?
I don't know.
Okay. And would that be for you to know, or would that be someone else within homicide?
Judge, I'm going to object to the form of the question. I don't think go away is clear enough. I mean, obviously, we're here on a catfish theory.
What's your legal objection?
Judge, it form. That is an unclear question.
Overruled. Go ahead. You can answer. Remember the question.
You're right. Would you just mind repeating the question?
So what I'm trying to determine over the lifetime of the case, was the catfishing theory ever disregarded or put to the side?
No.
Was there, during the life of the case, was there periods of time where the homicide squad was not supporting the catfish theory?
So everything is on the table. I wouldn't say that it wasn't, we explored all options, and that was always on the table.
Okay. And when was it that in your mind, catfishing was confirmed or negated?
It was toward the end, I would say, that once we understood the full for the investigation, catfishing is maybe how you got to a point, but what happened in the room, in the bedroom, that is really what you need to figure out. That's the determination of who would be charged in the crime of murder. So once you understood all of that and what happened within the room, and then you have the other evidence of it coming forward and through the digital forensics and the interviews and all of this stuff, that decision was made on who to charge for it based on the forensics evidence.
And you charged Juliana Peres Magalhães in October of 2023, correct?
Yes.
So was it concluded at that point?
She was charged for her involvement in the crime. So she wasn't charged with Christine.
Right. And so was it based upon her recantation that Brendan Banfield was charged?
No.
In terms of the catfish theory, actually strike that, Judge. I don't have any further questions, Your Honor.
All right, cross-examination.
Good morning, Detective.
Good morning.
So you've told us that you conducted your investigation in a manner consistent with following the evidence. Is that correct?
That's correct.
Okay. You explained to us that theories were certainly discussed, but that they did not drive how this investigation was conducted, correct?
Ultimately, no.
All right. Counsel asked you about this meeting where you were told and detectives were told that there were two theories and you needed to get behind the right one. You challenged that, correct?
Correct.
Okay. Did that statement impact how you investigated the case?
No.
Did you see that statement impact how your coworkers investigated the case?
No.
Your investigation was focused on who killed Joseph Ryan and Christine Banfield, correct?
That's correct.
And you followed the evidence in your investigation, and that evidence led you to charging decisions, correct?
That's correct.
Okay. Juliana Peres Magalhães was charged because you were able to prove that she shot Joe Ryan. The evidence supported that, correct?
Correct.
Okay. And Mr. Banfield was charged when? What was the turning point in your recollection of when Mr. Banfield was charged?
When we got the blood evidence back.
Thank you. Nothing further.
All right, redirect.
Detective Smith, were you ever feeling pressure to follow a theory instead of evidence in this case?
I did not.
You spoke out about it, correct?
Yes.
Did you feel pressure by command after you spoke out about it?
No, I did not feel pressure. I know what I have to do as an investigator. I know how to investigate, and no matter what they thought or the theories they wanted to put forward, that was not how I was going to investigate or provide mentorship or counsel to other investigators on the squad.
Did you raise that with other investigators, the appropriateness of command staff suggesting theories?
Yes,
And did you address that with the group?
individually as a group, yes.
And who was it that was applying the pressure to you?
Whoever was in charge at the time, at the beginning, Lieutenant Smuck, who made that comment in the first time.
After March 24th, March 24, 2024.
It would become from Lieutenant Giaio and Bruce. I think at the time it was a Captain Bruce.
Thank you. I have no further questions.
All right, is this witness subject to recall? No? No? No, ma'am. All right, Detective, free to go. Thank you.
Thank you.
All right, ladies and gentlemen, since we started a little early, I'm going to go ahead and have our 15-minute recess now. All right, do not discuss the case and do not do any outside research. We'll see you in 15 minutes. Okay?
All right, the court is taking a break, about 15-minute break now. Court did start at 9:30 this morning, a little earlier than that usual 10 a.m. start time because of the snow event that we're going to be hit with this weekend.
These breaks could be a little longer because of that, because they're going to have a longer day. So we'll see, but at least 15 minutes.
Yeah, and so for those of you glued to this trial, welcome back into WUSA 9 Plus. I want to remind you that court sounds like will be held tomorrow as well on Friday.
Possibly, yeah.
Yeah.
The jurors are available, so we'll find out soon.
So likely than not, court will probably go on tomorrow, and this is different, right? Because we were told that the proceedings would just be Monday through Thursday, and now tomorrow. So be sure to
and actually I can add that I just got an update from Matthew Torres, who's in the courtroom, and there will be trial tomorrow.
Okay, there you go. So
Friday trial.
And I presume 9:30 start like today.
Yeah, it'll probably
in
be
that window.
in the 9:30 to 10 a.m. hour. So we'll get some clarity on that in a few moments.
We just went to break following Officer or Detective Leah Smith, and this was really interesting. Of course, we'll talk about the other witnesses, but a lot of the other witnesses sort of dragged on, but I think what Leah Smith got to was very important. She was the homicide detective on this case, and they really peppered her about this theory that was floating around the investigators, right? Let's clarify first the catfishing theory that was applied to this case.
Yeah. So the theory that they're talking about is the theory, if you will, that Brenden and Juliana created this fake profile for Brendan Banfield on the FetLife website. They created a Gmail account, then created a FetLife username, and then lured Joseph Ryan to the home.
Which is what catfishing is.
Right, and that's
so
the prosecutor's theory.
And we're all sort of familiar with what catfishing is, and so they're applying that catfishing theory to this case because that's what prosecutors say happened.
Right.
So the defense is really trying to find flaws in this theory and has officers from this investigation up on the stand to prove a reasonable doubt.
Right, and so what they were it's really centered around a detective who was called to the stand yesterday. His name is Brendan Miller, and he is the detective that was in the digital forensics unit at the time. He's no longer in that unit, and John Carroll has really been pushing the point that he's not in that unit because the officers above him, his supervisors. Did not agree with his theory of the case. So you have this catfishing theory, which John Carroll is saying the police department was really pushing, but then you have Detective Brendan Miller's theory, and I have his conclusion summary right here. We were able to get it from the court yesterday, and his forensics conclusion which I do want to preface by saying, you know, he was brought on the stand yesterday and questioned about this, and he was questioned by both the defense and the prosecution. And I want to be clear that the prosecution, when she got up there, she said, you can't conclusively put someone behind the screens, and he said no. So keep that in mind. But we do have his digital forensics summary, and one of his findings was that he confirmed that Christine's phone was utilized to create that new account, the new Gmail account. And one of the things he made note of is that during the time of that account creation, he also found evidence that Christine was also chatting with Juliana on WhatsApp and shopping on a shopping app, Poshmark, utilizing the Chrome browser. So he says there were other things that she was doing, that she would be doing, while this account was supposedly being created. So he's just pointing out some issues there. Of course, the question being, you know, could they have been on her laptop while she was on her phone? You know, a lot of questions there. And one of the other things that he points out in his summary is that he had no indication that Christine lost control of her devices at any time during the January 9th, 2023 period to the morning of when she and Joseph Ryan were killed. So a lot more stuff on this summary here, but those are some of the key findings and some of the things that were brought up yesterday. And then you have these investigators today being brought up and really questioned about the transfer of Detective Brendan Miller, because we know he was questioned, or he was transferred shortly after he was told that those findings were not the findings they were going to go with. You know, they ended up arresting Brendan Banfield, but they also went with Juliana's theory, or her story, that they set it up. So a lot happening there, but let's go back to today.
I want to get on to the Brendan Banfield arrest, because Detective Leah Smith was specifically asked, when was Brendan arrested? And she confirmed, or in her testimony, she said that he was arrested when they got the evidence of the blood splatter back.
Right, the blood evidence. And that's been the prosecution's push. They've been saying, believe the blood evidence. They're saying Juliana is not the only piece of evidence we have here. Believe the blood, where John Carroll has been adamantly saying people lie, but forensics don't lie. So he's pushing on this forensics data, and they're pushing on the blood data.
That's right. Let's go back to the first witness call today. That was Officer Robert Kasanova. He was a responding officer on the morning of February 24th, 2023, and he stated that he never entered the home, but they did spend quite a while looking at his body cam footage with the audio off. We could not see it, we could not hear it.
About half an hour they listened to that.
It was pretty lengthy.
Or watched it, yes.
That's
there was no audio. So for those of you who were tuning in at home and you were just kind of watching a silent movie, if you will.
We saw some of your comments.
Right, yes.
Like, what is going on? Why are we watching this in silence? But what we learned out of that was he was the officer that had a Juliana in his patrol car.
He engaged with Juliana in some capacity, and it wasn't clear what their total interaction was, but that body camera footage, they watched it silently. So the judge ruled no audio. That was a request from the prosecution, and the defense agreed. So they watched the video. We couldn't see it because it has been sealed, but they watched it together and watched it quietly. And we did hear John Carroll asking some questions at different points, just asking, were you told what your duties would be when you arrived to the scene, things of that nature, but not a lot came out of that.
Not a lot came out of that, right? So that was interesting, because that was the first witness he called to the stand, and I wasn't quite sure exactly where this was going. Other than we learned he had Juliana in the car, and we know that morning following the killings that Juliana and the Banfield's 4-year-old daughter at the time, and I say at the time because she was 4 then, she's probably now 6 or 7, was transported to police headquarters. Sergeant Brian Ames was the second witness called to the stand. At that time, believe he was a street supervisor, and this is where he was asked about Brendan Miller's summary of this theory.
Right. And, you know, he was in the digital forensics section, the same section that Brendan Miller was in. And he was in that section for 4 months, he said. And he pointed that out a few times because John Carroll was asking him a lot of questions, and they were again focused around Detective Miller and the transfer of Detective Miller and the conversation of do you follow the evidence? Are you the type of investigator who follows the evidence or the theory? The theory being the catfish theory, as John Carroll has called it, and the evidence being that blood evidence or the forensics evidence. And he made a point to say he follows the evidence. So interesting there.
I'm just reading some of the comments that we were getting on our YouTube channel, and I think, you know, just like we were wondering, one of our viewers was wondering why aren't we able to watch this body cam or listen in? I know Frank's not here to let us in on that, but speculating why it might be under seal?
So a lot of this footage is very graphic. The judge said yesterday during when one of the other camera or the body camera clips were played, she said because of the graphic nature, we are going to seal this. They don't, you know, there are families here. There are families in the courtroom, families tuning in. And this is very graphic, and you know, some things the public doesn't need to see. It's just extremely graphic and invasive to the people who were killed that day.
So just want to address that question. Was there anything out of the witnesses so far? I mean, it's been only about an hour and a half, and we've spent a lot of time learning about the catfish theory and which officer was on board, which wasn't, you know. Anything that comes out at you as surprising in any of this?
A few things. You know, I think we all kind of expected to hear some of these things, but some key takeaways for me were when, you know, we heard from Sergeant, I believe he's a sergeant now, Sergeant Ames, and he was asked about the decision to transfer Brendan Miller. That's really been the focus of today. Detective Brendan Miller, the digital forensics section investigator who was transferred shortly after his summary was kind of disputed by the police department. And in that cross prosecution, we heard the prosecutors say to Sergeant Ames, you weren't involved in the transfer in any capacity. So we got some clarity on there.
And he wasn't.
He was not.
He was not involved.
No. But then Detective Leah Smith, I thought it was very interesting to hear from her that she talked a lot about how there were two theories, and the investigators in this case were told, you got to get behind one of them. We have two theories, get behind one. And that goes against everything she says she stands for, that being that they don't go by theories, they go by evidence. And she was asked, was it because of Juliana's recantation that Brenden was arrested? A reminder, Brenden was arrested in September. Juliana didn't, you know, change her or recant, if you will, until October and take that plea agreement. So there's almost a full month between Brendan's arrest and when Juliana agrees to testify. So the prosecution came back on and pointed out that that happened. You know, the arrest was in September, and said, did you change, did you feel pressure? Did you change or arrest him because of that theory? And she said, no, it was because the blood evidence came back. So that's why they initially arrested Brenden, according to this homicide detective who was very much involved in the case.
And I would think the prosecutors are using the catfish theory to sort of suggest that there was premeditation along this, you know, this orchestrating this murder scheme, that there was a premeditation involved and planning involved. And so now the defense is arguing against the catfish theory on several points, including you know, bringing the officers to the stand.
Yeah, and another big point from Leah, she was asked about, you know, on the cross back to the defense, John Carroll said to her, did you ever feel pressure to change and align with the theory that the department was pushing? And she said, I did not feel pressure, and no matter what was going on, she continued to investigate the way she would. So I thought that was really interesting, and I was kind of surprised that he would ask her that. You would think he would know ahead of time what her answer would be, and that kind of goes against what he was trying to present here today.
Yes. So now what's next? We're in this break here for another couple of minutes. When we resume, I'm curious as to whether the questioning with Detective Leah Smith will continue. I feel like it was sort of wrapping up. Did you get that sense as well, that he got what he needed?
I'm curious to see if he's going to bring up some of the other investigators. So he was asking her, you know, which supervisors were telling you guys had to get behind one of these theories, and she listed a few names, and I don't have their correct spellings down here, so I'm not going to try to guess the correct names there, but I'm curious to see if he's going to bring up any of those supervisors to testify to why they were pushing those theories. I think that quote, though, from her is extremely powerful, that there were two theories and you have to get behind one. I think that's going to be something he really pushes forward.
I agree. And remind us again how many officers from this unit were reassigned.
Yeah, so I believe there were 12 at the time, and I don't want to misquote, but I believe there are still 4 in the unit, and I can look back at my notes from that. That was pretty early on in this, correct?
Yeah, that
so
actually
I
was
have it,
presented, I believe, on the first day.
Yeah, so there were 12 homicide detectives in that unit at the time. Only 4 of those homicide detectives are still there. So, you know, a lot of transfers, the question of course being, were they transferred because they didn't agree with the theory?
Right.
Or were they transferred because they wanted to be transferred? You know, what was the backstory behind those transfers? And I think if he does bring up some of those supervisors, maybe we could get some context and clarity on why so many of those detectives are no longer in the homicide squad.
And why some of them didn't get behind the catfish theory.
Right. And remember, the prosecution didn't call any homicide detectives from this case. And that's something John Carroll used in his comments that he wanted to get this case dismissed. He said, why would the prosecution not bring up any homicide detectives? And we heard the prosecution say, why would I bring up a homicide detective to tell you the narration of what happened when I have somebody who was in the room? Why would I bring up a third party?
Yeah, and that was his argument, to which the judge, Judge Ascarati, denied that motion. So that's why we have resumed day 7 of this trial. And I'm sorry, Bree, did you say we're going into this?
No, we have quite a... Yeah, so I think, you know, we're going to see that play out. You know, when we go to the lunch break, which is coming up in a few hours, we are going to have a legal expert here with us. Not Frank today. We'll have Paul Kianaga, and he'll be here to answer some of the questions. We're going to do a little bit of a recap on what we've seen these past 7 days. Crazy to think it's only been 7 days.
It's only been 7 days, but we're in week 2 now, and I know they expected this to go on for 4 weeks. We'll see if that holds true. I'm curious to see at this point, as we inch closer to that midway point, if you will, you know, if you had a crystal ball, what could be the outcome of this so far? What are jury members thinking at this point? I mean, today I feel that they had to sit through a lot of X's and O's of, you know, homicide detectives and their jobs, and these emails that were shared throughout the investigation, but really trying to get to the bottom of this catfish theory. There were 2 theories being, you know, tossed around, and if you didn't get behind the catfish theory, then they were subject to possibly being reassigned, is what
that's the accusation from John Carroll. Yeah. So. And you know, I think it's important to mention that nobody has testified that they knew the exact reason of why anyone was transferred, but it does look like court is about to get underway, so we are going to take you in the courtroom shortly and be back during the lunch break with some...
It looks like the judge has just taken a seat, so let's take you live back inside the Fairfax County Courthouse for the Brendan Banfield murder trial, day 7.
All right, your next witness?
Matt Nielsen.
Matt Nielsen.
Stand here, please stand and put, raise your right hand. Do you swear or affirm to testify truthfully in this case under penalty of law?
I do.
Thank you.
Good morning, sir.
Good morning, sir.
Can you please tell the ladies and gentlemen of the jury your name and spell your name for the court reporter?
Matthew Nielsen, Nilssen.
And where are you currently employed?
I'm currently employed with the Fairfax County Police Department as a detective sergeant with the Major Crimes Bureau.
Okay. Were you previously in the homicide division?
Yes, I was.
When was that?
I was employed as a homicide detective prior to my promotion to sergeant from approximately February 2023 until what would have been November of 2024.
Okay, so I'm sorry, you were the homicide sergeant at that time?
I was a detective on the squad.
Okay. And then you transferred to where you are now, which is in the homicide division?
I work for the Major Crimes Bureau. I am not the supervisor of the homicide unit.
Okay.
I work for
what areas are you working in?
I supervise the sex crime squad.
Okay, gotcha. Now, calling your attention to February 24th, 2023, were you involved actively with the homicide that occurred at the Banfield house?
Yes, I was.
Okay, and what role did you play in that?
I assisted beginning on that day with the investigation by handling investigative tasks such as writing search warrants, and then throughout the remainder of the investigation with tasks that were assigned to me by my supervisor and other detectives handling the investigation as primary.
Okay, and based upon the time frame that you said you were there, you were still there in October of 23 when Juliana Peres Magalhães was charged, correct?
Yes, sir.
Okay, and were you involved in that?
Yes, I was.
Okay, was there any sort of planning that went with that?
Yes.
Okay, what was the ultimate goal of charging her with murder?
I would state there were several goals that included the fact that evidence supported probable cause to charge her with murder at that time. But based on our investigation, there was belief that there was more to the story that could be elicited from her. And the effect of charging her with a crime was effectively a way to introduce a change in circumstances between her and Brendan Banfield that could lead to the elicitation of more information about what happened.
Okay, so charging her, keeping her in jail, the pressure that would be caused, was that part of the plan?
Yes, in terms of in any type of incident in which you have multiple people involved in the carrying out of that act, there is competing interest between self-interest and cooperation. And by introducing circumstances that would encourage cooperation with law enforcement over cooperation with other parties, it could change the outcome of the investigation, change the amount of information available to us as investigators.
Okay, like a plea agreement to a lesser charge and no further jail time, something like that?
There's a number of different ways that could be accomplished, or the ultimate goal could be accomplished.
And that's ultimately what happened, though. That's what caused the change in Juliana Peres Magalhães.
My understanding is she did at one point cooperate with detectives. I was not involved at that point in the investigation.
Now, while you were on the homicide squad, were you ever assigned to listening to the jail phone calls?
No, I was not.
Okay. Was that something that was employed in order to determine whether or not she was subject to the pressure that had been intended?
I know that someone was assigned to review those calls, and the information learned from those calls was part of our investigation.
Okay. Thank you, sir. I don't have any further questions.
Cross-examination? No, ma'am. All right, is this witness subject to recall?
No.
All right, you're free to go, sir.
Thank you, Your Honor.
Your next witness?
Your Honor, Patrick Bruce.
Patrick Bruce.
Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
Good morning, Mr. Bruce.
Good morning.
Can you please state your name and spell it for the court reporter?
John Patrick Bruce, B-R-U-S-C-H.
And you previously were with the Fairfax County Police Department?
That's correct.
Okay. And in what capacity was your final position?
I was the deputy chief
Okay.
of the Administrative Support Bureau, I'm sorry.
Yes. At some point prior to going to the administrator, were you transferred from another department to go to the Administrative Support Bureau?
Just for clarification, are you asking my previous assignment before
Yes.
that?
Yes.
Yes, sir, I was the deputy chief of the Major Crimes Bureau.
Okay. And you were transferred from there?
Yes, sir.
Okay. And was that of your own volition?
Yes, sir.
Okay. You wanted that transfer to the Administrative Support Bureau?
Yes, sir.
Okay. Now, during your time as deputy chief of the Major Crimes Division, you were overseeing or supervising the homicide squad at that time, correct?
It was one of several squads under the Major Crimes Bureau.
Okay, I'm just asking about the homicide squad. You were supervising the homicide squad.
Could I have permission to clarify?
Yeah, sure.
So I was the head of the entire Major Crimes Bureau, which encompassed the Domestic Violence Unit, the Sex Crime Squad, Child Abuse Squad, Robbery, Cold Case, as well as Homicide.
Okay. And were you involved, or were you in that position at the time of February 24, 2023?
So at that time, I was the captain of the Major Crimes Violent Crimes Division, so not a deputy chief.
And when did you become deputy chief?
I became a deputy chief in January of 2024.
Okay. And did you have contact or involvement in the case that we're here for today?
Yes, sir.
Okay. And how would you describe your role in that case among all the other ones that you were handling?
Overall, my responsibilities are similar for all the cases in the Major Crimes Bureau, to include this one. So it's oversight, it's providing advice as needed, support, guidance, and then also raising concerns in the investigative process if those arise.
Okay. Were there concerns in the investigative process by you in this case?
I think that's fair to say, yes.
Okay. And did it relate to digital forensics?
Yes, sir.
Okay. And just to get to it, were you involved in the transfer of Detective Miller from digital forensics to child sex?
Yes, sir.
Okay. In fact, you at one point spoke to...
Objection leading.
All right, I'll sustain as to lead.
What, if anything, did you say to Deputy Chief Freed about Brendan Miller to have him transferred?
I had indicated that as far as I was concerned, Detective Miller was not to work another digital forensic case that pertained to the Major Crimes Bureau.
And were you aware of his history prior to you making that, I guess, happen?
Could you please clarify?
His work history there in digital forensics?
Was I aware that he was a detective within the division, the bureau? I guess I'm looking for...
Well, I'm assuming you were aware of him being a detective in the bureau. Were you aware of his background in digital forensics?
I guess I would have to say no at that point.
Okay. Was that anything you took into account with regard to Detective Miller?
No, sir.
And so is it fair to say, or what if anything, or what if any case was the reason that you asked for him to be transferred?
It would be this case that we're here for.
Okay. And what item of this case was it that caused you such concern?
Could I actually go back for 1 second? I didn't say that he needed to be transferred. I indicated that he wouldn't work a case for the Major Crimes Bureau.
Okay.
That was Deputy Chief Freed's decision whether or not he ultimately would be transferred.
Okay, so you as the head of you're the deputy chief of the homicide or the major crimes bureau. By saying that, you essentially caused the transfer.
Judge, I'm going to object to his characterization of the evidence. Objection is to form. The witnesses testified that at this point in time, he was the captain of major crimes when the decision was made, not the deputy chief.
All right.
Is that correct?
I was the deputy chief of major crimes when I made that
All right.
statement.
Okay, and when you're the deputy chief, you make that kind of statement, especially with major crimes, that gets things moving, correct?
I certainly acknowledge that had influence on his transfer.
Okay, and his transfer was classified as performance management? Do you know that term?
I didn't know that that's what his transfer was classified as.
Okay, have you ever heard that term?
We have a performance management document.
Okay, but not a doctrine that allows transfer without documenting discipline?
I couldn't comment on that.
Was there discipline associated with this decision?
Not that I'm aware of.
Were you disciplining him by moving him out of your area?
Absolutely not. I actually retained him in the child exploitation unit.
Okay, so where he is right now?
Yes, sir.
Now, calling your attention to immediately after the killing of Christine Banfield, were you in meetings at that time when you were a captain?
Yes, sir.
Okay, and were you involved with any theories relating to the case after the killing?
I'm sure at some point.
Okay. Do you know what catfishing is?
Yes, sir.
Okay. Was that something that you were pushing with your homicide detectives at any point?
I wouldn't characterize that as pushing.
Okay. Would you tell them that this is the theory? Is that not pushing?
So I had a specific meeting with then Lieutenant Harrington. I believe it was in November of 2023. I was asked by the two commanders, Lieutenant Matthew Lewick as well as Lieutenant Aaron Weeks, to meet with Lieutenant Harrington. During that time, I actually proposed 3 separate theories to Lieutenant Harrington. And we discussed those theories at that time. So there was not only one theory I was pushing, or presenting, I should say. Ultimately, I was looking for an objective and comprehensive analysis of all the facts and evidence in this case.
And when the catfish theory came up, had there been a collection of all of the evidence, all the digital forensics, fingerprints, DNA, all those things?
Just like with any investigation, it was fluid.
Okay. Had that theory of catfishing come out before any of that was finalized?
I'm sorry, could you go back to the things you had listed?
DNA, digital forensics, and fingerprints.
The digital forensics, for the most part, had been back at that point.
What time frame was that?
That would probably be the spring of 2023.
Okay, so
to fall of 2023.
So my question is, within weeks of the killing of Christine Banfield, did you suggest the catfish theory in a meeting of the homicide detectives?
I don't recall ever being in a meeting with homicide detectives. I do recall talking to my command team about that possibility.
And who was your command team?
Lieutenant Weeks as well as Lieutenant Lewick.
Okay, and where was Lieutenant Giaio there at that point?
He was not.
Okay, but you brought him in, correct?
That's correct.
Okay, and that was March of 2024?
That's correct.
And it was at that point that you had decided that catfish theory was?
Objection,
viable?
leading.
All right, I'll sustain as the leading.
What, if anything, had you concluded about the catfish theory at the time that Lieutenant Giaio was brought in?
I hadn't made any conclusions at that point. Did I have a strong working theory that this was a catfish? Absolutely.
Okay, and was that something that you told Lieutenant, I guess, Giaio when he came on with you?
I don't ever recall explicitly having that conversation. I think he probably came to that conclusion on his own.
Okay, but the two of you were pretty close in terms of the investigative issues, correct?
Yes, we were.
You were both in narcotics together at one point?
Yes, we were.
And you brought him in to major crimes, correct?
I did. That was a collective decision amongst my command team.
Okay. And so is it not true that you insisted you had to have Giaio come in March of 2024?
That is not true.
Okay. Were you aware that he was on the Brady list?
Yes, sir.
Okay. What's the Brady list for the ladies and gentlemen of the jury?
It's basically an indication of a time or a potential in where you weren't totally potentially forthcoming.
So truthfulness?
It could be.
But that's essentially the basis of the discipline in the police department, truthfulness, correct?
I think that could vary as well.
Okay.
Ethics, not necessarily truthfulness, so it varies.
But at the time you hired him into that division, he was on the Brady list, correct?
I did not hire him.
Okay, at the time that you asked him to come in and be a lieutenant in your section.
So could I have an opportunity to explain the transfer process?
Judge, I think at this point in time, I would object. I'm not sure the relevance of a non-testifying witnesses being on the Brady list.
Oh, I think we've already established that if you want to move on from that.
Yes.
Okay.
At the time that he was hired, he was on the Brady list, correct?
When he was hired by the police department?
No, by you as a lieutenant within major crimes.
Again, I'd have to explain the transfer process and the selection process.
March 24, was he on the Brady's list?
Yes.
Okay. And this is 2024, March of 2024.
Correct.
And has he been put on the Brady list again during this time?
Objection as to relevance.
What's the relevance as to this time?
Judge, it goes to truthfulness, which will ultimately come in to the decisions to have him involved, the decisions why.
But at this time, I'll sustain as to at this time.
Okay. Now, sir, you indicated that you you decided that Detective Miller was not going to be, I think as you said, involved in any other major crimes while you were there.
Any of the digital forensics for the major crimes cases, correct.
Okay. And then he was transferred.
Within weeks, I would say, yes, sir.
Okay. And what was your basis for that?
So there were a few factors. Would you like me to expand on this?
Were they related to this case?
Yes, sir.
Exclusively related to this case?
Yes, sir.
Okay. Was it related to his work product?
Yes, sir.
And are you talking about the executive summary work product?
That was part of it.
Okay. And so his conclusions were not agreeable to you?
I wouldn't word that way.
How would you word it?
I would word it that his analysis was incorrect.
Okay. And at that time when you determined his analysis wasn't correct, had you had any training in digital forensics?
I have my master's in computer forensics.
Okay, so did you look at some of the items of evidence in order to arrive at that informed decision?
So he had provided me a zip file of a Cellbrite, but that wasn't able to be downloaded.
Okay, so you didn't really review anything in order coming to that conclusion?
Well, I can get into the specifics if you'd like me to.
Well, I'm asking some questions right now, and perhaps we'll get there.
Okay.
You didn't actually check the source of his findings. With
Objection leading.
What, if anything, did you do to check the source of his findings, the digital forensics?
I didn't conduct my own digital forensic analysis, if that's what you're asking.
Okay, and I think you said you couldn't get into the portable case when you were given to
The zip file of the Cellbrite, correct.
Okay. And so what would be the reason that you would differ from your expert's opinion?
Because of some of the unsubstantiated deductions that he made.
Okay, so it's based upon his decisions relating to his digital forensics expertise.
So the deductions in the wrongful analysis.
Okay, so the decisions.
I wouldn't use that word. I'd say deductions and wrongful analysis.
Okay, and the wrongful analysis relating to the actual digital forensics that were downloaded?
Some of them, yes.
Okay, and did you ever go over those with him in detail?
I would ask clarifying questions.
Did you tell him exactly what it was that you disagreed with in terms of his deductions and his analysis?
I think a couple of them, yes.
Okay, how many were there in total?
Off the top of my head, I could probably list at least 4.
Okay, and so it was based on that, based on your reading of his executive summary, that you decided that it had gotten to the point where he's no longer doing any more major crimes under your tutelage.
Digital forensics for major crimes cases. I retained him as a detective within the Major Crimes Bureau Child Exploitation Unit.
I understand that. The digital forensics section.
He was not going to do digital forensic analysis for any other major crimes case.
Okay. And sorry, bear with me for a second. Were you aware that his work was peer-reviewed outside of the police department?
I was.
And were you surprised to see that they concurred in his findings?
I have a question to clarify. Did they concur on his extraction or his analysis?
Both.
That's news to me.
Okay, so that peer review held no weight for you because you had already decided that the analysis was wrong.
Objection leading.
All right, sustained as to leading. You want to rephrase?
Why was it that the peer review did not hold any weight for you?
Because ultimately the analysis was incorrect.
Okay. Now, in terms of the Cellbrite messages that you say you reviewed, what was it that was the problem with those?
The Cellbrite messages that he had provided?
Yes.
I wasn't able to open the zip file.
Okay, so we don't know anything about the Cellbrite messages as to your decisions on his analysis. Were you privy to a printout of his communications on FetLife?
Yes.
Okay. Were you privy to the communications from Telegram?
Yes.
And do you understand how those were obtained?
Through the digital forensics.
Do you know how that's done?
It's essentially tied to software that then downloads both from a cell phone and or laptop or any digital device.
And did you review that data?
I didn't review all the data, no.
What data did you review?
I reviewed the correspondence.
I'm sorry, the what?
The correspondence on Telegraph, the correspondence on
Okay.
FetLife. There's a significant amount of data when they download these items.
Okay. Now, are you still working as a police officer?
I am not.
Okay. On July 10th, when we were here before the court, you had just moved to the Administrative Support Bureau, correct?
I moved there in February of 2025.
Okay, so, but that's when we found out you had moved, or I found out that you moved to the Administrative Support
Objection,
Bureau.
counsel's testifying.
Overruled. Go ahead.
Correct?
I can't testify to when you found out I was moved.
Okay, on the 10th, we talked about this, correct?
Yes.
And how you had enjoyed this position, and you were really looking forward to, you know, the things that happen in an administrative support bureau, and the challenge of not having, that's being in more of an administrative role than being in major crimes.
I would agree that it was a completely different assignment than I'd had throughout my entire career.
And that's something that you sought, correct?
Correct.
Isn't that what you said?
Yes, sir.
And it's something that you're really excited about, correct?
I don't know if I'd say really excited, just,
Well, when you were here on the 10th, you said that you were very interested and excited about your new challenge.
sure.
Okay. And when did you retire?
July 25th, 2025.
When did you put in your retirement paperwork?
July 11th, 2025.
So the Friday after the Thursday that we were in court here?
Correct.
Okay. So what happened, if anything, about the excitement with the Administrative Support Bureau?
Judge, I would object and ask to approach.
Sir, why did you retire one day or put in your retirement paperwork one day after the hearing that we had here on July 10th?
For personal and professional reasons.
Okay. And you're no longer a police officer?
I am not.
Sir, I'm going to change back here for a little while. Your Honor, I think we have ID'd 91, so 92 would be the next.
All right, yes, sir.
Sir, if you can look on the screen in front of you, are you able to see this communication?
Yes.
Okay, and who is that communication between?
Director Fayez.
Okay, and Director Fayez, who is that?
She's the Director of Victim Services.
Okay, and was she someone that was within your command structure?
Yes, sir.
Okay, exactly where does that fall in the Major Crimes Bureau command structure?
She's part of the command team.
Okay, so would she be involved with command staff meetings?
Yes, sir.
Is she supposed to be there?
Yes, sir.
Okay, so here we have, it looks like a,
Counsel, if you could go back to the microphone, the jury won't be able to hear you.
sorry. Can you hear me?
Yes, I can.
Okay. Looking at the exhibit that's going to be identified as Exhibit 92, do you recognize that?
Yes, sir.
Okay. And there's reference to a jail call. Is that you or is that someone else?
They're responding where it says my name.
Okay. And so who else was on this thread?
I believe it would have to be, based on the response of one last favor, GI, would be Lieutenant Giaio.
Okay, and so it was the three of you, and you agree that's a communication that you had with all three?
Yes, sir.
Okay, Your Honor, I move that as Commonwealth's Defense Exhibit 92.
Any objection?
Judge, it contains hearsay statements. Two of those individuals have not been called to testify.
I'll identify
ID
it,
it?
Judge,
Okay.
and we'll get to it later, and
All
that's
right, ID is 92.
92. Sir, do you see that on the screen?
Yes, sir.
Okay. And it looks to be three people.
That's correct.
Okay, and who are those three people?
Based on the text message, it would be Chief Kevin Davis, myself, Director Fayez, and Lieutenant Giaio.
And the date of Friday, October 25th, 7:32.
Correct.
Does that have significance for you?
I believe that's the date that Juliana proffered.
Your Honor, can I identify this as Defense Exhibit number 93?
93 identified as 93.
And I'd move that into evidence?
Objection contains hearsay.
All right, I'll sustain as hearsay at this moment.
I'll just identify it,
Okay.
Your Honor. and-
Identified as 93.
Sir, do you see what will be identified as Defense Exhibit number 94?
I do.
Okay, and is that a message group that you were involved with?
Could you just give me a second to read this, please?
Absolutely.
Yes, sir, it is.
And this message that you sent is on October 25th, 2024, correct?
Correct.
And the same significance as the previous message?
Are you saying this day of the proffer?
Yes.
Yes, sir.
Okay. Your Honor, have I identified this one yet?
You identified it as 94.
94. I'd move that into evidence, Your Honor.
Same objection.
Objection,
All
hearsay.
right, I'll sustain the objection at this point. But
Okay,
it is
I'll-
ID'd as 94.
ID is 94. Thank you. Sir, can you see that message?
I can.
And I'd identify this as Defense Exhibit 95. There are a number of people involved in this message, correct?
It appears that way, yes, sir.
And the names there, does that match up with your memory?
Could I review this as well?
Of course, of course.
I've reviewed it. I don't recall this correspondence, but my name is certainly on it.
Do you have any idea who is writing in the blue boxes,
I can't tell.
even by the discussion?
Well, my issue with being able to tell is that the banner, it's very small initials.
Okay. Your Honor, I think I've identified this as 95?
That's correct.
Okay. I'll ID this and
Okay.
come back to it.
Yes, sir.
Sir, I'm going to have you look at this. It'll be identified as Defense Exhibit 96. Take some time to read it.
I can see my first name up at the top. I don't recall this correspondence.
Okay, and is that with Lieutenant Giaio?
I couldn't say. I see my first name up at the top.
Okay. Your Honor, I'd move to admit that as Exhibit 96.
Judge, two objections, hearsay, and it has not been recognized by the witness as having been his
All right,
statement.
I'll sustain the objection. It's just ID as 96 at this point.
Sir, please look at this message. This is going to be identified as Defense Exhibit 97.
Again, I see my name at the top. I just couldn't verify if that's me as Patrick and or who this correspondence is with.
Okay. Let's talk about that. PB, Patrick, that doesn't show up on your text messages?
Well, it appears that this is with somebody else, so it's what appears on their text messages.
Okay, so do you have any idea, based on the content of it, who that person would be?
Are you asking me to take a guess?
No, I want you to conclude who that person is. Can you do that?
I can't definitively say who that's with.
Okay. Your Honor, I would move that in as Commonwealth's Exhibit, or Defense Exhibit 97.
Same objection.
All right, I'll sustain the objection, but ID is 97.
97, Your Honor, is that right?
That was 97.
Okay, thank you. Sir, I'm going to ask you to identify what will be marked as Defense Exhibit number 98. Please read it.
Again, that's my name at the top, or my first name at the top, with the initials PB. I don't recall this correspondence.
Your Honor, I'd move into evidence Exhibit 97.
98.
98, same
sorry.
objection, Judge.
All right, I'll sustain the objection. ID is 98.
Sir, can you look at the screen in front of you and tell me if you recognize this message? Your Honor, I'd identify this as Defense Exhibit 99.
All right.
Again, I see that my first name at the top, the initials. I just don't recall this correspondence.
Your Honor, I'd move in Defense Exhibit 98.
99.
99, objection, Your Honor.
99, sorry.
Sustained, and just ID'd as 99.
Sir, can you see the picture in front of you?
Yes.
And do you have any recollection, based upon your review of the content of these messages, as to whether or not that's yours?
This I do recall, yes, sir.
Okay. And were you the one who wrote about Klingon and Kelsey and not holding off on bringing Klingon and Kelsey?
Objection is to counsel's reading the document into evidence, but it's not being admitted.
All right,
Just trying to identify which message.
all right. Well, you can have, just point to it and
Which,
state objection.
I'm pointing to that one right there. Is that you, or is that the person you're talking to?
Based on how this is presented, that would be me.
Okay. And in that message, you're talking about Eric Klingon, the prosecutor, correct?
Yes.
And Kelsey Gill, the prosecutor?
Yes.
Okay. And whomever you're speaking to, you're saying, hold off on...
Objection. It has not been admitted into evidence. Counsel cannot read what is written.
I'll sustain that objection.
Okay, Your Honor. I'd move this into evidence as Exhibit 100.
And again, Judge, Commonwealth would object. It contains hearsay.
All right, I'll sustain the objection, but ID'd is 100.
Okay. Sir, this is going to be identified as Defense Exhibit 101. Do you recognize that message?
I don't recall this specific message.
Okay. Is that, do you know if that is your communication, even if you don't remember the content?
I don't recall.
Your Honor, I'll hold this as identification
101.
before moving in.
Okay.
101. Sir, do you recall this conversation?
Yes, sir.
Okay. And do you know who you were communicating with?
Lieutenant Giaio.
And which color of the bubbles are you communicating on?
Gray.
And this is Friday, October 25th. Well, tell me the date. What does it say?
It says Friday, October 25th.
Okay, and what's the significance of that?
That's the date of Juliana's proffer.
Okay. Your Honor, I'll hold off and
All right.
move that.
That's
This
fine.
is 102.
ID'd is 102.
Sue, sir, do you recall this message that's before you?
Yes, sir.
And was that a message that you participated in?
Yes, sir.
Okay, and are you in the gray?
Yes, sir.
Okay. Your Honor, this would be identified as Defense Exhibit 103.
All right. 103, identified.
Now, sir, in your communication, you reference someone else in the fourth grade communication down. Who is that person?
That's Director Fayez.
And Director Sally Fayez?
Correct.
Okay. Your Honor, it's identified
It's
as
identified as 103.
103.
Yep. You got it.
Sir, can you see the message before you?
I do.
is that a message that you were participating in?
Yes, sir, I'm again in the gray.
Okay, and the second box, those are your words?
Yes, sir.
And these are your words?
Yes, sir.
And do you know who you were speaking with?
Lieutenant Giaio.
Okay. Your Honor, I identify that as 104, and
Yes.
we'll move in for...
All right, identified as 104.
Sir, this is Defense Exhibit 105. Do you recognize that?
Yes, sir.
And are those your words?
Yes, sir.
And who are you speaking with?
Lieutenant Giaio.
Your Honor, I'd identify and move to be admitted at a later time.
Okay, just right now it's identified as 105.
Sir, I'm going to identify this as Defense Exhibit 106. Do you recognize that communication?
I do not.
Are you not a participant in this?
I don't know if I am. I can't tell.
Okay. Your Honor, identified as 106.
Identified as 106.
Sir, I'm going to ask you to identify what will be marked as Defense Exhibit 107. Are you involved in that message?
I don't believe I am because I'm referenced in the third person. So if you see the second gray box down, wasn't for your leadership and Bruce believing in you. I don't refer to myself in the third person.
Okay, but you don't remember it if, in fact, you were included in this?
I don't recall.
Okay. Your Honor, I move that, I would identify it as
Identified as 107.
107. Sir, those messages appear to be quite frequent and with the same group of people. Is that correct?
I guess.
I mean, would that be your, a group that you rely on for discussion about the case?
Certainly people I was in text communications with.
Okay. And the text communications that we know from what we just saw were what you told us, Lieutenant Giaio and Sally Fayez, Director of Victim Services, correct?
Well, there was definitely other ones where you had group people on there as well.
Right, but we didn't identify them.
I think there was one line that said Dan Spital on there as well.
Okay, was he part of your command staff?
Yes, he was.
Okay, and were there anybody else that you saw on there?
I believe Tom Harrington was on one of those threads.
Was he part of your command staff?
Yes, sir.
Okay, and anybody else that you saw there?
I don't recall. I'd have to go through those again.
Okay. You're on court's indulgence.
All right, yes, sir.
Sir, in terms of your command structure, who is below you
As in, how would it
within
appear?
homicide? Yes.
My command structure would have been myself to Major Spatal. Then underneath him would have been Captain Harrington, Captain Bobel. Let me clarify, I assume you're talking in this 2024 timeframe.
Yes.
Yes. And then the direct report to Major Spatal, I think by the way the diagram was, or as I best can recall, would have been Director Fayez.
And so Director Fayez had a direct report, Major Spatal had a direct report.
Yes, I was his direct report.
And is that something that's put into the structure that was set up?
Could you clarify what you're asking?
Well, are you the one who's asking for the direct reports, or is it just by based upon their position that they're?
It's based upon their position.
Okay. Was Lieutenant Giaio ever a direct report?
He would have then been underneath, at the way it was structured, Captain Bobel.
Okay. Was there ever any concern by the people in your command staff regarding Lieutenant Giaio directly reporting to you?
Yes, sir.
Okay. Was that an issue that you had to deal with?
It wasn't an issue for me.
Okay. Well, in a command structure such as yours, who would Lieutenant Giaio have to go to if he wasn't a direct report?
I think I'd like to be careful about the word have to. It's a command structure, so there is a hierarchy, and I would be at the top of that hierarchy.
Okay, and would you be the person who would give him permission to bypass the others to get to you?
I could.
Okay, in this case, specifically this case, did you tell him to come directly to you and bypass the others?
I did not tell him to bypass the others, but it was known that he would be reporting directly to me.
Okay, so you gave him that assignment, and then he just took it from there without talking to the others?
I actually spoke to the others. They were part of my command team.
Okay, so you then disseminated whatever he said to you directly?
Yes.
Okay. Now, when you came into your position as deputy chief, were you told to clean up the homicide division?
No, sir.
Did you in turn tell anybody to clean up the homicide division?
No, sir.
Were you aware of anybody saying that they were here to clean up the homicide division?
Objection as to relevance.
Overruled, if you can answer. That's fine.
No, sir.
Judge, I don't have any further questions.
All right, first examination.
Good afternoon. So are we to understand that your involvement in the Banfield investigation was as a supervisor only?
As a commander, yes, ma'am.
Okay. And you did not collect any evidence in this case?
That's correct. I did not collect any evidence in this case.
Did you direct that any evidence be ignored?
No, ma'am.
You spoke about Brendan Miller and your concerns about his work. You specifically made the statement that he had unsubstantiated deductions. Is that correct?
That's correct.
Was one of those unsubstantiated deductions recorded in his executive summary that Christine Banfield was the operator of her devices when interacting with the FetLife account?
That's correct.
Okay. And was it that type of unsubstantiated deduction that caused you concern?
Exactly.
Okay. Did you do anything to change his report?
Never.
And did you do anything to change the evidence that he had collected that he believed substantiated his report?
Never.
Okay. Judge, I don't have any further questions of this witness.
Redirect? I'm sorry, could you?
I had one other exhibit that I neglected to introduce
All right,
in
do you have
my
any objection
direct.
to him? Just, he has one more
No,
text
asking
message.
questions, certainly not.
That's fine. Okay, go ahead. It would be 108, Mr. Carroll.
108, yes. Let me just, I'll do my cross and
Okay.
then, or my rebuttal.
Redirect.
Mr. Bruce, the word unsubstantiated can be a difference of opinion in digital forensics, right? Correct?
I guess it would depend on how it applies.
And your statement that it's unsubstantiated was in conflict with your digital forensics expert statement that she was in control of her devices on the FetLife communications, correct?
I don't know that I agree with part of that statement.
Okay, which part?
So there was a conclusion that Christine Banfield was always in the possession of her devices. The crime scene definitively
Relating
demonstrates
to
that to be
FetLife, which is what she
incorrect.
asked. The question was relating to FetLife. Do you?
So could you repeat the question?
So you want me to go all the way back to the difference between unsubstantiated and what?
No, the part where you're bridging of unsubstantiated with the FetLife.
Yeah, that was the question that you were asked by Ms. Sands. And so what I'm asking is, you've indicated that it was unsubstantiated, I'm assuming as to the question as to the FetLife communications, correct?
That's what Ms. Sands asked me, correct?
Yes. And so I think your answer was you were talking about generally the statement in his executive summary that she had not relinquished any of her devices. Is that what you were talking about?
Well, those are two different things. I answered Ms. Sands' question, which would be that, yes, his deduction that Christine Banfield was communicating with Joe Ryan was not only actually unsubstantiated, it was wrong.
Well, so what did you look at to reach the conclusion that it was unsubstantiated? What digital forensics did you look at?
So going back to my education and being a master's in computer forensics, you never attribute a device and or a username to a person.
Okay, and is that what you're relying on to make that point?
With regards to Ms. Sands' question, yes.
So that's not supported by any review of the items that were extracted from the 60 different devices that he did?
Well, by happenstance, it is unsubstantiated. Unless Detective Miller was sitting next to Anastasia or Taco Supreme, he could never attribute whomever was talking on those devices.
And so what your position is that you're not going to believe that you can conclude someone's control of the devices unless you have a video or you have someone who was watching it?
It just would be forensically incorrect to make that conclusion.
But digital forensics makes that conclusion.
Objection, counsel's arguing.
I'll sustain that objection.
Okay. Sir, I'm going to show you what will be marked as Defense Exhibit 108. You recognize that?
Yes, I do.
And do you recall the date?
I believe that's going to be October 25th, is that correct?
Yes. It doesn't say, but if you recall it that way, that's what.
That's consistent with my communication with Lieutenant Giaio on the date of the proffer.
Okay. And is it your understanding that he was in a separate room outside of the proffer? And you were communicating with him?
I wasn't on site. I don't feel comfortable answering that question.
You don't know personally?
I don't.
Okay. But it was while it was going on, correct?
Correct.
Okay. And is this the communication with Lieutenant Giaio?
This was my communication, as I recall it, with Lieutenant Giaio.
Your Honor, Defense Exhibit 108, we'll ID it.
It's identified as 108.
Were you also involved in the transfer of Kyle Bryant, the lead detective?
Yes, sir.
And was that due to his performance?
Performance due to inexperience, as well as the phrase I would use, I believe he was in over his head as a homicide detective.
Okay, and so Miller, so from the group that was in place in October, Detective Brendan Miller was transferred.
He was transferred, I believe, in November.
Okay. But okay. And then Detective Bryant, who was the lead homicide detective in this case, was transferred.
He was transferred in January of 2025.
And that was as a result of your deciding he had to go?
I just didn't believe he was experienced for the homicide squad.
So you transferred him?
He was transferred to the sex crimes unit.
Okay. And in that same time frame, you were transferred, correct?
I was transferred in February of 2025.
And Lieutenant Giaio was transferred
Correct.
during the same time frame?
Right around that same time frame.
Okay. I don't have any further questions, Your Honor.
All right. Based on Exhibit 108, did you have any questions? Since that was a new,
No, but it was not offered into evidence yet.
no, it's just
so,
ID'd.
Yes.
Okay. Is this witness subject to recall?
Not by the Commonwealth.
No, are you free to go then?
Thank you.
All right, your next witness? Giaio.
Do you swear or affirm to testify truthfully in this case under penalty of law?
Good afternoon, sir.
How you
Can you
doing?
please state your name and spell your name for the court reporter?
Lieutenant David Giaio, Giaccio,
And where are you currently stationed?
the Sully District Station,
Okay. And where were you prior to the Sully District Station?
the homicide unit.
Okay. And you were lieutenant there?
Yes,
Was that under, at one point, Deputy Chief Bruce?
yes.
Okay. Or actually, during the entire time you were there was under?
During the entirety of the time I was there.
Because he transferred as well, correct?
I'm sorry?
Because he had transferred around the same time you did.
Yeah, I think about a month before I arrived, he was there.
Okay. I am going to ask you to identify what has been marked and introduced as Defense Exhibit 88.
It's just been marked, not introduced, but.
Oh, sorry. I thought 88 was.
Oh, 88 is, you're right, 88 is in evidence.
Do you recognize that?
It's an email.
Okay. And What's your role in this email?
Without context, it's hard to say. I think it has to do with an executive summary that I was having Detective Miller review.
Okay, so is that the executive summary right there? Was that the attachment?
I believe so.
Okay. Well, during that time frame, perhaps you can recall, during the time frame of November 8th, were you communicating with Sergeant Brian Ames then?
Yes, I was.
Okay, and you were communicating about the digital forensic executive summary?
That's correct.
Okay. Your Honor, I think that's in evidence.
That's in
Can
evidence.
we publish that? Is that already?
It's already been published.
Okay,
If it's in
thank you.
evidence, we publish it.
Sir, I'm going to have you look at what has been marked as and moved into evidence as number 89. Does that give you more context in identifying it?
Yes, I believe this was after the co-defendant in this case came in for a proffer. And those attachments or links, I guess would be the better term, at the bottom are links to the attachment or to the body-worn camera that was used to record that proffer. There were two parts.
Okay, and in this instance, you went to Brian Ames with the two proffers, correct?
That's correct.
And was there a phone call that went along this? Where did he get his direction from?
I don't recall. I think we talked, I don't remember if it was a phone call or an in-person conversation, but after the proffer, we had a conversation about some of the forensics reports and the need to revisit them.
Okay, and the need to change them, correct?
No, sir.
Okay. Was there an attempt to update, sorry, I'll leave that there so you can see it. Was there an attempt to update the digital forensics based on the proffers that you sent?
So we had a meeting, I think it was after these emails, there was a meeting set up with Sergeant Ames and the two Brendan Millers. Names are slightly different, but they work in the same unit to go over the basically all the digital forensics and to understand why they came to certain conclusions previously and understand how the evidence was correctly, how it would have been correctly analyzed.
Okay, and that was entirely based upon the proffer of Juliana Peres Magalhães?
I think it was partially based on it. I think there was some question about the analysis from the leadership, both me and above me, prior to that.
Are you talking about Deputy Chief Bruce?
Yeah, he would be one of the people, yes.
Okay, and so, well, I guess, so what you're saying is that you analyzed the digital forensics and you arrived at a different conclusion than your expert?
So I reviewed the data, and I think the data is what the data is. I think the context and how you analyze what it may mean is different.
Okay, and so you were looking at the more the conclusions?
I would say the logic used to arrive at certain conclusions.
Okay. And this is with Brendan Miller's report?
Correct.
The executive summary?
That's one of them, yeah.
Okay. And did you ever talk to Brendan Miller and have him show his work?
Yes.
How many times did you do that?
Several.
Okay. And when you were doing that, were you trying to get him to change?
Not the data, the analysis.
Okay.
And I wouldn't say change, I would say to understand what I was seeing.
Are you aware of this email?
What number is this?
This is actually, sorry, 90.
90,
And
so
it's
it is
been
evidence.
introduced, yes.
Okay. Thank you.
I'm not aware of this email, no.
Okay. I think it might have been the day before.
Well, yeah, some of it, obviously, the one I sent, I'm aware of. The one at the top, I assumed is what you were speaking about. I'm not aware of that one.
Okay. And is it accurate in terms of how he characterizes it?
Judge, the witness just indicated he's not aware of the document.
He's aware of the bottom part, I think is what he said. So if you want to direct your questions to that.
Well, I think I can ask him questions, Judge, about whether the body of it is accurate, whether it's being communicated properly.
What, if he recognizes it? He said he didn't recognize it, so I'll sustain that objection.
Okay. Do you recognize the content of what's being sent?
I'm not sure what you're asking.
The body of.
I mean, I can read it, if that's what you're, I can read it and understand it.
Does that sound like what you said to him?
Yeah, I think that's pretty accurate.
Okay. Sir, I'm going to ask you to identify what has been, or look at what has been identified as Defense Exhibit 90.
No,
Nope.
Oh, sorry, 91.
This is 91, which is
Yes,
not in
91,
evidence.
Sorry. So I'd be most interested in you looking at this area down here. Is that something that you created?
I wrote that email, yes.
Okay. And Your Honor, I move this in as Defense Exhibit 91.
Any objection?
I can have the court's indulgence for 1
Yes,
second.
ma'am.
No objection.
All right, 91 in evidence. Publish it, or it goes away.
Now, I'm going to go through a series of communications where it's multiple people. And so what I'm going to ask you is whether or not you recognize the communication and whether you're involved in the communication.
Okay.
Okay? So this would be exhibit number 92. Do you see that?
Yes.
And does that look like the communication that you were involved with?
Yes, I believe the blue bubbles are mine.
Okay. We still don't have the third person, so I'm just going to identify that, Judge.
That's still 92.
92. Sir, do you recognize that text message chain?
I do.
And are you involved in that?
That's my, in blue as well.
I'm sorry, in the blue?
The blue is my
Okay.
text, yes.
Thank you. Do you recognize that message? That would be Exhibit 93.
It's exhibit 94.
This is 94.
94. I apologize, Judge. 94.
Yes,
Okay, and that's a communication that you remember?
I do.
And it looks as though it's Patrick Bruch is one, and who's the other one?
Sally Fayez?
Okay, and Sally Fayez is, what's her position within?
She's the director of the Victim Services Department or unit.
Is she are you a direct report for her?
I'm not sure what you're...
Am I speaking in, is she or do you directly report to her?
No, I never have.
Okay, Who did you directly report to while you were in homicide?
Well, I had, I guess, Captain John Bobel, Major Dan Spital, and Deputy Chief Patrick Bruce.
Okay. Did you have any privilege to report directly to Patrick Bruce when he was the deputy chief?
For the purpose of this case, he was my primary report.
Okay, so it would just be the two of you communicating, much like these messages?
I mean, the other commanders were part of it, but he was the primary person that I reported to.
Sir, I'm going to ask you to identify if you are involved in this, if you are involved in this, which is a Defense Exhibit 96, 95.
95.
Yes, I believe that's my text in blue as well.
Okay. And do you remember this day?
I believe that was the day after the arrest of the defendant.
Okay. Thank you. Sir, do you recognize this has been identified as Defense Exhibit 96?
97? We're on 96. No, we're just on 95.
96, right?
Yes. Do you recognize that?
I do.
And that's just a direct message between you and Patrick Bruce?
That's correct.
Okay. And do you remember the context of it based on looking at it?
That was on the eve of the preliminary hearing for the co-defendant.
Your Honor, I'd move this in as Defense Exhibit 96.
Any objection?
No objection.
96 in evidence and can be published.
So you're in blue again, correct?
Yes, sir.
Okay, and Big Day, you're speaking of what you just said, which is the preliminary hearing?
Correct.
Okay, and you reference Klingon? Are you
Yes.
talking about Eric Klingon, the prosecutor?
Yes, sir.
Okay, he was the prosecutor on this case back then, correct?
Yes, he was.
And what just describe for the ladies and gentlemen of the jury, what's the communication about?
Your Honor, if counsel is asking the witness to read it, I would object. It has not yet been moved into evidence.
He asked him what it's about, so I'll overrule the objection.
You can go ahead and answer.
It's about being nervous for the preliminary hearing.
Okay, and that's between you and Deputy Chief Bruce?
Correct.
Okay, were you directly involved in the preliminary hearing that day?
No.
Okay. And was that the day of the hearing?
I believe it's the evening before, or, yeah, the evening before.
Okay. The preliminary hearing was on April 1st?
Yes, sir.
Okay. And were you involved in the preparation? Is that why you're privy to that?
Well, I was the supervisor. I'm sorry. Oh, closer. Sorry, it sounds loud to me. I'm sorry, can you repeat the questions?
Were you directly involved with the preparation for the preliminary hearing?
Yeah, I mean, I was the supervisor of the homicide unit.
Okay, but you didn't have any investigatory role in this?
No, in this case, I wasn't involved in any interviews. I didn't collect any evidence. I simply oversaw the investigation starting in, I think, early March 2024, so about 13 months after the murder.
Okay. Is it customary for lieutenants not to be involved in any of those things?
At the time, I was a sergeant, but yeah, I think that's fairly normal. The detectives do the investigating, the supervisor oversees it.
Would there be any other reasons why you couldn't prepare for the hearing?
No.
Were you on the Brady list at that time?
Objection is to relevance.
Overruled.
I'm not aware that anybody keeps a Brady list, but the Commonwealth has told me that they make certain disclosures about an investigation where I allowed an employee who had a brain tumor to stay home on light duty at the direction of a commander.
Okay. And so that was one instance when you were put on the Brady list. Have you been put on the Brady list on other occasions?
No.
Objection is to relevance.
Overruled, he answered no.
And the Brady list essentially, well, you tell me, what is the Brady list?
Well, like I said, I don't think there's a Brady list, but the Commonwealth makes disclosures based on opinions that they form about a case.
And the underlying finding is truthfulness, correct?
No.
Okay. Now, there's comment in here about catfishing. Was that a concern on March 30th, 2024, amongst you and Deputy Chief Bruce?
Was catfishing a concern?
There's a comment here. I'm just trying to get the context of that.
So based on the evidence, I think that after I reviewed it, it was about a month in, I believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now. That was set up by the defendant, yes.
Okay, and after doing 1 month's worth of work as a lieutenant, you were able to arrive at that conclusion?
I was a sergeant at the time, but yes.
Okay, and describe for the ladies and gentlemen of the jury, what were your digital forensics qualifications in order to arrive at that conclusion?
Well, I reviewed sort of the evidence that was provided to me by the digital forensics people. You know, for instance, the accounts were created in January. They had never, you know, they were brand new accounts. That was unusual to me. We reviewed Christine's history. I think it went back to the mid-2000s. She had never so much as visited a porn site that we could find, so I thought that was...
I guess my question was about the digital forensics.
Well, I think reviewing her digital footprint, there was no evidence of that. There were 2 occasions where the co-defendants were out of town for 48 to 36 hours, and none of the accounts, the CB 920 at Gmail wasn't used, the FetLife account wasn't used, the Telegram account wasn't used. It seemed unusual to me that that wouldn't happen while they were out of the house.
So if I can, let me just redirect you back to digital forensics.
Well, this is all part of the digital evidence, right? So,
not your opinion as to whether or not it's unusual if they're in or out of town.
Just want to you ask your next question.
Yes. In terms of catfishing, that was a theory that you were pushing, correct?
That I was
pushing.
It's what I believe the evidence overwhelmingly supported, yes.
And you then attempted to educate the homicide detectives about
Objection,
that,
leading.
All right, I'll stay this lead.
What, if anything, did you do with the homicide detectives in order to convince them of your theory?
We reviewed the evidence many times between March and September. However, it wasn't until the co-defendant came into proffer that everybody was in agreement that the catfish was the actual correct.
Okay, so once again, it was the co-defendant, not the digital forensics, that caused that conclusion, correct?
That's not my opinion, no.
Okay. Okay. I don't have any further questions on that. Sir, I'm going to have you look at what will be marked as 98, Defense Exhibit 97.
No.
It's 97.
97?
It's 97, correct.
You see that, sir?
Yes,
Okay. And in that, this is between you and Deputy Chief Bruce, is that right?
it is.
Okay. And there's some concern about losing the probable cause hearing, correct?
Yes.
Okay. So question for, Your Honor, I'd move that into evidence.
All right, any objection, 97?
Yes, Judge, our previous witness did not identify that as his information, so it stands as hearsay.
It's kind of a follow-on of 96, it just keeps going down, so I'll
I can-
rule the objection on
Thank you.
97 in evidence.
Is this communication with Patrick Bruce?
It is.
Okay. And in here, there's discussion about the prosecutor's plan, correct?
Yes.
And are you in the blue or the gray?
Blue.
Okay. And there's something about a fail-safe that's been put in place. What's that?
We had evidence that the co-defendant may have misrepresented things on her visa application, and I think Customs and Border Protection had planned to investigate that and potentially arrest her for it.
Okay, so if the preliminary hearing didn't go well, you wanted to get a hold of her immediately afterwards.
Correct.
So if the preliminary hearing hadn't gone well, just for the ladies and gentlemen of the jury, the case would have been dismissed,
Correct.
and then she would have been released.
Judge, counsel's testifying.
I'll state as the leading.
Sir, what would have happened if the preliminary hearing had been dismissed?
The co-defendant would be released.
And so the fail-safe was to have Customs and Border Patrol there to grab her?
Correct.
Okay, so come to the jail before she's released.
I think they were planning on getting arrest warrants. I'm not fully read into what their plan was.
And was this a plan between you and then Deputy Chief Bruce, or was this a plan amongst everyone involved?
It was the detectives on the task force that was created set it up.
Okay, and so who else would have known about the fail-safe?
Detective Bryant, Detective Goodell, and Detective Smith, I think, was still pretty well involved at that point.
Was Detective Bryant the chief detective at that time?
He was the lead detective, yes.
Okay, and Detective Goodell was another co-lead detective?
Correct.
And was Detective Smith a lead detective, or she?
Yeah, so essentially when I arrived, Detective Bryant had been the lead for the first year or so. I think at some point prior to my arrival, Detective Smith had been assigned to help him. And then once I got there, I assigned Detective Goodell. So there was 3 detectives plus myself that were reviewing all the evidence.
Okay. Okay, did you say in a prior statement that as a lieutenant you wouldn't review all the evidence?
No, I would absolutely review the evidence. I wouldn't take part directly in the investigation. I didn't interview witness, collect evidence, or have any real direct involvement, just in reviewing and advocating for investigative leads.
And Your Honor, I'm sorry, 97 was moved into evidence?
97 is in
Okay,
evidence.
and that's, the jury has, it's been published. Okay, thank you. Sir, can you see that communication?
Yes.
Is that the communication with Patrick Bruce?
Yes.
And this is from November 8th, correct?
Yes.
Okay, do you recognize this?
I do.
And you're in blue?
Correct.
You're going to move this in as Commonwealth's Exhibit number 98?
Judge, I'll renew the objection that former Deputy Chief Bruce could not identify this item.
On this one, he could not identify.
I think the witness just identified him.
All right.
Correct, but the witness indicates based on the document
I'm going to
itself.
sustain the objection since he testified that he did not recall it. So I'll sustain the objection.
Okay. Sir, in the blue box, you indicate that you did something. What is that?
I used the words markup. Or took a red pen. What I did was highlight in red on a document.
And did you actually take a pen?
No, it was the red. I changed the font to red rather than black.
Okay. And the document that you were referring to there, what document was that?
It was the executive summary prepared by Detective Miller.
Okay. Your Honor, may we approach on 98?
Sure.
Your Honor, if I may, I also had 106.
I had 106. I put that on his.
Okay, and 107. Yes.
Yes.
Thank you.
Sir, do you identify what's been marked as Defense Exhibit 100?
Yes, it's a text message.
And that's between you and Patrick Bruce?
It is.
Are you in the blue box or the gray box?
Blue.
Okay, Your Honor, I'd move that into evidence as
No objection.
Comments
100 in
Exhibit
evidence.
100.
And we'll publish.
So what, if anything, did you do when you were told to hold off on bringing Klingon and Kelsey into the loop?
I don't remember specifically, but I would imagine I held off on giving them a call.
Okay. And who, for the ladies and gentlemen of the jury, who's Klingon and who's Kelsey?
They were the prosecutors assigned at the time.
Okay. And do you recall when it was that you put them in the loop after this statement?
I'm sure within 24 hours. I don't recall
But you
exactly.
don't have any recollection?
No, I don't recall, but it was definitely not for any extended period of time.
Okay, and this looks like it was something that might jog your memory. It was relating to Celebrite Task Force. Do you have any recollection when it was that you would have told the prosecutors in this case, whatever the conclusion was?
Judge, I think that's a mischaracterization of the evidence.
If you want to rephrase your question.
Was the was the information that you're holding off on relating to the task force meeting at Cellbrite?
I believe it was the blood inside Juliana's shoes and on Brendan's pants.
Okay, and so how long did it take for you to communicate that to the prosecution team?
Like I said, I don't remember exactly, but it would be something that I would bring them up to speed on within a short period.
Okay, but you don't remember if you did?
I'm sorry?
But you don't remember if you did?
I certainly remember that they're aware of it. I just don't know exactly what that time frame was,
Okay.
but I would guess within 24 hours.
Thank you.
Mr. Carroll, would this be a good time to go ahead and take our
Okay.
lunch break?
Yes, thank you.
All right. Ladies and gentlemen, we'll go ahead and take our lunch break for an hour. Please do not discuss the case with anybody and don't do any outside research, okay? Thank you.
We're going to do SACA at 1:30. So I'm going to
The prosecution or the defense at this time, okay?
Yes, Your Honor.
All right. We'll be back. Let's go at 2:05, okay? 2:05. Thank you.
Court's recess until 2:05.
All right, you have been watching the Brendan Banfield murder trial here on WUSA 9+. We have been streaming that trial live for you. They began at 9:30 this morning. Here with me is Paul Kiyonaga. Thank you so much for being with me. He's an attorney here in the district, and he's going to be kind of weighing in, answering some questions for those of you at home. And those of you who do have questions, just a reminder, you can text us at 202-895-5599. We'd love to hear your questions, and he'll be able to hopefully give some perspective on some of the things that have been happening. And a lot has been happening today. We are on day 7 of this trial for Brendan Banfield. He's facing a number of charges. He's on trial for murder. Aggravated murder is one of the charges. He's facing 4 counts of aggravated murder, 1 count of using a firearm to commit a felony, 2 counts of child abuse with disregard for life, and 1 count of child cruelty. We've been hearing from a lot of witnesses the past few days. The defense has been taking their witnesses up to the stand since yesterday. Today, we heard from 6 witnesses so far. We expect to hear from more, but let's take you back to last week. We heard opening statements last Tuesday. I want to play you some of the highlights from opening statements last week. All right, so we're going to get you some of those highlights in a few moments if we're able to, and then get you some recap as well of some of the testimony that we heard. We heard from so many people last week. Paul, why don't we talk a little bit about what we really just saw in the last few moments? We were hearing from some of the detectives, some of the upper leaders of the Department for Fairfax County Police who were really involved with this case. We're talking about a case where 2 people were killed inside of a Fairfax County home. This was in February of 2023, February 24th. Juliana Peres Magalhães, she's arrested several months later in October of that year. So October of 2023 is when Juliana's arrested, charged with murder. It's not for another year, September of 2024, that Brendan Banfield, Christine Banfield's husband, is arrested and charged as well. And then a month later is when we see Juliana take that plea agreement. A lot of the conversation there today was about that timeline. Brendan being arrested in September, Juliana being arrested or taking the plea deal in October. Your initial thoughts when you're listening to this coming on?
Well, interestingly today, a lot of the focus is on the investigation that was done by the police. And it appears that what the defense attorney is trying to do is what most defense attorneys in this sort of situation would do, which is cast doubt on the integrity, thoroughness of the police investigation. So this morning, for example, we heard testimony from Leah Smith, who is a detective. And at one point she used the phrase that she felt she was being essentially pushed to adopt a certain narrative that her supervisors were pushing, that she had to get behind the narrative. This, for a defense attorney, is very important.
Right.
You know, we remember from the OJ days when they said that there was a rush to judgment. Well, in this case, there would be kind of a rush to a foregone or a theory that was favored, okay? So that is kind of the theory. And I remember hearing that Carol, the defense attorney, at one point had termed this case one of a theory in search of evidence.
Right.
All right. So the more that he can do to build up the idea that the investigation was not thorough, that the investigation was biased, and that it had a predetermined, pushed outcome, the more he's able to cast doubt on whether or not this prosecution case is viable, whether or not it meets that high standard of proof beyond a reasonable doubt.
Right.
So that appears to be what he's doing today. He's getting witnesses who are police officials or former police officials.
Right.
And he's asking them all sorts of questions about, well, did you feel pressured in trying to reach certain conclusions? Did you pressure people to reach certain conclusions? Did you try, in other words, to have the evidence that had been marshaled match the theory you wanted? All of which is being used to suggest that this is not the sort of solid investigation upon which a conviction can be built.
Yeah, just trying to poke those little holes in the case, just cause any sort of reasonable doubt. And you know, I've represented a lot of cases,
Correct.
had a lot of clients. Have you ever represented a case that was similar to this one?
Not similar. I mean, look, what case, this is so sordid on every level, regardless of whatever theory one wants to adopt. It is a tragic, awful circumstance involving the presence of a 4-year-old in the home.
Right.
So have I handled homicide cases? Yes. Have I handled cases involving sex abuse or sex assault? Yes. Have I handled one involving this sort of contorted catfish situation? No, this is not your typical case.
Yeah, it's very complex. Paul, I do want to, if we can, share with our viewers, again, the opening statements, some of the highlights from that. And I do want to preface by saying we saw these opening statements. They lasted less than 40 minutes, which was a surprise for me to see them move so quickly. So let's take a listen to that if we can.
It's the Commonwealth versus Brendan Banfield. Mr. Banfield is present in the courtroom with his attorney, and the Commonwealth is present.
We're here today because Brendan Banfield, the man seated behind me, killed his wife, Christine Banfield, and another man named Joseph Ryan.
The murder of Christine Banfield by Joe Ryan occurred on February 24th, 2023.
They sneak up the stairs to the bedroom where they hear Joe Ryan and Christine. Brendan enters the bedroom first, shooting Joe in the head, picks up the knife that Joe had brought, and stabs Christine repeatedly in the neck. He directs Juliana to shoot Joe a second time with her gun. Brenden spends the next several minutes manipulating Joe Ryan's body, in the process leaving Christine's blood on Joe's hands and pants.
The arrest of Juliana Peres Magalhães took place in October of 2023. And the whole reason she was arrested was to flip her against my client. You won't hear any dispute as to the relationship between Brendan Banfield and Juliana Peres Magalhães. But there's an awful lot more to look for, ladies and gentlemen.
The blood puts Brendan Banfield standing over Christine, stabbing her in the neck until she died. While Juliana presents us with the narrative, it is the blood evidence that you can rely upon without a doubt.
Digital forensics doesn't lie. People lie. And there are going to be plenty to see.
And since those opening statements, we've already seen the prosecution close their case. We've seen them present all of the evidence that they're mentioning there, a lot of that blood splatter evidence that they provided an analyst to come in and talk about the blood splatter. And, since John Carroll has taken over and he's been calling his witnesses, we've started to see some of what he talked about, that forensics.
Correct.
He talked about how the forensics don't lie, people don't lie, and we've really seen him kind of pushing that forward. Your reaction to just those opening statements?
I think the opening statements, it's not atypical for the government to present what the evidence will show in some degree of specificity. They want to tell the story. They want the jury to be on their side from the jump. It is also not unusual for the defense to be a little more guarded, a little more open, and a little more, let's see how things go. Because if you stake out something in a defense opening that you cannot support with the evidence that follows, then the jury is going to look at this and say, what have you been trying to sell us?
Right.
So I think it's not unusual that the defense opening was a little more, hey, there are a lot of questions here. There are a lot of things we need to look at. There are a lot of things that aren't going to make sense to you, jurors. So keep an open mind and let's see what those are. Because bear in mind again, that the job of the defense is not necessarily to present an alternate theory to the government's theory. It's not to educate the jury on what actually happened here necessarily. Their first job is to show that the government's theory in the end does not hold water and is not enough to lead to a conviction. So that's how it's positioned strategically, typically. And what we saw is that, the government is trying to present as much evidence as possible that this was a catfishing, that this was a deliberate attempt between Juliana and Brenden to manufacture this very scenario of a fetish rape fantasy that then led to the ability to create what happened, namely the death of two people. Because after all, according to the government, the whole reason why this was done was because Juliana and Brenden had an affair and wanted to get rid of Christine, and divorce was not evidently the option, because divorce would have potentially meant that Brenden could not have custody of the 4-year-old daughter. So it's a leap, I would say. I mean, that's an extreme idea that you're going to physically end someone's life for those reasons rather than other alternatives, but that is the theory.
Right.
And so that's where we go from there, is in trying on the defense side to poke holes in it.
All right, thank you for that perspective, Paul. Paul's going to be taking our questions here in a moment. The number to text, again, if we could put it up there on the screen, is 202-895-5599. So if you're watching this live with us, we would love to hear your questions. We do have some questions already lined up for you, Paul, but the more questions, the merrier. I know this is a very complicated, complex case, so we want to make sure we can clarify as many things and many questions you might have as well as we can. It does look like we do have Matthew Torres, who has been in the courtroom for us all morning long. He's been in there for all 6 of these witnesses. If we can bring Matthew in, would love to get his perspective on kind of the reaction as we're seeing these law enforcement officers being called to the stand. Matthew, what has been the reaction from the jurors? What's on their faces when you're looking at them?
They've been paying attention. There was one point, especially in the beginning there, when they were showing video that we were not able to hear, so we don't know exactly what was being shown. We know it was a bit of an interaction with an officer and Juliana Magalhães in the police cruiser there. They were watching the whole time. There was one point one juror kind of glanced away and then looked at us. So that was a lengthy video, almost 30 minutes long. Outside of that, though, it's been a lot of questions when it comes to these detectives. Keep in mind, these are detectives who we have not seen being called on by the Commonwealth. And so what was interesting as well was just before they let go of Captain Bruce, who was the one involved with the transfer of the forensic investigator, Brendan Miller, you saw Brendan Banfield really working with John Carroll. You could just tell how involved he is, at least with the follow-up questions to redirect and then ultimately is the reason why John Carroll asked Captain Bruce about the hierarchy, the structure of the command system, and who homicide detectives direct themselves to. And so as far as that, no specific major emotions really coming from the courtroom. I'm very intrigued to see what other exhibits will be shown by the defense. We're already seeing those text messages sent by Lieutenant Giaio to Captain Bruce, the ones who reportedly were pushing this catfish theory, according to the defense. And so whether that is sticking, we understand what they are arguing about, but the idea of as far as how much this came into play, the theory versus waiting for all of the evidence. And I thought what was interesting regarding the line of questioning from John Carroll from Giaio there at the very end, asking him whether or not he pushed for this catfish theory. He's saying that yes, he believed this is what was that was the case, and ultimately he also said that they pretty much waited until they got all the evidence and the proffer from Juliana Magalhães, which is that statement she made to police, before they came to the conclusion as far as charging Brendan Banfield in this case. And so, as well as the homicide detective from earlier, the back and forth there as far as whether or not she felt pressured to pursue the catfish theory. I think they're really trying to show that they collected all of the evidence before truly charging Brendan Banfield, but this is where the defense is really now poking holes in the prosecution's theory and case ultimately. So as far as reaction, Katie, I know this is what you asked earlier, really no big reaction, as we're really now going to text by text message the correspondence between the people with command staff and the Major Crimes Bureau.
Yeah, and Matthew, we've heard from a lot of the upper leaders of the Fairfax County Police Department. I know you and I have interacted with a lot of the officers who were up there on the stand. I know one of the questions Annie and I were having or discussing earlier is, do we think Chief Kevin Davis is going to be called to the stand? Obviously, we're hearing some of these names being mentioned. Director Fayez, Chief Davis. Have you seen him there? Do you think he's going to be one of the people called by the defense?
That's what I'm also wondering, because as soon as they mentioned one of the text messages being with Chief Kevin Davis, our ears perked because now we want to know what those text messages said, exactly how much influence potentially Chief Davis had when it comes to this investigation. You heard from one of the investigators there that typically when it comes to supervisors, they're not the ones actually investigating the cases. As far as Director Fayez, I have not seen her at all. I've certainly interviewed her in past stories as being the victim services director there. Her name was part of the subpoena list, so potentially she could be called on to testify. Just being out in the hallways though, I do notice two other investigators, so presumably they might be called on first before Director Fayez, and whether or not Chief Davis testifies, that is something that clearly we are also paying attention to.
Yeah, Matthew, you mentioned that body camera footage that was shared with the, everyone in there earlier that was played quietly. You couldn't hear the audio from that. We were not able to get kind of a clear idea of why the judge ruled that it would be played without audio. Did you seem to get an understanding of why that choice was made?
No, so interesting that you heard a little bit of audio. We did not hear anything at all, aside from the couple of questions that John Carroll asked this particular officer. We are not particularly sure. We're thinking because there might be the presence of Christine and Brendan's 4-year-old child at some point during that. But again, they wouldn't have shown the video anyway, so not being able to hear the audio, that was interesting, a good question. Certainly I'll try to ask actually, Jenna Sands or John Carroll when we see them entering the courtroom. I do also want to mention one of the text messages mentioned Eric Klingen, one of the Commonwealth attorneys there at the time, mentioning how his case may not be as strong, the concerns about the preliminary hearing. He was actually in the courtroom. He's been in the courtroom the whole time, except maybe the past 2 days, actually. But he was back in the courtroom today. So for us to kind of turn our heads to see his reaction, he didn't give much. He certainly was paying clear attention to what they were saying about him. But knowing that he was in the courtroom, especially that he was mentioned in these texts, were also interesting.
Yeah, and Matthew, I know you and I were discussing yesterday, he's no longer a part of this case, correct?
He is no longer a part of this case, correct? And the question is exactly when he left. That part is unclear. They did mention that July hearing last year. At that time, Klingon was still the prosecutor.
All right, thank you, Matthew, so much. We'll check back in with you, and please keep us posted if anything else develops. Obviously, we're going to be looking forward to more testimony, possibly more investigators. Does that surprise you, Paul?
No, I mean, I think this is all, even though I understand Matthew to be saying that there didn't seem to be a lot of overt drama in the courtroom. The fact is that some of the things that were said and some of the themes that are being developed are very important, even though they may not, on the surface, create fireworks. So the theme, for example, that John Carroll is trying to create, that there was we have this Miller report. And the Miller report, in its executive conclusion, says that there is no indication that Christine lost control of her devices during this January 2023 until the date of the murder. Now that's critical, because if she did not lose control of her devices, then there's no catfishing because she's got the devices. No one is pretending to be her. And so this is important for John Carroll to be able to show that this individual, Miller, who did this report, was then transferred or deemed to have performance management problems. And that's because they wanted, they being the police department, to support this catfish theory that they had developed. And what stood in the way of the catfish theory was this report. And that's why you had so much testimony today from the different investigative officers where Carroll is asking them, well, wait a minute, you disagreed with this report by Miller. What was your basis for disagreeing? You actually didn't do the forensic analysis yourself, did you? You're kind of reaching deductive conclusions, but you weren't the one who was the expert in digital forensics. You're not the one who was analyzing all the data from the phones, etc. So he's suggesting that there was this bias in the investigation toward a catfish theory and away from the executive summary that had been presented by Miller.
Yeah, and it's interesting you mentioned that, he was trying to poke those holes, but then we had the prosecution come back and say, but how do you corroborate that that phone was in her hand? How do you know unless you were sitting there next to her? So there's a lot here.
Look, I'm not a digital forensic expert, but if somebody says that I sent a message to somebody because it came from my phone, well, maybe somebody who knows my password, maybe somebody who wants to pretend they are me, gets on my cell phone and sends out a message. The fact that it comes from, and what does it mean to have control of a device? Does that mean you have 24/7 control of a device? I mean, I have control of my cell phone sitting here. And I have control of my cell phone generally, but do I have control of my cell phone when I'm cooking dinner and put it on the table? No. Do I have control of it at night when I'm asleep? No. So it's really not clear what is being meant when it says that Christine never lost control of her devices during this time.
Yeah, and I think, when I was reading that report, what stuck out to me is the reason he said that that was his finding is because around the same time as the activity was happening with FetLife, he said he also saw activity happening where Juliana was having a conversation with Christine through that device, that she was shopping online using that device. But, that brought up another question for me, because we have heard Juliana testify that they were doing most of this, she and Brenden were doing most of this on Christine's laptop.
Correct.
And so, we have control of our devices, right? Say we have an iPhone, well, you have a MacBook. It's all connected. So who's to say who physically is in control? It's very confusing. And I think what was interesting for me was hearing one of the people that was up there on the stand, and I can't recall which person said it because we heard from so many people today, but he said, you know, you can't tie a device to a person. So it's interesting to hear that.
Yeah, I think the testimony there was, as a digital forensic expert, the mere fact that something appears to have come from somebody's digital device is not ipso facto proof that that individual sent it.
Yeah.
I mean, which kind of makes common sense based on what I was just talking to you about. So it really, it's the prosecution's idea that this was a setup, okay, and this was all done in order to get rid of Christine, and that Joe Ryan was unfortunate collateral damage in this scheme, is a hard one in the sense that the government is going to have to show that this entire catfish effort, how do you explain the killing of Christine by Ryan? I mean, it's one thing to say, oh, I happened upon this assault on my wife and I took efforts to protect her by shooting this assailant, not knowing it was a rape fantasy. But how does it follow that this assailant is meanwhile stabbing her?
Right.
I mean, it's one thing to engage in a fantasy and participate in it. It's another thing to decide to take it that one much step further and not only, quote, rape this person, but kill them.
Right.
Which is really, I mean, is the theory that this Ryan was so depraved, so out of control, so unwell, that he kind of seized the moment to take it that one step further and kill her?
Yeah.
You know, these are
We haven't
things
heard the defense say that,
we haven't heard that. So the defense is not necessarily, as I said, positing an alternate theory of what happened here yet.
Yeah.
They're more just questioning the government's conclusions, questioning the government's investigation.
Yeah. And you know what's interesting about that? You're saying how they haven't provided this alternate theory. So the only alternate theory that we have heard John Carroll provide is that very initial in his opening statements, he said Christine was killed by Joseph Ryan, but he's never really shown us what he believes kind of was the backstory there.
Right.
And it's interesting you bring up the correlation of the rape fantasy to killing someone. I interviewed Joseph Ryan's mother 2 weeks ago before the trial started, and she and I talked at length. She had a very close relationship with her son, and he told her about some of the things he was into, and she told me he was into these sexual fetish websites. He would go on there, and the term knife play came up, and that was essentially what was supposed to be part of the plan here, according to those FetLife conversations. And she said to me, you don't go from knife play to murder. And she was saying,
my point. Yeah.
People involved in that type of sexual activity, they have rules, and there are very strict rules, and you have a plan, and the goal is not to hurt the person. So it's interesting to hear all the different perspectives, and obviously we're learning so much through this process. And there's, again, we want to remind you, a ton of graphic information through this. So if you have little ones at home, try and keep them away from this conversation while we're talking about it. Again, Paul's going to be answering some of your questions. So if you want to text those to us, the number to text is 202-895-5599. But before we get to those questions, I do want to recap some of what's happened this morning. If we're able to play some of the audio from earlier today when we were hearing investigators be questioned by John Carroll, Sergeant Ames specifically be questioned by John Carroll about whether or not he follows the evidence or the theories. So we can play that right now. I'd like you to take a listen. All right, it sounds like we don't have that, but we were able to listen to that. So we do have a different clip. If we could play that, and then we'll have you react to that.
Excellent.
Are you the type of investigator that follows the evidence, or are you the type of investigator that follows a theory before the evidence is developed?
Me as an investigator, I go with evidence.
Okay. What, if anything, do you do when you question a suspect in terms of their story?
I mean, I have a conversation with them, sir.
Okay. And if the conversation isn't consistent with the evidence that you have, how do you handle that?
I mean, if I have the opportunity, I clarify it.
All right, so who you just heard there on camera was Sergeant Brian Ames, and he is now with the Internal Affairs Bureau for Fairfax County Police, but at the time, he was assigned to the digital forensics section, so he was essentially Brendan Miller's supervisor, Detective Brendan Miller. He did clarify that he is not the person who chose to transfer Brendan Miller, but you could hear him there being questioned again on that. Did you go by evidence or did you go by theory? Just for people watching this at home, what was the goal there? What would your mindset be for John Carroll?
Well, again, I think that John Carroll is trying to present in the mind of the jurors that there was a theory that was adopted by the police and that they then tried to marshal the evidence to fit the theory. Now, that's not the way it's supposed to work. And I think that some of the witnesses who were police officers or retired police officers did a good job of saying, look, this is an evolving fluid process. One of them used the term fluid. So we might think that it was this, but then we get more evidence and we switch to this line of thinking and we go to this evidence and we switch back to this. And they seem to be painting the picture that there was no bias, that there were simply different ideas that were being posited for what might have happened here. And that it was Juliana's testimony that ultimately confirmed their theories of catfishing. And of course, John Carroll is trying to attack each level of this. So not only is he attacking the police investigation, but he's also attacking the credibility of Juliana. Because if so much of the case hinges on her testimony, then to the extent that you can show that she said one thing one day and then something else another day, it gives cause to question her testimony and therefore the government's case.
And that's really their goal, just to get the jurors questioning things, right?
Correct. To the point where there is reasonable doubt. Correct.
Right. And for people at home who are tuning into that, why do you think it's so important to keep reminding them, they don't have to prove that he didn't do it. They just have to prove that there are questions about whether he did it.
Exactly. I mean, sometimes you hear defense attorneys use an analogy when they stand up in closing, where they say, if you're going to go across a river on one of those step bridges, okay, and you look across and you see all the planks are there except for one or two, okay, that's enough. That's enough for reasonable doubt. You may have built a lot of the case, but if you didn't build certain critical components of the case, that equals reasonable doubt. So the job of a defense attorney is to remove those planks from that bridge and create that doubt.
All right, so I do want to play another clip from you from earlier today. I believe this is also Sergeant Ames. And this is a moment where I was thinking to myself, was this actually helpful to John Carroll? So if we could take a listen to that moment.
Did you have any role in his transfer, whether administrative or making the decision?
No, not making the decision. I think my role was figure out where Miller wanted to go initially and just be a first-line supervisor for him.
Okay.
Okay, so to me, my reaction was, wait a second, was that helpful to him or was that helpful to the prosecution? Remember, this is the defense's witness that they called up there.
Well, I actually think it was somewhat helpful to the defense. And I say that because it was not very compelling testimony about why this Miller was transferred when Miller is the one who made this conclusion that didn't square with catfishing. So when you heard him just testify now, it's not like a compelling, here's why. It's more of a, well, he got transferred to where he wanted to go. Actually, later, when you hear other witnesses, it's not, quote, where he wanted to go. This man was evidently transferred because of performance management issues, which have not been specified, but it's building Carroll's theory that they got rid of the guy who didn't agree with them. And therefore, it's yet more evidence of a rush to judgment or a biased investigation.
Yeah, and you mentioned how later we do hear a little more passion behind the reasons of the transfer. And I think it's interesting, when we heard from John Patrick Bruce, who was with the Fairfax County Police Department, he was a deputy chief. I believe he was a captain at the moment of when the crime occurred, but he was the deputy chief. And, part of the conversation he shared was that he did say in passing that he did not want to see Brendan Miller work another case for the Major
Correct.
Crimes Bureau. And I think that was extremely powerful.
Oh, that's very powerful.
Yeah.
I mean, it appears that this Miller's boss is saying, I don't want him doing another one of these cases.
Right.
I mean, and he was asked, well, is that just because of the Banfield case? Or is it some other thing? No, it's just because of the Banfield case. So
Right.
there are internal apparent divisions, squabbles, disputes within the police department over these conclusions about catfishing, about the Miller version versus the other versions. And to the extent that the defense can show that, they tried to sideline or get rid of people who didn't agree with their theory of catfishing, the better it helps the defense, I would say.
So everyone is starting to send us some questions, and we are going to get to those questions in just a moment. Again, if you have questions, text them to us at 202-895-5599. I see a few popping up here, so I'll get to those in just a moment. I do want to go to the next person who testified first real briefly. We do have some sound. This was Detective Leah Smith, and I think her testimony was very interesting. So let's take a listen, and then we'll have you.
Great.
There were two theories in the case, and we needed to get behind the right one. I told Lieutenant Smirk in a room full of investigators that at this point in time, nobody should have a theory in the case, that we are still at the very beginning, and we should only be investigating and gathering facts and information.
And how was that received?
There was no response.
Okay, so she uses the words, they had no response, but a no response is still a response, I always like to say.
True. No, I mean, silence is the unbearable
Right.
repartee. But what I found significant about what she had to say was that she used the phrase, get behind
Right.
the theory, okay? That there was evidently some sort of explicit or implicit pressure to, quote, get behind the theory that the supervisors wanted.
Yeah.
And she was pretty candid about that. Although I will say, what she went on to say is, look, I'm not pushed around, essentially. I have an independent obligation as a detective to go where the evidence leads.
Right.
And that's what I did. So while there may have been this sort of push to get behind a theory that she described, they didn't end up pushing me, was ultimately where she came out.
Yeah, and actually that brings us to this next audio clip I want to play for you, this clip from inside the courtroom earlier today. Again, Detective Leah Smith, and kind of branching off of that, she's further questioned by John Carroll. So let's take a listen to that. All right, so what she ultimately says is that she's asked, was the ultimate goal of her and the other homicide detectives what was their ultimate goal in arresting Juliana? And she said it was evidence and belief that there was more to the story. We go on to hear a lot more about that. But in that moment, how powerful is that exchange?
Well, I mean, I think the fact that Juliana ultimately proffered a theory that was the catfish theory really is critical for the prosecution, of course, you know, and it is, as a defense attorney, you look at this and go, wow, that's a long period of time from the time of the murder to the time when they actually end up having a preliminary hearing for Juliana and arresting Brenden. So there's a lot that happened during that period of time. And we know there were a ton of search warrants. We know there was a lot of digital evidence. So the fact that something takes time doesn't necessarily mean that you're not sure what you're doing or what your conclusions are. It takes time to build a case and get all the evidence. But it appears that it's her testimony that confirmed the prosecution's theory.
Right.
And I think it's unwise in some ways for the witnesses to keep on using the term theory, because I think the better term, if I were, suggesting a more accurate term, would be determination. We reached a determination.
Right.
Theory makes it sound like you don't really have much to go with.
Is that on purpose, though? Is John Carroll using the phrase
I
theory?
think he is,
Yeah.
because he wants to paint this as a theory in search of evidence, to use his words, okay? And I think the prosecution witnesses are kind of buying into his phraseology,
Yeah.
rather than saying, wait a second, this isn't a theory. These were, viable, possible determinations that the evidence was pointing to. But the evidence varies. We get something new, we shift it this direction. We get something else, we shift it that direction. That's the nature of police work.
Yeah, and you mentioned the multiple theories, if you will. You've even heard some of the police officers that took the stand using that word theory. Before I get to what I was going to say, how harmful of a word theory is it to the jurors, for the prosecution, for the jurors to keep hearing that word theory? How detrimental is that?
Yeah, no, I think if I'm a juror, I'm potentially thinking, well, wait a minute, is this all built on a theory? Is the evidence conclusively in line with that theory, or are there suggestions that, maybe there were counter theories, maybe there were people who supported those counter theories, and maybe those people were transferred? What's wrong here? This doesn't look great. I'm not sure if I'm comfortable finding guilt under these circumstances. That's what I think the strategy is with the use of the word theory.
Yeah, and of course, I do want to mention one other thing that Detective Leah Smith said. She said that it didn't change how they investigated the case, and they made the arrest of Brendan Banfield a month before Juliana took that plea agreement. She said they made it because they got back the blood evidence. So she's going back to what we heard the prosecution say, that the blood evidence is what you need to listen to, and Juliana's the bonus.
Yeah, no, look, and I haven't listened to all the blood evidence, which was an entire day of testimony. But it seems to be focusing on the idea of whether or not the blood evidence supports that, Christine was stabbed and therefore the blood flew out and landed in a particular pattern on Brenden, or whether or not he had blood transferred to him in trying to address the circumstance on the scene, okay? So in the end, I think jurors really value scientific evidence because it's much less, as the defense attorney said, forensics don't often lie, people lie. So I think that's what the prosecution is trying to do, is use that whole theme against the defense by saying, here we've got evidence of blood spatter that does not support the idea,
the theory,
that,
if you will,
that Joe killed Christine.
Right. All right, well, let's talk about one of the next people to take the stand, Detective Matthew Nielsen. And one thing that stood out for me, he was asked the question of what was the ultimate goal of arresting Juliana, like we previously heard. And he said evidence, but also belief that there was more to the story. When he said that on the stand, it got my attention because I was like, oh, wait a minute. He's going to corroborate the story that John Carroll has told, that Juliana was only arrested so they could get his client. How important was that testimony from him kind of agreeing with what John Carroll has said?
Well, I don't think he was suggesting that she was just arrested for the sole ultimate goal of hearing what she had to say and having her fill in blanks. I mean, the police have to have probable cause, 51%, so to speak, in order to justify an arrest.
Do you think, though, that was made clear in that testimony?
I don't know. It wasn't, as forcefully made, that point, as it should have been. I mean, I think the police have to support the integrity of their own operations, and they need to rebut any suggestion that this was just a sham. They need to be able to say, look, we don't deprive somebody of liberty and choose to arrest them for something as serious as murder without having what we believe to be sufficient evidence that we know is going to be combed through and challenged later on. So when you arrest somebody, do you have then leverage to maybe hear more for them if they want to cooperate so they can fill in blanks that maybe you have in your investigation? Yes. Does that mean that your arrest was ill-founded from the start? Not necessarily.
All right, let's get to some of those questions we've been receiving. The first one we'll start with, somebody texted us, if there is a retrial, so I guess they're asking if they do not come to a conclusion, if there is a hung jury here, will the nanny, Juliana Peres Magalhães, be held in jail until the next trial? How does that work out? Because her plea agreement was that she testifies, and then she would
Yeah, I
subsequently be
don't know the
released.
details of her plea agreement.
Right.
But the basic answer would be, if you're required to testify, then you testify once, and there's a mistrial or hung jury or whatever it may be. I mean, if there's a hung jury, you're not going to have. But if there's a mistrial, okay, and they have to do this again, all right, yeah, I think she would have to testify again. I don't know the specific terms of her plea agreement, but that would be the general way that it is done. So it's not as though, oh, we got a mistrial, well, she's serving time served and now she's gone. No, I don't anticipate that the prosecution would allow that to occur. They're not going to lose this witness who is so critical to their case.
Yeah, I'm going to try to see if we can get our hands on her plea agreement to take a closer look at that. Somebody asked, can jurors' phones be subpoenaed? And I guess that's going back to the conversation of that these jurors were not sequestered. So, they've been told, don't go on social media, don't watch the news, don't go on your phones, don't talk about the case. So can the jurors have their phones subpoenaed?
I mean, look, that is an interesting question and not one that I've ever had to deal with. But I will tell you that our system is built on the idea that jurors take their solemn obligation to follow instructions to heart. Now, does it always pan out that way? No. But in order to have any basis to question the integrity of the jury process, there would need to be, after some sort of verdict is rendered here, there would need to be concrete evidence of juror misconduct, i.e., ignoring the judge and looking on social media or listening to what we are saying now, in order to justify, the issuance of any subpoena by a body. I mean, that would be a high level. So I don't think that's not a routine thing. Okay, after
I've
you
never
have a
heard
verdict,
that, yeah.
you say, hey, all right, everyone, please turn over your cell phones so we can check them. No, that's not a routine thing.
That's an interesting question. A good question, though. Okay, so the next question we received was, why wouldn't the prosecution have put Joe Ryan's mother on the stand in order to paint a clearer picture of her son and his motivations during all of this?
You actually would be in a better place to answer that question than I, because I don't know. I mean, every decision on whatever side of a case to put on a witness is one that is carefully considered. Sometimes a witness can go astray. And even though they may have told you something in witness preparation, they either are not solid enough in terms of their ability to recall, or they're not solid enough under cross-examination, and you just get the sense that they just are not a witness that you want to call.
Right.
It's an individual judgment call by attorneys. But it also, of course, goes to the substance of what that witness is going to say, not just their ability to say it. So I don't know. One would think that maybe she would help. I mean, the prosecution, from the sounds of it, wouldn't want her to, because she doesn't support the idea that her son would lose control and take a rape fantasy into the line of being a murder. Okay, but I don't know. Maybe the defense will call.
I think it's complicated, right? Because, she speaks to her son's character, but her son's not the one on trial here. So this is a woman who's mourning. I know that she's not in the courtroom as we speak. She's watching this virtually because she does have some medical issues that didn't allow her to travel up here. I know she has been in touch with the prosecution through all of this. She's been in touch with the detectives, but it's not her son who's on trial here. So does she need to defend her son's character? I guess that would be more of a question.
This is a case about whether or not Brenden is guilty. It is not a question about, necessarily the character of Joseph Ryan.
Right.
To the extent that his character or his modus operandi or his practices at a fetishist are relevant to that determination about Brenden and whether or not he's guilty, well, then her observations might be relevant. But then again, her observations might be hearsay. They may not be admissible. She might not have firsthand knowledge of what her son is up to when he was on FetLife. So it may be of limited weight, too. Those are all considerations.
Yeah, and I mean, I would say if you're interested in hearing more of her perspective on all of this, we do have our conversation up on WUSA9.com. I can also link it here in the chat on YouTube, and we can, bring you some clips. We do have a full conversation that we are planning to upload after the trial is over. Let's get to some more questions, though. Somebody asked, how come there aren't more witnesses in terms of more neighbors? I guess this is kind of on the branch of that, but more neighbors, family members of the victims, friends, people who can sort of bring emotion to this. I'll add that we did see Gary Benson, Christine Banfield's father, take the stand. He was the last witness called by the prosecution, but it was not an emotional testimony. It was focused on Christine's medical history as a child, how she was injury prone. Why is it, do you think, that the prosecution didn't call any emotional witnesses other than Juliana?
Because I don't think the prosecution is building its case on the emotions of friends or family. The prosecution's job is to build a case based on evidence, based on testimony from people who have the ability to observe, based on digital evidence, based on circumstantial evidence. The fact that somebody is deeply aggrieved by the unfathomable death of Ryan or Christine is in some ways not relevant, okay? And there would be a strong objection on the defense side to producing evidence of this kind, which would be seen as meant to inflame the jury's passions rather than have them focus on the actual evidence. So that's typically why why a court is not going to say, well, and why the prosecution is going to say, why are you presenting, or why the the defense would say, why are you presenting this witness? There are limits to what sort of witnesses are appropriate in this type of trial.
Yeah, and I think it is important to mention, so many people are looking for that emotional factor to it. And this is a criminal trial. This is not a Lifetime movie. This is not a Netflix reality kind of documentary. This is real life, and these are real lives. And I think a lot of people are confusing maybe the TV version of what a crime and a trial are and what reality is.
Yeah, but then again, you don't need emotion here. This is so on its face horrible.
Yeah.
The idea that a woman was killed, a man was killed, a 4-year-old is in the basement, and you've got two people who evidently were in love and whose lives are now forever, regardless of this case, irrevocably destroyed. This is not a situation that is, even if it sounds dry at times, this is not that. This is a tremendous tragedy all around.
And we were even talking about how it wasn't as interesting, if you will, to listen to some of the testimony today, but I thought it was fascinating because we're learning a lot of the background behind this, a lot of the details around that science. So we're learning the science to it, but then we're learning the why decisions were made. So I think this is all very fascinating to understand.
I mean, I can tell you that in any criminal case, you're going to have the hard type of forensic evidence. You're also going to have the very human evidence of why people might shade their testimony in a certain direction. You're going to have inconsistencies of memory. It's a human process ultimately. So yes, it is complex, and this is a complex case.
All right, I'm going to get to a question that we have been posing to every attorney who sits here next to me, and that is, do you think that Brendan Banfield will be called to testify?
I mean, I am not yet there, and I can't tell you.
Yeah.
I think the prevailing wisdom among defense attorneys is, if you don't necessarily need him, don't take the risk, okay? I would say that if Carol is able to cast sufficient doubt on the integrity of the prosecution's case, then he's not going to have Brenden take the stand. Why? If he feels like he's moved the needle enough where a juror is going to say, you know what, I just don't feel comfortable finding guilt beyond a reasonable doubt when there's so many questions about, the Miller report and other things. In that sort of circumstance, no. There are cases where there are so many kind of awful circumstances that have not been explained, where you say to yourself as an attorney, look, call the person, call the defendant, Because if they don't hear, if the jury doesn't hear, it's not going to work. We're not going to win. We need some sort of explanation. We need something that ties everything together. It's a huge risk, but sometimes it's a risk worth taking. I think it's premature to make a prognostication of whether or not Brenden is going to be called.
Right.
Let's see.
At this very point, is it beneficial to have him up there, do you think? If you were Brendan's defense attorney right now, would you think I need to put my client up there, or are you keeping him away from the stand?
Well, look, from what I'm hearing, there is evidence that seems to suggest that there was concerted action between Juliana and Brenden. You know, oh, I'm going to go ahead and fix the windows so that they are more soundproof. Oh, I'm going to go ahead and call you, and I'll be sitting outside, and when I see Ryan go into the home, I'll let you know. I mean, these are detailed, concerted efforts that show collusion between these two individuals. If there's some way to explain this alternatively, if there is some way for Brenden to stand up and say, you know what, there's a lot of confusion here, but let me explain it to you, okay? I was waiting because I was, part of this whole fantasy myself, and I was just waiting to see what would happen. I don't know if there's an alternative explanation, because otherwise you're saying to yourself, well, if there's concrete evidence of all these plans and of them waiting for Joseph to go in and calling each other, that's pretty damning when it comes to whether or not this is a setup.
Right.
So, I would not have the benefit of knowing what Brenden has to say about all this. Obviously, I'm not his attorney, but if he can clear up some of these things without exposing himself to withering cross-examination on others, yeah.
And I was going to bring that up because, when you call a witness to the stand, that allows the prosecution to then ask their questions.
Correct.
And, I would imagine one of their focuses would be on that affair. In your opinion, how crucial is that affair to the outcome of this trial and the determination of whether or not he did something like this?
Well, the affair seems to give the motive, okay? If there was no affair, well, then why is he doing this?
Right.
Why would he be setting up this elaborate catfishing thing in order to get rid of his wife, okay? Why does he want to get rid of his wife, according to the prosecution? Because he's fallen in love with Juliana, and they want to have their own life.
And divorce is not an option.
But something stands in the way, and that person is Christina. So that's why their affair is so important. And it also helps explain, at least, to some degree, why Juliana may have been loyal to Brenden for a long period of time because of that connection, because of that affair, and why she evidently, at some point said, look, I'm not going to continue down this path. I'm going to go ahead and plead guilty.
Yeah, and she was, I'll add, questioned about that pretty intensely when she was up there on the stand. She was questioned about the timeline of why she waited almost a year to decide to take the plea agreement, what was going on there. They had her read some of the letters. So initially she was writing letters to Brenden, how she was so in love with him, was going to make sure nothing happened to him. But then the letters transitioned to her talking about how she was disappointed with her attorney and the way he was handling things. And then one of the final conversations was with her mother, where her mother said, you need to tell Brendan's mother that he was the orchestrator of this. And for your background information, the prosecution has said that Brendan's mother is who was paying for Juliana's attorney up until that moment she took the plea agreement, and that's when she stopped. So some interesting stuff there. And I know that Brendan's mother wasn't on one of the initial witness lists. We haven't heard from her yet. We know she hasn't been in the courtroom through this process. Matthew Torres told us that she was not in the courtroom. So there was this anticipation of, is she going to be called to the stand to talk about that? Is she someone that the defense would call up there, or is that unlikely?
That's just too much of a black box for me to opine. It would require too much kind of speculation. But my overall thought on those sorts of issues, again, is that you only call someone if you make a determination that they will advance your theory of a case, if they will support with evidence what you are trying to show, whether you're on the defense or on the prosecution. So if somebody has obvious bias, if somebody is not didn't firsthand observe something, and I don't know about Ms. Banfield, but you are going to have some hesitation about whether or not that person is worth calling. Because the last thing you want is to build a strong case and then have it kind of crumble like a house of cards, because you call a witness who maybe added a little bit but wasn't that critical and then blew it on the stand.
Speaking of calling witnesses, somebody asked in the comments here, can the defense call Juliana for further questions? I can tell you that they can call her for further questions because she is subject to recall. When she finished up her testimony, the judge said, as she does with each person that's up there on the stand, is this witness subject to recall? And before she could even get the words out of her mouth, both attorneys, the prosecution and the defense, said yes.
Right.
The question now, from my perspective, is will they call her back up there? Do you see this going in a direction where they're going to bring her back up there?
Well, I think it's certainly a possibility, all right, because she is such a critical part of this case that to the extent that the defense can hammer away at her testimony, so much the better. Now, you always take a risk that if you have somebody recalled, they might be a little more prepared, they might be a little bit thoughtful, and they can clean up some of the messy stuff they created the first time around. So you have to be a little judicious about whether or not you actually recall somebody. If you got enough out of somebody in the first testimony and you don't want to mess with it, then keep it as is. But if he didn't feel like he was able to get everything that he needs out of her, and if there's, for example, certain evidence that he strategically held in reserve thinking he would recall her, then he's going to recall her. And he's going to do his best to make it sound like she is trying to save her own skin by adopting a prosecution theory that she initially did not support.
Yeah, we heard him, when she was up there, he was, peppering her with questions. I actually think this might be a good time to just take us back to last week when she was up there on the stand. You'll hear a couple of other witnesses, but let's listen back to that testimony between her and the prosecution and defense.
I need help. There is my friend. She just was attacked in the neck. Now she's bleeding a lot.
My name is Brendan Banfield. I'm a federal agent. This is my house. There's somebody here. I shot him.
What did you see when you went into the bedroom?
At first glance, I saw a female that was nude. She was covered in blood with a gentleman standing over her with bloody hands.
Who is the shooter? Who shot who?
Brenden, he's an officer.
He first asked, does he have a pulse? He did follow up with, is she breathing? Or is she going to be okay? Was what he said.
What's going on this morning?
Brenden said, no, police dropped the knife, and he was saying, I'm gonna kill her, I'm gonna kill her. And I don't know, he started stabbing her. I think Brenden shot him.
Initially, we walked outside, allowed the first ambulance to leave, and then Mr. Banfield was taken into a second ambulance.
What, if anything, did you see him do while you were in the hospital room with him?
He washed his hands.
And before he washed his hands, had anyone swabbed his hands to preserve samples of blood that were on his hands?
No, I was trying to be empathetic.
Yes. No, I understand. Was there anybody who told you not to do that?
No, sir.
This case under penalty of law.
Yes.
Thank you.
Now you can have a seat.
But I told the detectives that day, it was the version Brenden had told me. Brenden said he yelled, police officer, and she yelled back at Brenden saying, Brenden, he has a knife. That's when Brenden first shot Joe. He got on top of her, and that's when I first saw him stab her with a knife. And I just start telling him, he's moving, he's behind you, and that's when I fired the shot too.
Did you see him interacting with Joe or Christine after you shot Joe?
Well, he was still stabbing Christine, and he got her blood, a handful of blood, and he starts dripping on Joe's body.
You asking the ladies and gentlemen of the jury to believe that you came out during that time frame because you wanted the truth to be known versus any time the year before that?
Well, the fact that I took a year to accept my plea, it does not mean that I didn't have any intention to tell the truth before. I had a video call with the producer who works with Netflix, and they want to make a movie or documentary about my case, and he explained in terms of compensation. So they were thinking about $10,000, but I want to negotiate. I want more than this.
You were charged with murder because you shot someone. Am I wrong?
No, you're not.
And so why would you deserve something because of that?
Not because of that. I didn't say that I deserved something because of
Okay.
what I did.
I didn't hear any details, so feel free to tell me why.
I'm saying for after, when this is over, for me and my family. And again, for everything we've been through.
All right, so those were some of the highlights from the first few days of testimony. Most of Juliana was on day 2 of the trial and day 3. So day 1 was jury selection. Day 2, we heard opening statements, a ton of witnesses, ended the day with Juliana. Then Juliana went through the entire next day. Were you surprised by her testimony at all? There was kind of, I'll give you a little backstory. There was a transition of her personality up there on the stand. You know, when she was with the prosecution, she was very emotional. But when she was up there with John Carroll, she was up there all day for background. You could see her starting to get frustrated with him.
Yeah, I mean, she is in an excruciatingly difficult position. She is, you know, required to testify as part of her plea deal, and she has a huge amount to gain because then she will be released on time served. So there are reasons to kind of question, the defense would say, her testimony because she has such incentive. So, you know, how did she acquit herself? How did she appear before the jury? Did they like her demeanor? Did they feel like she was being credible? That's for the jury to decide.
All right, so it does look like court is starting back up, so we are going to take you back inside the courtroom, and Paul will be here with me during the next break to answer all of those questions you probably continue to have, but let's head back into the courtroom for now.
All right. Are we ready for the jury then? Yes, ma'am. Let's wait. Mr. Carroll. Thank you. Bless you. Bless you. Great. Let's get the witness back on the stand. Sir, just a reminder, you're still under oath, okay?
Yes, ma'am.
Thank you. All right, your next question.
Yes, sir, Mr. Giaio.
Could you move the microphone back towards yourself there?
Oh, sorry.
There you go.
Can you hear me now?
Yes.
Okay.
Very good.
Lieutenant Giaio, I'm going to ask you to look at what has been identified as Defense Exhibit 102. You recall that conversation and who it was with?
Yes, and it was with Deputy Chief Bruce.
Okay. And, Your Honor, if I'd move that into evidence?
Oh, sorry.
Thank you. Any objection?
No, ma'am.
All right, 102 in evidence.
Now, this, the date is significant for what reason?
I believe that's the date of the proffer.
Okay. And was the proffer occurring at that time?
It was later that evening.
Okay. And what time did the proffer start, do you know, in the evening?
I believe somewhere around 4 or 5 is when we began. I don't recall exactly, though. It was in the evening hours, though.
Were you in the room where the proffer was occurring or the room next door?
Next door.
Okay. And how were you linked up to the proffer?
By phone.
A phone was just left open and you could just listen to it?
Correct.
Okay. Was there not enough room in the area where the proffer was occurring?
It's a relatively small conference room, but it was a decision of the Commonwealth Attorney who was in there.
Okay. Who was the Commonwealth Attorney?
That was Mr. Klingon at the time.
Okay. And was the decision that you would be out?
Yes.
Or there wasn't enough room?
I can't speak to what his mindset was. I mean,
I told you you're out.
Correct.
Okay. Now, I think we have a previous exhibit where it was requested that you hold back information from Klingon and Kelsey Gill. Do you recall that?
Yes.
Was that around the same time frame as this?
I don't know. If you could show me the exhibit, I can tell you. Yeah.
Exhibit 100.
It looks like that was in June, middle of June 12th.
Okay. Did it ever come to light that you were holding back information from the Commonwealth Attorney?
We weren't holding back information. It was simply to allow time for, I think, Deputy Chief Bruce to notify up the chain of command.
Oh, okay, so is that reflected here in this message?
No, but that wasn't unusual.
Okay. Was there some reason that Deputy Chief Bruce or you, if you can answer, didn't want to include the prosecutors in this case?
We always included the prosecutors, but there was a major piece or a major change, then I would notify Deputy Chief Bruce, and he would notify it up the chain to the Chief of Police, and we wanted to allow time for him to be aware of it on our side so that he would hear from it from us rather than from the Commonwealth Attorney's Office.
Okay, so looking at this exhibit that's been introduced into evidence, was the meeting with Cellbright a major change?
I think that what he's referring to is the blood evidence, not the meeting with Cellbright.
Okay, because Cellbright doesn't have anything to do with blood, correct?
No, that's digital evidence.
Okay, I'm just following my questions up on your statement saying whenever there are major changes, we might delay so he can go up the command staff chain before telling anyone else. So what I'm asking about is in this one, is Cellbright a major change?
Judge, I'm going to object. I think objection is to form. Mr. Carroll is misreading the information. There was no meeting with Cellbright. The statement is meeting with task force after Cellbright.
All right, I'll sustain
Fair
as to
enough.
form.
You testified that traditionally Deputy Chief Bruce would say, hold off so he could send it up the flagpole, essentially, correct?
Correct.
Okay.
But I think you're confusing what information. The information is the blood information that he's asking me to hold off on is the way I understand it.
Well, yeah, that's...
The Cellbright has nothing to do with the later statement.
And where does it say that?
Well, I'm saying that.
Okay. And so that would be, what you've just testified to was that this would happen when there were major changes so that everyone and staff could know and be able to answer questions by the press and things like that. Is that correct?
Correct.
Okay. And in this case, what I'm saying is, what is the major change in the case that would cause there to be some delay in talking to the prosecutors?
The blood evidence. So Christine's blood inside Juliana's shoes and on Brendan's pants.
Okay.
That was new information, so that was something that I considered significant.
Okay, you sent that on. And then, so you remember that moment?
Well, yeah, I mean, I remember sending the text, yes.
But do you remember as you're reading this text, what the context of it was?
Yes, we got a lab sheet back that contained new blood information, and I notified my chain of command.
And so what about that would not directly relate to information the prosecutors need?
I'm not really following what you're trying to ask.
Okay, I'm trying to understand why there is any need to hold back evidence from the prosecutors.
There was no holding back evidence. It was merely giving time for it to get up our chain before the notification was made to the prosecutor's office.
Okay, and you don't know specifically what that time was?
I think I testified earlier, it was no longer than 24 hours. It was either later that evening or the following day.
Okay, but we're now talking about this major event of the blood evidence that's referenced here, and that doesn't tell you any different?
Objection leading, counsel's testifying.
Is leading.
Now that we're identifying what it is that was the major evidence break, do you remember why you were holding back and when you ultimately gave them the information?
Again, Judge asked and answered. He has testified that He does not recall specifically when he shared the information, but he knows that it would have been within 24 hours.
I think that was previously, Judge, when we weren't talking about the major event, which is what he just testified to.
All right, I'll overrule, go ahead.
I'm sorry, can you repeat them?
So what was it about this major event with, I guess, a lab sheet coming back that caused you to hold it back from the prosecutors? And then my question is, if it's a major event, wouldn't you have an idea of how long you're holding it back from the prosecutors?
I wouldn't say major. It's a significant thing that we get a lab sheet in that shows blood evidence. There's no holding back. The evidence was all provided to the Commonwealth Attorney's Office, but we allow time when we get some kind of information for it to go up the chain of command so that they're all aware of it, so that they can, if the Commonwealth Attorney's Office calls over to somebody higher ranking, that they can speak educated about it.
So is that a policy?
I mean, it's just how we do business. There's not a policy.
But I mean, somebody has to determine it's major, and somebody has to then make the decision whether it gets held up.
I think it would go to my discretion whether it's something I'm going to notify my chain of command, and they're going to tell me sometimes they're not, it's not significant enough that they would hold it back. Or perhaps, if it was a phone call and the deputy chief was with the chief or the assistant chief, they could relay it immediately. In this case, I'm assuming that the deputy chief didn't have immediate access and was waiting for some reasonable amount of time so that he could make that notification prior to bringing the Commonwealth Attorney into the loop.
How many times in this case did you find yourself speaking to Deputy Chief Bruce at the time about holding back evidence from the prosecutors?
Again, we're not holding anything back. We're making notifications and then notifying the Commonwealth Attorney.
Well, couldn't it also be done as telling them, hey, we haven't made notifications, keep this under your...
Objection leading.
Sustain.
Weren't there other ways to do that with involving the Commonwealth Attorney's Office?
Well, they were involved.
Not if it was being held back.
Objection argumentative.
I'll sustain the objection.
You just testified that they weren't involved because you were holding back.
Objection leading.
Sustain the objection.
Okay. Let's go back to exhibit number 102. This was, it looks like the entire chain was October 25th, which is I think you had previously said was the day that Juliana Peres Magalhães recanted?
Yes.
Okay. And it looks as though, and Your Honor, I'm sorry, have I moved this into evidence yet?
Yes, that's already been
Okay,
evidence.
okay. And you're the blue bubbles there, correct?
Correct.
And I guess the offer hasn't been made yet, but you have the offer there, or has it already been accepted?
I don't know. Okay. I'm aware of the offer. I don't know if it had been accepted yet, I guess is what I don't know the answer to that.
And who would have been involved with that process?
The Commonwealth Attorney's Office.
And do you know who made the offer?
I believe it was Mr. Klingon.
Okay, did you talk to him before that?
I talked to him.
About the offer?
Yeah, there was discussions throughout the case about a potential offer.
Okay, when was the first time that an offer was made in your recollection?
I don't know.
Could it have been around January 1st?
Objection leading.
How long were offers going on as far as you knew?
I don't know.
Were you privy to all offers that were made?
I don't know.
Do you know of any other offers other than this one being made to her?
I believe there were others. I don't know the ins and outs of them.
Okay. And would that be because of your your capacity as a lieutenant in homicide?
Well, the police department investigates and the prosecutor's office prosecutes, so they make those prosecutorial decisions, and I'm not always privy to them.
Okay. How many offers were you privy to?
I know that there were other offers made. I couldn't tell you if it was more than one. I just know that there was discussion that there were previous offers.
Okay. And in the context of the calendar year, and the big events of that calendar year of 24, were there offers made before Brenden was arrested?
I believe so, but I wouldn't know the details of that.
Okay. Were there offers made before the preliminary hearing that was a cause for concern for the fail-safe?
I believe so, but I don't know for sure.
Okay. That was a pretty big event, though, wasn't it?
The preliminary hearing?
Mm-hmm.
Yes.
And that was something that really stood out in your mind?
Objection leading.
Is that something that stood out in your mind?
I mean, it was the first, with my involvement in the case, it was the first sort of major milestone, I would say.
Okay. At any point, did you hear of an offer of a misdemeanor for her testimony?
Not that I'm aware of. Or not that I remember, I guess would be the more appropriate answer.
And I was just going to follow up. There may have been, but you don't know.
Yeah, I just don't know.
Okay. Now, were you involved in any way in your capacity, either directing or performing review of jail calls?
I listen to them regularly, yes.
Okay, and you were listening to them.
Objection leading.
Were you listening to them when Juliana had been arrested and was in jail and Brenden was out?
I don't recall when I started, but I believe it was before. I at least listened to some. I listened to more after.
Okay, but you were the command staff person. Was there someone assigned to listen to calls all the time?
Yes.
And what was the reasoning for that?
Well, part of it was that with Juliana, she spoke in Portuguese, so we had a Portuguese-speaking police officer that listened.
Okay, was that who was assigned?
Yes.
Okay, and what was the goal of listening to her jail calls?
To gather evidence.
Okay. And was there ever any discussion amongst your group about the pressure that was applied to her relating to her being incarcerated?
Yes.
Okay. And was that something that was favorable for what your goals were?
That she had pressure because she was incarcerated?
Yes.
I mean, potentially.
Okay. Were there, in listening to all those calls and having them translated, when you listened to the ones in English, were you concerned about her mental health?
There were times where the officer who was listening had concerns, and we relayed those to the sheriff's department.
Okay. Were there times that you were concerned about her talking about the meetings that she had been with the police and the Commonwealth's office?
I don't recall any concerns about that, no.
Okay, so you didn't hear any calls where she was telling somebody what's going on?
Objection leading.
Sustained.
Did you hear any calls like that?
Like what?
Recounting what the offers were or talking about the case after talking to the police?
Not that I recall specifically.
Okay. And so how often did you find yourself as a supervisor listening to those calls?
If I had free time, I tried to listen.
Was the Portuguese officer that was monitoring them, was it just on the Portuguese calls?
I think he checked all the calls and he summarized them. So from time to time, he would, send a note if he thought something might be worthy of the detective or somebody on the task force, giving it a listen to see what context it had.
And what kind of things were said?
I couldn't specifically tell you. I would have to go through emails.
So it would be something that would be beneficial to the case? from
Objection
your
leading.
perspective? Would it be something that would be beneficial to your case?
Yeah. Yeah, I mean, anything that he thought was unusual or stood out to him, he would pass on. He wasn't directly involved in the investigation, and hadn't reviewed the whole investigation, so sometimes he didn't really know what something might mean. He would forward it on.
In assigning him, did you or anyone give him parameters on what you're interested in?
He was assigned before I got there.
Okay. Did you ever educate him when you got in there, what you wanted?
No. I don't think there was, like I said, he was there and had been doing that for some time before I arrived.
Now, when you arrived, what were you told to do when you arrived?
My job was to be the homicide supervisor. Also, I was asked to review this case and other open cases.
And were you told to close this case?
Well, of course, that's the goal for any open case.
Specifically this case?
Yes.
Okay. Were you told to clean house in homicide?
If necessary.
Did you ever say, or what, if anything, did you say about cleaning house of the existing homicide detectives?
I think I told all of them when I first got there that was not my goal. I hope to keep everybody who was there.
Okay. And did people leave?
Yes.
Okay. And how many people left the homicide squad?
During my time there, 5 were promoted to sergeant. I think they're all back in the Major Crimes Bureau now, and 1 was transferred out.
Okay. And who was that one?
That was Detective Bryant, or I'm sorry, 2. The Detective Bryant and Detective Hanging were transferred out.
Okay. Now, did you have any control over Detective Miller being transferred?
No.
Were you aware of Deputy Chief Bruce at the time saying that he was no longer working on any Major Crime Bureau cases?
Yes.
Okay. And were you aware of any...
I'm sorry.
You okay? Were you aware of any proceedings for transfer for Detective Miller?
No.
Okay, so you had no say in that?
No.
Okay. Or were your discussions with Deputy Chief Bruce informing him as to his decision to transfer?
I mean, we discussed it, but that wouldn't be, it's not even our bureau at that point, so I would have no real input.
Okay. Now, Detective Bryant, he was transferred.
He was.
And that was, I guess, was the decision around the time of October 25th? Which is
I think he was transferred in January.
Okay, but the decision, when was that made?
Shortly, I mean, probably in January, maybe late December.
Was the reason for his transfer the October 25th?
Objection leading.
What, if anything, did the October 25th recant and the time leading up to it, what, if anything, did that do to hasten his transfer?
I think once Juliana came in proffered and provided more context to the evidence, everybody agreed that the evidence was overwhelming and that they had missed the mark, and he was the lead, so that's what ultimately was what caused him to be transferred.
So he was transferred because he didn't get it done. You needed Juliana.
Objection leading?
Sustained deleting?
So am I to understand it was because of
Judge,
Juliana?
that's still leading.
Right, I don't know what the question is, but go ahead.
Were there any other factors that were considered other than what you just testified to as to Detective Bryan's transfer?
When he became aware of the proffer, it was 5 days before he passed that information up the chain of command, so that also played in.
Okay. And his leaving, was that, how was that characterized?
It was a transfer?
Okay. Was it related to discipline because he didn't notify command staff?
No, it was a lateral transfer.
Was that the circumstance of performance management that was talked about last summer?
Yeah, I would say that's the term used.
What is performance management?
Well, if somebody isn't performing at a level that you would expect for the position they're in, you might move them to another unit to gain further experience. And that's what happened in this case.
And he's now in digital forensics. Is that correct?
That's my understanding.
Was that where he was transferred from homicide to digital forensics?
No, he went to sex crimes, also in the Major Crimes Bureau.
Okay, so sex crimes and then now digital forensics?
That's my understanding. I don't have any knowledge of that transfer.
Okay, you haven't
I
kept
wasn't
track
involved in
of
it, no.
anything like that? Now, he was the lead detective on this case from the beginning, correct?
Yes.
From that day on February 24th.
That's my understanding, yes.
And Brendan Miller was the lead digital forensics person from the beginning of the case, correct?
Yes.
And he was the only one that worked on extracting the 60 devices and things like that, is that right?
I believe so. There's two Brendan Millers. I think they may have helped each other out at points, but so I'm not 100% on that. But I believe the Brendan Miller you're speaking of was the lead.
Is that the one that is sitting in the court right now?
Yes.
Okay. And so that, we're talking about the same person.
Yes.
And he was also transferred during that time, correct? Within a month, couple months.
I don't recall the exact time he was transferred.
Okay, but it was soon after the proffer and
yes,
and the back and forth in terms of the emails with Sergeant Ames.
Correct. It was right around that time. So if you put that exhibit up, I could give you a better ballpark.
If I said November 7th, November 8th, would you believe me?
If you're representing that that's what it says, then I will accept that.
Yes.
That sounds about right.
And so now I know you weren't in homicide for long, right?
About 11 months.
11 months. And that was before you were transferred.
Correct.
And prior to that, were you ever in homicide as an investigator?
I was not in homicide, but I've been an investigator for most of my career.
Okay.
Or supervised investigations.
And your career as an investigator was in narcotics, correct?
Primarily before I came to the police department, I did fraud investigations as well.
Okay, with another police department?
With a private insurance company or insurance agency.
Oh, okay. But in terms of your experience, police experience, you hadn't had any homicide experience up until you got there on March 2024.
Only peripherally. A lot of homicides relate to narcotics, so from time to time we would be involved in that aspect.
But you're never the lead detective or anything like that?
No.
Now, in your experience, does it seem odd that the chief detective...
Objection leading.
I don't know what the question is, so if you want to continue your question, I can't rule on it
Does it
yet.
seem odd that the chief detective of this homicide case and the chief digital forensic examiner were transferred around the same time?
No.
Have you ever seen a case where the lead investigator is transferred and another lead investigator is transferred prior to it coming to court?
The lead investigator transferred, yeah, I mean, that happens all the time, I think.
In homicide?
In any case, I think there's plenty of homicide cases where they've come to trial and the homicide detective has moved on through promotion or to another unit prior to the trial. That's pretty normal.
Well, there's a distinction in the way you said that. I'm talking.
Objection, counsel's testifying.
Let me ask you a different question. If the case is getting to the point where it hasn't gone to trial and a homicide detective is moving, that's different than what you just testified to, right?
Objection, leading.
No, overruled, I'll allow it.
I think that's exactly what I just testified to. Sometimes there's an arrest, there's a transfer, and then there's a trial.
Okay. I think, I don't want to quibble with you about it, but I think you had said once the case has gone to trial, then the person transferred.
No, that's not, if that's okay. What came out, that's not what I intended. I don't think.
Perhaps I misunderstood.
Yeah, I think it's relatively normal for a homicide detective to leave the unit, whether it be for transfer or promotion, and then still see the case through to trial.
Okay. And when you were transferred, did you have any additional duties with regard to this case?
No.
Beyond what you had as a watch commander?
Not really. I mean, I provided what I had and moved on to my new assignment.
You gave your one drive and then moved on?
For the most part. Obviously, I've been here to testify a couple times here with you.
So other than being subpoenaed, you're...
No, I didn't have any more investigative responsibility with the case.
Are you aware of whether or not Deputy Chief Bruch, then Deputy Chief Bruch, now Mr. Bruch, has played any role in this investigation since he was transferred to the Administrative Support Bureau up until he left the...
I'm not aware.
Okay. Are you aware of any duties that Kyle Bryant, who was the chief homicide detective, what duties he's had since he was transferred?
My understanding is he remains the lead. He remained the lead when I left, to put it that way.
Okay, so he was actually still involved in certain things, is that correct?
I believe so, yes.
Was that while you were still there, or did that happen after you left?
Well, he was transferred when I was still there, but my understanding is he's remained the lead, and if that changed, that would be news to me.
Was that in talking to him?
In talk about...
Is that how you learned that? You spoke to...
Well, I was still the supervisor, and I think I told him that he will remain the lead.
Okay. And he carried out his duties as he was supposed to, as far as you know?
To the best of my knowledge, yes.
Okay. And then with regard to Brendan Miller, do you know whether or not he had any responsibilities or obligations with this case?
I don't know.
After he was transferred?
That I don't know. I would assume so since he was the lead, but I don't know the answer.
Okay. And in any of the communications about transfer, you weren't privy to that?
So right when he was transferred, there was a couple weeks where we talked about reviewing and he was going through the evidence. Beyond that, I don't know.
Okay. And you didn't keep track of it?
No.
There probably wasn't any reason to keep track of it, right?
Right. I moved to a new command.
Okay. I'm sorry, 102 has been moved into evidence?
102 is in evidence.
Okay. Now, were you when you were speaking to the victim's family, You indicate that you're on a call with the, Joseph Ryan's family?
Judge, can we identify the exhibit?
Which exhibit?
I don't know what we're looking at. I'm sorry.
Is it still
Can you-
102, correct?
Yes.
Okay, thank you.
I think it's written on the bottom right corner.
I can't do that.
So were you the main contact for the Ryan family and the Banfield family?
No.
Okay. What was the phone call about?
I think that was filling them in. Well, I don't know. It may have been to fill them in that the proffer was coming, but I don't recall. Looks like it was right before, so I would imagine, but it wasn't a phone call that I set up or led.
Okay, would that be under your umbrella, I guess, or would that be victim services?
I think that was in concert with victim services.
Okay, and so in concert meaning you were on the phone with someone from victim services?
Yes, I wouldn't have made that call without victim services, but to the best of my recollection, I believe I was just a silent observer in that call.
Who else was on there?
I don't know. I believe that, I don't want to misspeak, I'm not sure.
Okay, I mean, how many times did you talk to the victim's family with someone from victim services?
At each of the hearings, I mean, if they were in town, we always tried to be in the room, or if there was an update, we would update them.
Well, I understand that, but I mean, was this a phone call?
I believe it's a phone call.
Okay. And so would you oftentimes call the Ryan family or the Banfield family part of your?
Primarily, it would be in-person meetings when they were in town.
Okay. And this call would stand out as not being the usual contact?
I don't remember specifically the call. Based on the date, I would imagine that it was to notify them of the proffer.
Sir, can you see what's on your screen?
Yes.
And have you reviewed that?
What number is that?
Sorry, Defense Exhibit 103.
103, thank you.
Yes.
Do you know when that text occurred?
I believe that was during the proffer.
Okay, so you were in the adjacent room?
Correct.
And you were, well, you tell me, who are you texting with?
Deputy Chief Bruce.
Okay, and you're going to move that in as?
All right, any objection to 103?
No, ma'am.
Defense Exhibit 103.
Publish.
So let's go through this. It's tough to see what's under the banner there. Do you know what you wrote?
I think it says no real response yet. I did let Klingon know.
Okay, and you said this is while it's going on?
Correct.
So were you communicating via text with Klingon at the same time you were communicating with Patrick Bruce?
So we had a group thread for questions, and then I was communicating with Deputy Chief Bruce as well.
Okay. Who was on the group thread that you're talking about?
I believe it was Mr. Klingon, Detective Goodell, Detective Bryant, and Ms. Sprisler.
Was Detective Miller on there?
No.
Was there anybody on there that had expertise in digital forensics when those
No.
questions were being asked? Was he still in his position at the time this took place?
Yes.
And was there any reason why he would have been excluded as the expert?
So for the investigative and interview stuff like that, it would be the homicide unit, and then we shared that video later with him.
Okay, but was there any benefit to having his perspective, like it would any other part of the agency that did some investigation?
I mean, I think there's a number of people you can have that are present, so we made it the task force and provided that recording to everybody else afterwards.
Okay, but there would have been room because there was an ante room that you were in.
Sure, there would have been room.
Okay, and so who made the decision to exclude Detective Miller?
Mr. Klingon determined who was going to be there.
Okay, that's different from my question. You just answered my question by saying he determined who was going to be there. Was there anybody who excluded Detective Miller?
Mr. Klingon, I guess. I mean, he determined who was going to be invited.
And okay,
so I imagine the converse would be true.
So because he wasn't there, it had to have been Eric Klingon.
Objection, counsel's testifying, and I think that would be a mischaracterization of the defendant's, I'm sorry, the witness's statement.
Sustain the objection. Next question.
I don't want to mischaracterize. Tell me what you were just saying about who was invited and who wasn't.
Mr. Klingon, I believe in concert with Ms. Sprisler from the prosecution team, determined who and where this would occur and who would be invited.
Okay.
Or excluded.
Now, it looks like there's additional back and forth chat. What's that about?
It's about the, has been characterized, the catfish theory.
And does that highlight the dispute as to who believed in it and who didn't?
I think that's fair, yeah.
And is that why you said you were looking for an apology?
Yes, I think we had back and forth. I advocated strongly that I didn't believe that Christine had set up or sent any of those messages. That wasn't the theory that went forward until Juliana came in and told the truth.
So this is a celebration of you being right?
I don't know if I would call it a celebration, but it's a realization. Confirmation.
And then it looks as though everybody's telling everybody how great they were. Is that
Objection leading.
Sustained deleting.
What's the rest of it about?
I think it's just acknowledging that we had gotten it right, and that now everybody was on the same page, and that nobody believed that we were not right.
Okay. And so you arrived at the determination that you were right because Juliana Peres Magalhães told the story.
Yeah, I think she filled in the blanks, but by and large, what she said was consistent with what I believe the evidence showed pretty much within my first 30 days of being involved in the case.
Okay, so were you aware that it was 2 weeks before trial when this proffer occurred?
Yes.
Okay. And was it your position that you needed her to testify against Brenden in this case?
I thought it would be helpful, but I don't think it was necessary based on the evidence.
And your opposition to Detective Miller's executive summary was based on her testimony, correct?
No. No, I opposed it from pretty early on, but I think it was confirmation. It gave context to a lot of the things that were in there.
Okay. And it was at that point that you worked through his chain of command, Sergeant Ames, to get him to change the executive summary, correct?
I never asked him to change anything. I asked him to review it, be able to explain why he arrived at the conclusions that he had, and to be able to explain why he doesn't believe that that to be the case anymore. And my understanding is that's what he did.
Not with you?
Not with me, no.
Okay. Did you ever go and ask him what his original position was?
I think it's well documented in his summaries. I mean, we discussed it.
That was an inartful question. Did you ever ask him to go through like a math problem and show your work as to how he arrived at those conclusions?
Yeah, we looked at it time and time again.
Okay, but I mean, I'm talking about a comprehensive explanation based on his expertise that arrives at his, did you ever do that?
Judge, I'm going to object, asked and answered, not just now, but earlier, prior to the break.
Sustained. Next question.
When you say you talked about it from time to time, is that a comprehensive review of his work?
I mean, we spent a lot of hours in his lab, yes.
Okay, and were you questioning him?
I mean, we discussed all the things. There was something in the digital side that I didn't understand. I would ask him to explain to me what he felt that it meant.
Okay, so at least one aspect of whatever you didn't understand, you would ask for his explanations. I guess what I'm asking is, did there ever come a time when you had him explain his entire report?
Probably not all at once. Obviously, it was, there was extensive evidence, but we went through a significant chunk of it in his lab, yes.
Now, just specifically with regard to the executive summary, when did you recall, when did he complete it and when did you see it?
He completed it prior to my arrival, so I saw it, sometime probably in that first 30 days in March of 24.
Okay, and at any point did you agree with it?
I think in the first bit, I just took it all in. I tried to take in all the evidence. I spoke with a number of detectives and sort of got their impressions, and then I reviewed it, and then I had questions about the analysis. I think part of the issue is it was not the data that I had issue with, it was the interpretation.
Okay. You mean the statements surrounding the data, the findings?
For instance, he attributes things to people rather than devices.
Okay. And is that something in your digital forensic experience that's not best practices?
I think it's difficult to say who's holding a device if you don't have a lot of context.
I think that's, I mean, isn't that why digital forensics is what it is?
Well, they extract data and look and tell you what's going on, and I think probably some of his analysis went outside the bounds of what he would normally do.
And did you ever directly address him about that statement you just made?
Yeah, we discussed it, and I think he agrees.
You think he agrees?
That it was beyond what he normally does, yes.
Okay. Were you aware of the peer review of his executive summary and files?
So there was stuff sent down to University of Alabama, I believe. My understanding was that they were trying to do a deeper dive into certain devices and see if they could pull more information than perhaps Fairfax County has the ability to pull.
Were they able to do that? Do you know?
I don't think they really got much further than he did.
Were you aware that they concurred in his findings?
My understanding is that they concurred that he extracted things properly and that the data was correct.
Did that peer review change anything in terms of your position as to the executive summary?
I'm sorry, I lost you. Can you speak into the microphone? It's hard to hear up here. I'm sorry.
Did the peer review change your thought process as to the executive summary that he had created?
I think it gave me confidence in the data, but it didn't affect the analysis part of it.
Okay. And so perhaps I've asked you this. What was your experience in the analysis of digital forensics?
Well, I'm not, you're looking at what the data is. I've been an investigator for almost 2 decades. So I've looked at lots of data and developed theories or trends, stuff like that.
But can't anyone do that?
Objection, argumentative.
Sustained. Next question.
Would that be difficult for anyone else to do?
I don't think so. I mean, I've spent a lot of time in investigations and putting things together, and you look at, patterns of life and how people act and how humans behave, and this is just more data points to look into.
Now, and that's what, is that what differentiates experts to investigators?
Well, I think the expert...
Objection, relevance, I'm not sure where we're going with this. He's not an expert, he's testifying as his recollection of the events.
Well, I think the discussion is about Brendan Miller's work.
I'm going to sustain the objection. Next question.
Sir, I'm going to ask you to look at defense number 104. Is that yours?
Yes.
And that's with Deputy Chief Bruce?
Yes.
You're going to move that in as Defense Exhibit 104?
Any objection?
No objection. We also would not object to 105 as it appears to be page 3 of this same conversation.
Okay, 104 and 105 in evidence.
And sir, you're in the blue, correct?
Yes.
And so your first statement there, what does that mean?
Which,
The first statement in blue.
I'm sorry, without the microphone, it's very difficult to hear you and understand.
The first statement in blue?
B guided her through, B was Brenden.
Oh, so you're recounting her story?
Correct, this is during the proffer.
And is this in the ancillary or?
Correct.
The ante room of?
Yes.
Okay, gotcha. And this is Detective Bruce's statement?
That's Deputy Chief Bruce speaking, yes.
Deputy Chief Bruce, sorry. And did you have any, in your text group, did you have any say in any of the questions that were being asked?
Yeah, so we, in the text group, if there was something we wanted to explore, we would put a question in there, and then Mr. Klingon would either ask the question or not, depending on, his expertise, I guess, as a prosecutor.
Okay. Sir, it looks as though 105 has been admitted to evidence.
Yes, that's correct.
Do you recognize that?
Yes.
Okay, and is this part of the chain of text messages back and forth?
Right, it's a continuation of the previous exhibit.
And the discussions in, I guess, the gray is then Deputy Chief Bruce, correct?
Yes, sir.
And then you're in the blue responses?
Yes.
And so these are what you guys are in this, well, tell me what you're talking about there.
So we're recounting some of the stuff that's coming on from the proffer and talking about some of the days leading up to the proffer. And then sort of the response of people who became aware of it.
And the discussions about specific situations, those were your theories going in, correct?
Well, confirming the account that Brenden and Juliana created the account is, yes, part of our theory. And then the revenge rape or was she dead was a question as part of that theory as well.
And it looks as though Klingon is a prosecutor, correct?
Yes.
And there was comments about him?
Yes.
And what about Kyle and Tommy? Who were they?
That's Detective Bryant and Detective Goodell.
Okay, and those were the two head detectives at the time?
Correct.
And is that just banter between the two of you?
Yeah, it's a text thread between the two of us.
Sir, I'm going to ask you to look at defense number 108. Is that your communication?
Yes.
And who are you communicating with?
Deputy Chief Bruce.
Your Honor, move that in as Defense Exhibit 108.
Any objection?
No,
108 in evidence and published.
So it looks like, well, tell me what you're saying here.
Which part?
This part.
I think you just pointed at Deputy Chief Bruce's comment.
Okay, were you part of that?
Yes, I think what it's referring to is where I say this is good, she confirmed that he would send her home a little early from the gym so she could post when he was not in the house, which was confirmation of some of the digital forensics where you could see that Juliana's device and Brendan's device were at the Lifetime Fitness in Reston, and then Juliana would leave, and as her device would leave, as she arrived at the Stablebrook address.
I don't think this is responsive to my question.
Or you want to ask your question again?
Yes.
This area up here, does that indicate that you were still in the room?
Yes.
Okay, so this is while this is going on?
Mm-hmm.
And the things that you're reporting to Deputy Chief Bruce at the time, are those some of the questions that you were sending in or some of the things that you were trying to get the au pair to say?
I wasn't trying to get her to say anything. We were trying to ask questions to get to the truth.
Okay,
And like
were you asking questions regarding that particular incident you just started wanting to talk about?
So that's something I think that came up. Juliana put that out there without being prompted. But like I said, we could confirm it with the digital evidence, and it was, corroborating what she was saying.
Now, when she confirmed that she created the account, did she tell you what the email address was?
I don't recall.
Did she tell you what the password was?
I don't think so, but I also don't think she specifically said that she created the account. I think that she said Brenden created the account.
Okay. Did she say that she was there when Brenden created?
Objection. Calling for hearsay.
All right, I'll sustain the objection.
Okay. Was there anyone in the text group asking her or suggesting questions to Mr. Klingon regarding the account platform?
I don't recall.
Was there anybody suggesting questions in what you saw regarding the passwords?
I don't recall. I do remember that Mr. Klingon had a list of, I think, over 100 questions that he hoped to get to. So a lot of that was covered in there.
Do you know what the origin of those questions were?
I think his review of the case, I don't know though.
Okay. What, if anything, did you know about any meetings that Juliana Peres Magalhães and her attorney had with Mr. Klingon prior to that?
I'm not aware of any, but if it happened outside of my knowledge, I couldn't tell you.
Okay, so it was your impression that she walked in there and
Objection. Counsel's testifying, leading.
what was your impression of the interview?
She appeared truthful, and we were able to corroborate a lot of what she said.
Oh, okay, and is that the measure of the truthfulness for you?
I think when you see interviews and conduct interviews over a course of a career, you start to kind of get a feel if somebody's being truthful or not. And one of the ways we do that is corroborate through other evidence.
Okay. Now, with regard to your digital forensics that you did, and forgive me if I've asked you this, but it's something that I want to make sure we cover. Did you ever extract anything from any of the phones or devices, or I think there were 60 of them?
No.
Okay. And I think you'd said that you don't have any problems with the data that was generated from those.
No, as far as I can tell, the data appears to be extracted, in compliance with the industry standards, and as you said, University of Alabama confirmed that.
Okay, so what did you do to determine what the industry standards were and what he did?
I just took what the Detective Miller represented to me and the University of Alabama report.
Okay, so he says this was industry standards and you accepted it?
Yes.
Okay, so there wasn't any real, to inform your conclusions, there wasn't any real investigation.
Objection, leading.
Was there any investigation relating to digital forensics that informed the conclusions that you were working from?
I reviewed the data. I don't think I did any quote-unquote digital forensics work. He provides data. In this case, he provided some other reports and summaries, but the data is the data. You can look at it and sort of figure out what it means. And if there was something I didn't understand, I would ask him for help. But it was the analysis, I think, of that data that I thought was problematic.
Okay. Court's indulgence.
All right, yes, sir.
Sir, this is Defense Exhibit 104. I think you've previously looked at it. This particular statement right here on the October 25th, that was when you were still in the anteroom where the recant was happening, correct?
Correct.
And that's a statement that you wrote. Is that what was said?
I mean, that's my understanding of what was said. I don't recall the specific wording.
Okay, but you were in the moment and you said that was...
Yes, that would be what I understood it to mean.
Okay. Now, did you... I know it was a goal, or I won't say it that way. One of the things, what if any... I'm sorry, Judge, strike that.
That's all right.
I want to make sure. Was there anything that occurred in the recant when you were in the anteroom that challenged any of the questions that she was asked, or any of the answers that she gave?
I'm not sure what you're trying to ask me. I'm sorry.
Was she challenged on any points in this recant?
You mean, did Mr. Klingon ask her clarifying questions? Yeah, I think so.
Okay. Do you remember any of those?
Not offhand, no.
So the people that were in the room, and I can name Detective Bryant?
Detective Bryant, Detective Goodell, Miss Sprisler, Mr. Klingon, I think Mr. Campbell and his co-counsel may have been in there as well, and Juliana.
Okay, and that was it?
I believe so.
Did anyone else, other than Mr. Klingon, ask questions of Juliana Peres Magalhães?
I don't think so.
Did anybody, if you had a vantage point to see this, did anybody interrupt him to try to get a point across before he asked a question?
I didn't have the ability to monitor the room. I could only video monitor. I could see it on the phone, or got me crossed up there. It was just an open phone line, so I couldn't see anything until afterwards.
So there was no video feed?
No, I couldn't see into the room.
Did you hear anyone challenging like a detective would to what she was saying?
Objection leading.
Status leading.
What, if anything, did any of the detectives or the prosecutor do relating to issues that came up in the questioning?
I don't remember specifically. I think the plan was for Mr. Klingon to do all the talking from the prosecution side. I don't know that any detectives actually spoke during that proffer. And there were definitely times when he asked clarifying questions, but as to specifics, I'd have to watch the video. It's been quite some time.
Okay, and I guess that brings up another point. Is it unusual in your investigations to have the prosecutor question the cooperating co-defendant versus a detective?
To me, it was a little unusual in a state case. In a federal case, that was standard.
Right, but in federal cases,
Objection, counsel's testifying.
there's a little more.
He's still
The
testifying.
objection. Next question.
And did you know whether those people in the room could say something, or were they told not to say something?
My recollection is that Mr. Klingon the plan was for Mr. Klingon to do all the talking. I don't recall there was a, specific statement that nobody else should talk, but that was the plan going in.
Were you involved in any sort of a breakout session between the groups, between the recants?
I'm not sure what you're asking me.
Well, there's, and I think it was on your email, there were 2 proffers. And so there was a break between 1 and 2. Do you recall that?
Yeah, I wasn't present for the second one. I had been transferred by then.
Well, no, sorry. There were 2 separate recorded proffers on October 25th. Were you aware of that? I know.
Yes.
Okay. And then I think on February 7th, there was another proffer. That's probably what you're thinking of.
Yeah, so in the first proffer, between the 2 sessions, we had food. We had taken Juliana out of the jail prior to her receiving a meal, so we provided her some pizza.
Okay. And then were you there for the second portion?
Yeah, I was in the room next door listening.
And
Same through the whole time. There was just a break in between.
Okay, so the break occurred where everybody could join together?
Yes.
Okay, and in that, was there any sort of a discussion amongst the potential questioners that were in the room?
Not that I recall. We kind of scarfed down some food and got back in there because it was starting to get late.
And so it sounds to me like, so Eric Klingon basically controlled the whole process?
Yes.
Was he willing to take input from you?
Yes.
He did? Did he take input?
Yes, like I said, we had a text group where we, provided questions and, and I kind of remember in some cases we would send a question, but by the time, he kind of finished the thought, he already got to that question, and then there were some times where he asked the question. I don't remember the specifics, I just kind of remember that flow.
Was it ever suggested that she take some sort of a lie detector or anything like that before she would be offered that plea?
Judge, objection. It's not relevant.
All right, I'll sustain the objection.
Was there any discussion as to how to confirm her veracity by whatever means?
Yeah, so like I said before, we tried to corroborate a lot of what she said through evidence, whether it be digital or documentary. Like, for instance, the windows, we were able to, that was something we had no idea about. And then once the proffer had been completed, we were able to kind of run that down and confirm it.
Now, did you ever say to any of the investigators that they arrested an innocent woman, talking about Juliana?
No.
That was never said by you to anyone?
About me?
By you to anyone?
No. I think what you're probably referring to is I expressed concerns about the articulation of how, the reasons they charged, but I think the charge was solid.
And who was that with that you expressed those concerns?
Detective Bryant.
Okay. Your Honor, I don't have any further questions.
All right, cross-examination.
Good afternoon.
How you doing?
Okay, so let's talk about this case and how the Fairfax County Police Department Homicide Division got involved. Do you all have a rotation for call-outs when there is a crime committed?
Yeah, so there's what we call a homicide list, and there's, generally about 12 detectives on the squad, give or take, and there's an order, and it kind of rotates through that list so that nobody's overwhelmed with work at any one time.
Okay, so when the call came out for the murder at the Banfield's home, was Detective Bryant essentially on call?
I believe he was up for murder. Again, that was prior to my time there.
Okay.
So
And so his assignment, you indicated that it's not uncommon for cases to be handled by multiple detectives over the course of the case's life. Is that correct?
Yes.
Okay, and in this situation, this case has been pending for 1 month shy of 3 years. Is that correct?
Yes.
Okay, so there's nothing really out of the ordinary about multiple detectives having been involved in this case?
Not at all.
Okay. Likewise, this was a really big case for Fairfax County homicide, correct?
It created a lot of attention, media attention, so there was a lot of eyes on it.
And there was a huge volume of evidence to go through, correct?
Yes.
Okay. And as such, your leadership was very involved in this matter, making sure that they were up to date on how the case was progressing, correct?
Yes.
Okay. So was there anything, again, intended to be hidden from the Commonwealth by making sure your leadership was aware of developments in the case as they arose?
Absolutely not.
Okay. Turning to Ms. Peres Magalhães' proffer, you all were working as a team in developing the questions for Ms. Peres Magalhães, correct?
Yes.
Okay, and it was simply determined that Mr. Klingon would be the mouthpiece in the room, nothing more, correct?
Correct.
Okay. Ms. Frissler was present as she sits here at the table today. This is Ms. Frissler, correct?
Yes.
Okay. And Ms. Peres Magalhães' attorney was present, correct?
Correct.
Detectives Goodell and Bryant were present.
Correct.
All right, and you were all smushed in a room, is that accurate?
Well, they
good
were
for you.
smushed.
They were smushed,
I was
you were
comfortable
outside.
in Miss Frissler's office.
Okay. Was there room for anyone else in that particular room at the time?
It's a small room, as you know.
Okay, thank you. Her proffer was 2 weeks before her trial, is that correct, Ms.
Yes.
Peres Magalhães? And that was more than a month after Mr. Banfield had been charged, correct?
Correct. He was charged September 16th. I believe the proffer was October 25th, about 6 weeks.
So the proffer was not the determining factor in whether or not to charge Brendan Banfield with the murder of his wife and of Joe Ryan, correct?
Correct.
What was it about Ms. Peres Magalhães' proffer that you believed made her to appear truthful?
Well, like I said, we were able to corroborate through digital evidence that she left the gym. She basically said that
I'm sorry, could you put your microphone on? What's your objection?
Objection to, it's outside the scope of what I've asked. It's an open-ended question as to the investigation, and it's...
I'll overrule the objection. All right, continue.
Please continue.
So she essentially kind of confirmed the sequence of events that I believed occurred. Part of the way we did that was looking at the digital evidence. There were things along the way, for instance, going to the gun range, we were able to see pictures of that. She talked about leaving the gym, that Brenden told her to leave the gym early to go home so that he wouldn't be in the house while the FetLife or Telegram account were active. And we were able to see that on the geolocation of her device and Brendan's device, and then we could see her log, or see a log on the Telegram shortly after that device arrived in the area. The windows was something we hadn't had any idea about once she...
When you say the windows, do you mean the replacement of the windows in the Banfield home?
Right, so she said that there was a time where Brenden had the windows replaced with windows that were like soundproof, and he asked her to go stand in the driveway, or actually he asked her to stand in the bedroom and scream while he stood in the driveway to see if screams would be able to be heard. She said that she did not want to do that, and so he screamed and she went outside. We were then able to track down a receipt and some emails, I believe, about the windows, and ultimately find the company and speak with the salesman who spoke to Brenden. And there was just a lot of things that over the course of August until February, in the digital evidence that she was able to corroborate for us in that, or that we were able to corroborate her statement after.
All right, thank you. Just a final question from me. I'm sure counsel will have more. Did you change, distort, or hide any evidence in this case?
No, ma'am.
Okay. Did you direct anyone to change, distort, or hide any evidence in this case?
No, ma'am.
All right, thank you. Nothing further, Judge.
All right, redirect.
Lieutenant Giaio, you were ordered by the court to turn over evidence that should have been turned over months before during the summer, isn't that correct?
No, I gave everything that I had.
The text messages and the emails that you were seeing here were turned over in July when we had a discovery order in November, isn't that true?
Yes, and that's something that we have never turned over in any other case that I'm aware of. So as soon as the court ordered it, we complied.
Okay, and when you say we, who are you talking about?
Fairfax County Police.
Okay, and so the issues relating to the conflict in the case were exculpatory evidence, wasn't that correct?
Objection calls for a legal conclusion.
Sustained. Next question.
Did that ever occur to you that that was something that should have been turned over?
Objection is to the form.
Sustained is the form.
Did the emails and the text messages that you have just witnessed, were they, did that ever occur to you that that was something that should have been turned over on the discovery order?
An objection, Judge. I think we're still on the legal conclusion. He indicated that it was turned over once he received a court order.
I'll sustain the objection. Next question.
Who in your division is in charge of looking to see whether something's exculpatory?
Objection is to relevance.
How is it relevant?
I think the question, this is in response to her question that...
I'll sustain the objection. Next question.
In terms of the transfers of Brendan Miller, or actually I think you were involved with the transfer of Kyle Bryant, what was your reasoning behind that?
Well, I gave input, and my input was that I thought he should stay.
And in fact, he was then removed?
Yes, he was ultimately transferred.
Okay. And what was the reason, the October 25th situation?
Objection calls for speculation.
Overruled if you can answer it.
I think it was a combination of the withholding the proffer for 5 days and, and just being wrong about with the analysis in this case.
And you're talking about being wrong after the Juliana Peres Magalhães proffered.
Well, I think that's when he realized it. I think after that, there was nobody on the police department that I'm aware of that doesn't believe the current theory of events.
I have no further questions, Your Honor.
All right, is this witness subject to recall? No. Oh, no?
No, ma'am, thank
Okay,
you.
you're free to go, sir.
Thank you, Your Honor.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess of 15 minutes. Don't do any outside research and do not talk to anybody about the case. Thank you. And just a reminder, our next, we were going till 5:30, so keep that in mind on your break, okay? Come back at 3:50 then?
Yes, ma'am.
3:50, Mr. Carroll?
I'm sorry.
All rise.
All right, you have been watching the Brendan Banfield murder trial here on WUSA 9+, and we have been watching some testimony from Lieutenant David Giaio for the past 3 hours, really. We've been watching that testimony. Joining me is Paul Kionago. Thank you so much for being here with us. I know we were taking some questions during the lunch break. We do have one more question. I'll start there with that question just so we can get that done with. But somebody asked, how come they obtained all the correspondence between investigators and detectives? I mean, how was it possible? Are they not supposed to be confidential? And I know we were also discussing that at length. We kind of got an answer there towards the end.
I mean, it appears from what the testimony was just now that the court ordered that these text messages and emails be produced. Now, whether or not these are coming from a government-issued work phone or whether they are coming from a personal phone of the detective is not clear to me, but they were ordered to be produced. There was a question about whether or not they are confidential. The answer is typically no. Communications between law enforcement about a particular matter are not confidential. They're not attorney-client privileged, for example. Somebody had mentioned that in one of the questions. So I think this is fair game. And I think it's very important because the defense attorney is trying to build the theme that there was a holding back of evidence, that there was no challenge to Juliana when she gave her proffer, that they were basically trying to guide her in saying the right things, and that this is therefore flawed at the root, this proffer and her involvement. I think what's interesting is that I think the prosecution was able to, through this detective, on cross-examination, have him say, look, when we heard her say things, we had already, in that proffer, we'd already charged Brenden. So her proffer was essentially icing on the cake. What it allowed us to do was to confirm certain things. And then we were able to go out and corroborate when she said that the windows had been changed. We were able to go out and gather evidence to corroborate what she was saying. So he was able, I think he took some hits on direct exam from the defense in the sense that he furthered the theme that things don't, you know, somebody doesn't agree, get rid of them, transfer them, that kind of thing. But on cross by the prosecutor, he was able to rehabilitate some of the themes that I think the prosecution wanted to hear.
Yeah, and he was up there on the stand since 12:30 this afternoon. They went to lunch, they came back, and he was back up there. And this is Lieutenant David Giaio. He is with the Fairfax County Police Department. At the time of this investigation, I believe he was in the homicide squad. He is no longer in that unit. He's in a different unit now. He is one of the officers who was transferred. And if you remember from the beginning of the trial, we heard defense attorney John Carroll talk about how when this occurred on February 24th, 2023, there were 12 members of the homicide squad. 4 of them are left right now. So 4 of those original 12 in that unit are still there. And today we learned a lot about why some of those officers are no longer there. And it sounds a lot, you know, the defense was pushing the narrative that the reason so many of them are not there anymore is because they disagreed about the theory that the department as a whole was putting out there. I thought it was interesting, though, to hear him talking about it, and we saw it in some of the text that they showed on screen. You know, Lieutenant Giaio mentioned that his theory pretty early on was this catfishing theory. He says that Juliana's testimony only helped confirm what he already thought. So that kind of, in my thought process, it kind of didn't go along with what the defense was saying, because he's up there saying, I did think this originally. How about you?
Well, they're saying also that when Giaio disagreed with the Miller report. And the Miller report appears to be crucial because the Miller report suggests that, or concluded that Christine never lost dominion and control over her phone. And therefore, it was she corresponding with Ryan, not this catfishing. And, you know, I think the defense was trying to say, look, you're not an expert in this area. And Giaio kept on saying, look, I'm not an expert on extracting data. I'm not an expert on necessarily kind of compiling data. But and Giaio was like, my problem wasn't with the extraction or the data. My problem was with the analysis of the data, the conclusions that were reached. And I think the defense was like, well, who are you to be making a judgment on analysis of this data? You're not even that experienced in the area of homicide. You spent all your time in narcotics. And so, you know, there are questions that are being raised about some of the judgment calls that were made by the police. But ultimately, again, he came around and basically said, when she explained a lot of things in detail, we were able to corroborate through solid evidence a lot of what she says. So I think he kind of made up for some of the ground that may have been lost.
Yeah, and we heard defense attorney John Carroll trying to push on him, were you involved in the transfer of Detective Miller? And that has really been the theme the entire day, just a complete focus on Detective Miller and his digital forensics summary, which we have part of it here. And, you know, you mentioned some of it, how he said that Christine never lost control of her device. And we were discussing, what does control mean? You know, we all have iPhones. We have laptops that are connected to the iPhones. Can you access one while the other one is in someone else's hands? His data showed that during the time of the account creation of the Gmail account that was used to create that FetLife account, he says that it shows that she was chatting with Juliana via WhatsApp, which is a different app than the app they were supposedly using at this time. They're using Google, creating this Gmail account, if you will. And then, you know, what was interesting to me is that we have all this from the forensics data, but then we hear Lieutenant Giaio talking pretty at length about some of the evidence that came to light for them in terms of just the specifics. You know, he said they already knew a lot of the things, but then Juliana confirmed them for her. But we learned a little bit more about some of the forensics to the phone calls and how they had data showing that, you know, her story lined up with what she was saying. The example about the gym. Yeah,
exactly. I mean, I'm not a data person, but what he seemed to be saying is that her description of how she left the gym at the direction of Brenden and came back to the house matches with the forensic evidence of when these FetLife or Telegram communications setting up the sexual tryst occurred. So the fact that they can kind of cleave this together is, I think, helpful in painting the picture that the prosecution wants to paint, that this was a setup, an elaborately set up catfish.
Yeah. And, you know, we heard him, but also some of the other former officers that testified earlier today. John Bruce, he was the major crimes. He was one of the upper managements for the department at the time, and he talked about how he made a statement that I'm never going to allow Brendan Miller, Detective Brendan Miller, to analyze forensics for Major Crimes Bureau. You know, hearing that and then hearing this testimony, what's your thought process there?
I mean, it appears that all is not well in the Fairfax County Police Department when it comes to this case. In other words, people who seem to have reached the wrong conclusion are transferred. And it just looks like you get the sense that there was turmoil. You get the sense that there was debate within the police department. And whenever you have turmoil, whenever you have debate, whenever you have the suggestion that certain theories were being pushed, you have defense able to say, essentially, garbage in, garbage out. And that's what appears to be a major defense theme. You can't trust what conclusions you are hearing from the police and the prosecution.
I want to go back to the text messages. We saw a lot of text on screen. It seemed like simple conversation. You know, at points they were gloating a little bit about how I knew it all along, right?
Right.
How impactful do you think that is on the jury seeing those text messages? Or do you think they're just like, okay, cool, whatever?
I think that, look, text messages can be critical in a case, whether it's criminal, whether it's civil. People text things all the time, never realizing that what they're saying is somehow later going to come to the light of day. And it's persuasive precisely because it isn't manufactured for a particular purpose. It's just two people talking. So it seems in my mind that the jury would give some credence, some weight to what somebody is saying in a text message as things are happening. It's not lawyered, it's not manufactured, it's kind of what they're thinking at the moment. So I do think the text messages, are important. Now, Carol seemed to suggest that there was an independent obligation to turn over these text messages before the court ordered them turned over. And that obligation was essentially, if you're a prosecutor and you find evidence that you believe is sufficiently exculpatory, you don't wait for a court order. You have an obligation to turn that over to the defense. And if you don't do that, that is bad. Okay, so there's this suggestion that these text messages are things that should have been turned over independent of any judge order because they are exculpatory. Whether or not they rise to the level of being exculpatory under law and under Brady, I mean, I haven't analyzed these text messages in context.
We only saw them for a second.
Yeah, we only saw them for a second.
What was interesting to me, though, is that we did hear Lieutenant Giaio say, I've never, in my time here as a Fairfax County police officer, been told I had to turn over my text messages. So that was interesting, and I think it begs that question again of why were those text messages subpoenaed? Is that okay? And it sounds like, yeah, it's your government phone. Of course, the question being, was it a government phone? We don't know, but
it doesn't appear that they were subpoenaed. Okay, it appears that they were
told.
There was a defense request for these materials to be turned over, and that there was resistance to that request, and the court heard arguments and said, turn it over, government, and that's why they turned it over. Whether or not it's from their personal devices or from their government devices, I don't know, but it doesn't appear that these were subpoenaed. A lot of other subpoenas, I'm sure, went out for a lot of other pieces of evidence, but those text messages appear to have been produced per court order.
There's a word that we keep using, we keep hearing, and I'm sure it's going to come up again, and it's the word proffer. Can you just kind of summarize for people that don't know what that means?
I mean, typically what it means is if you're charged with a crime, like I've had cases where somebody's charged with a gun offense, for example, and the prosecutor says, I want to hear a proffer. In other words, I want you to sit down and tell me everything that happened with this particular case. I'll give you immunity. And I want to hear the truth about what happened. And I want to hear if you can tell me who gave you the gun and, where you bought it from, etc. And that's a proffer. And proffer is typically used by a prosecutor to decide whether or not to use the person's testimony, whether or not to allow them to plead to something that's a lesser offense from what they're charged. That's what a proffer is. It's proffering, it's offering, it's putting forth information that you have. And sometimes if the prosecutor thinks that you're lying, if the prosecutor thinks that you're spinning something in order to get a good deal, they might say, listen, counsel, your client is not being forthright. We don't have confidence in this. This is contradicted by evidence that we have independently. And so we're not going to accept this proffer as a basis for some lesser plea, for example.
The text that we were seeing on the screen, that was the conversation before they had decided whether or not they were going to offer that plea deal, right? Is that what you took away from that?
It appears that the text messages we were looking at were from Detective Giaio while the proffer was being made by Juliana. He's texting with another officer or texting with the people in the room about the content of her proffer. And I think the defense is using this to say, you're making observations about her. At one point, one of the text messages said, well, she doesn't sound crazy, but she's ice cold. I mean, they're characterizations that are being made of her real time by Giaio while she's giving the proffer. So, I mean, why an officer would be texting about these things while somebody is giving a proffer is surprising to me. It is not a prudent move.
It sounded like a lot of the people involved were in and out of the room. I do want to bring up one other thing that we keep hearing. And it's the name of the prosecutor who was formerly on the case. I know Matthew was telling us that Eric Klingon is in the courtroom. He's been watching this testimony. When you're listening to this and you're hearing, I believe the prosecutor today, she said, Eric was just there as the mouthpiece. You guys all came up with the questions. Do you think he's going to get called to testify?
Well, typically when you have a trial, you have something called the rule on witnesses. And that means that if somebody is potentially going to be on the witness stand, they can't be sitting there in the courtroom listening to what everyone has to say.
Right.
Why? Because you don't want them to manufacture or shade their testimony to match what they're hearing. You want to hear somebody come in and tell it as they remember it, okay? So the fact that the prosecutor is in the courtroom listening to all this, assuming they invoked the rule on witnesses at the beginning of this trial, suggests that he's not going to be a witness. Now, why isn't he going to be a witness? I don't have that depth of understanding of his particular role. But we just heard how he was the one who did the proffer, so he does seem to be relevant. So it's surprising to me that he's sitting in the courtroom in short.
All right, thank you so much, Paul. Thank you for being here with us today. We are going to be back into the courtroom momentarily. Again, we are going to be continuing to stream this live on WUSA 9+. And a reminder, there is court tomorrow as well, so make sure you're tuning in then. But let's take you back into the courtroom.
All right, your next witness,
Sally Fayez.
Sally Fayez.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
Got it, thank you. Hi. All right.
Good afternoon, Ms. Fayez.
Good afternoon.
I'm going to show you some text messages.
Judge, I would object the witness has not yet been identified.
Could you just have her?
Sorry. Can you please say your name and spell it for the court reporter?
Sure. Sally Fayez, SALYFAYEZ.
And if I ask you any questions that don't come out right or you don't understand, just please tell me and I'll repeat the question.
Absolutely.
Now, you're the head of the victim services for Fairfax County. Is that correct?
For the Fairfax County Police Department.
Okay, and in that role, do you fall within their command staff, I guess MAP?
I do.
Okay, and so who, can you describe for the ladies and gentlemen of the jury of your organization and how it fits within the police department?
Sure. So we are a civilian unit within the police department. We fall under the Major Crimes Bureau. So there's 4 divisions in the Major Crimes Bureau. There's the Violent Crimes Division, the Criminal Investigation Division, the Cyber and Forensic Division, which are all sworn staff, and then the Victim Services Division, which is my division.
And so, and how many people do you have working for you?
17, plus we have interns, but 17 employed.
Okay, and when you, when something like what happened in this case happens, how do you get involved?
So my office is located on the 6th floor, which is where the rest of the violent crime detectives are. So it's not uncommon that something happens and I'm automatically made aware of it, which is what happened that day.
Okay, and so you get a call or you get a text or something like that, and then you roll to wherever you need to be?
No, so the day of the murders, I was already up at headquarters, and so I either received a phone call or a message, I'm not sure, letting me know that Valerie and and Juliana were headed to headquarters, and did I have an advocate to sit with them?
I'm sorry, I didn't understand.
Did I have a victim advocate that could go sit with them?
Okay, and did you arrange for that?
Correct.
Okay. Now, at that point, is that victim advocate the victim advocate for them for the remainder of the case, or how does your organization work?
Yes, on homicides, the advocate that responds, usually respond to a scene, but in this instance, we responded to headquarters, so they would keep the case. There's 2 different families, so I assigned one advocate to one family and another advocate later on to Joe Ryan's family.
Okay. And how long have you been doing that?
Doing,
Your job?
I've been with the department for 23 years, so I was an advocate for 7 years, and I've been the director for 16.
And so, in terms of your interaction with the police department, what's your interaction on a daily basis if you're not otherwise responding to things?
I'm in command meetings, I'm in supervisor meetings, there's daily dialogue about cases. I'm obviously making sure that my unit is squared away and going where they need to go. If there's a call out, we have a text thread of who's going to respond to a call out. It's really just the day-to-day of supervising the division.
And the command staff meetings you talked about, who's attending those?
The command staff meetings are all majors and above, majors, deputy chiefs, assistant chiefs, and I believe captains.
And are you on a level of a deputy chief or a major? Or?
I would be considered the professional equivalent of a major.
Okay.
So I answer to a deputy chief.
And who during this time frame would you answer to?
To Deputy Chief Bruce at the time.
Okay.
Well, at the time of the murder, it would have been Deputy Chief Reef, Jeff Reef.
Okay. And I think timing-wise, Deputy Chief Bruce came in just after this incident, or he was actually a captain?
He was the captain
Okay.
during the incident, yes.
So you had interaction with him when he
The day
wasn't
of.
the deputy chief?
When he was the captain, yes.
Okay. And then when he was deputy chief, you answered to him?
Correct.
Okay. And so the command staff meetings, can you describe for the ladies and gentlemen of the jury what those are without any specifics?
It's just to ensure that the command team of the Fairfax County Police Department know what is going on within each of the subdivisions. It's really just a conversation of what's happening within the department of all of the rank and file.
Okay. I'm going to show you some text messages and ask you if you can identify them.
Okay.
This is marked as Defense Exhibit 92.
Okay.
Do you have any recollection of that?
From looking at it, but no.
Okay, no, nothing on the page stands out for you?
No. I mean, I see that was from 2024, but otherwise, no.
Okay. Is it common to have jail call recordings in your communications with Deputy Chief Bruce, and who would be the other person? Was that Lieutenant Giaio?
I only see myself and Deputy Chief Bruce on here.
Okay. Would that be a common occurrence, the jail calls from a case?
Yes. I mean, it's not that it's every day, but if you're asking, is that okay that a text message included a jail call? Yes.
Oh, no, I mean, I'm sure it's okay. I just was curious if that's just something that would be naturally flowing from your position and his position.
Yes.
Okay. And is that something that are you ever involved in listening to jail calls, or just when it's sent to you in this kind of format?
I have in the past, yes.
Okay, and in this case, have you done any listening of jail calls?
No.
Other than this?
No.
Okay, and so, it appears there's a conversation going on What's the nature of that conversation?
There's several conversations going on. Which one are you referring to?
Actually, let me just, if I can just pause for 1 second. Your Honor, I move this in as defense exhibit number 92.
Any objection?
Judge, I think the witness testified that she doesn't recognize it.
All right, you want to lay a foundation?
In terms of your communications with Deputy Chief Bruce, would text messages be a common way that you would communicate?
Absolutely. I think that's the common way to communicate with most people.
And so, other than personal communications, would text messages, including jail calls or other discussions about perhaps defendants, would that be something that you would talk about?
Yes.
Okay. And in this case, is that what that looks like?
Without knowing what that call was, no.
Okay.
I wouldn't know.
What about the next statements regarding that?
Again, unfortunately, since it was 2024, there's not a lot of context of what this is for me to know.
And so you're based upon what you know right there, you're saying you're not certain that this was a communication that you had made?
Well, I obviously made it because my name is in there, but I really don't remember that specific text message.
And I think that's
But I'm not
understandable.
saying I did not do it.
That's certainly understandable with text messages. Your Honor, I'd move that in as Defense Exhibit 92.
Judge, I wouldn't object to its admission at this point, but obviously the witness's testimony would be limited by her
Well,
recollection.
I understand that, but as far as admissibility, 92 is an evidence. You want to publish?
Now, down the page of this message, I'll point to this. What are you saying there, and does that indicate that somebody else is in that message?
Giaio, Lieutenant Giaio.
Okay. Does that help you remember any of this?
No.
Would it be common for you, Deputy Chief Bruce and Lieutenant Giaio, be on a three-way text?
Yes, I've been on text messages with deputy chiefs and supervisors in the past.
Okay. And these are the kind of things that you discuss when you're talking to those two?
Well, if I'm reminding Lieutenant Giaio to ask people to do something, yes.
Okay. And how about talking about things like arresting him will put him over?
Again, I'm sure we have in the past. I just don't know the context of this.
Okay. Ma'am, I'm going to ask you to review what has been marked as Defense Exhibit number 94. Do you remember that?
I do.
Okay, and what's the significance of the date in remembering that?
Friday, October 25th,
Yes.
the arrest of Brendan Banfield. Is that what you're asking me?
No, I don't think, well, let me just do this, and then we can talk about it. Your Honor, I'd like to enter this as Defense Exhibit 94.
Any objection?
No, Judge.
94.
It appears it's a conversation with Deputy Chief Bruce, and it's relating to some message that the chief had written.
Yes.
And do you know what the significance of that is?
I believe after Juliana's proffer.
Okay. And you knew that to be October 25th, correct?
I only see it at the top of the text message.
But did you know that to be October 25th?
Not that I would have recalled, no.
Okay. And in this text message, You're talking about not taking no for an answer, correct?
Correct.
And what's that relating to?
It appears to say not taking no for an answer, so we're all grabbing a drink next week.
Okay, and do you know the context of that?
Probably just saying we're all going to grab a drink next week.
Okay, but not anything with regard to the case?
No, not that I would read from that.
Okay. Ma'am, I'm going to have you look at what has been marked as Defense Exhibit 98. Do you recognize that?
I don't recognize the text message, no.
Okay. Are you involved in that text message?
By looking at it, I can't say yes or no.
Okay, you don't see, okay, I'll withdraw that. Ma'am, I'm going to have you look at what's been identified as Exhibit 99. Do you recognize that?
No, I don't.
Are you not part of that?
It doesn't appear so, so I would know if I was.
And you don't have any independent memory of it?
No, I don't.
Okay, I'll withdraw that. Ma'am, this is Defendant's Exhibit 106. Do you recognize that?
I do.
Okay. Is that a text that you were involved with?
Yes.
And just for the sake of identifying people, which color were you on that? Gray or blue?
Gray.
Okay.
Your Honor, I'd move that in as Commonwealth's Exhibit 106.
Judge objected to, that was not identified by whoever the other party is in the email.
That's correct. The other witness said they didn't recall, so I have to sustain the objection to 106. Ma'am, I'm going to ask you to review what has been marked as Defense Exhibit 107. Do you recall that text message? Or can you identify that text message?
Identify it as in,
As a message you sent or as a message you were part of?
my name is up top, so I would say that it was from me.
Okay, do you know who you were communicating with?
Not just by looking at it, no.
Your Honor, I'd move that in as Defense Exhibit 107.
Judge, we do object.
The objection.
Again, it calls for hearsay. Ms. Baez is the person who was the recipient. She cannot identify who the communicator was.
And I believe the other witness said it wasn't him. So I have to sustain the objection to 107.
Very well, Your Honor. Now, ma'am, when you're in the command staff meetings, what kind of role do you have in those meetings?
My role really is to make sure that the victims and the survivors are a part of the conversation.
Okay, and so are you giving updates on things, or how do you engage with the command staff, the police command staff?
I think it really just depends. Are you talking about in this instant, or are you just talking about in general?
Generally.
I think it just depends on what the case is about. Sometimes if we have a case where a case went to court, then we would update the command staff on what happened with the verdict. If there's a case where we believe the family needed some awareness when there comes to a public affairs bureau release, we work directly with our public affairs bureau command staff to make sure that families are notified in a dignified way that something's going to be released.
Now, specifically with regard to this case, were you ever involved in the theory of catfishing?
Yes.
Did you suggest catfishing?
I did not suggest catfishing. I suggested that it be proven that it's not catfishing.
And when in time was that in relation to the killing of Christine Banfield?
I think as time went on, it became apparent that that was a possibility. And so are you asking when I started to think it, or?
Well, where did this theory come from? Were you the one who started it?
Did I start the theory? No.
Okay, when did the theory become a discussion topic in context of the time that the...
I think throughout the investigation, depending on what meeting you were in.
How soon after the killing of Christine Banfield did that come up, is what I'm asking.
I think it came up once they were in a hotel and our intel detectives heard her call, ask if she could call her mommy.
I'm sorry,
I think there were things that came out a couple of days after the murder that made people question whether this was a catfish or not.
Okay, so within days after the murder.
Correct.
Did you believe that it was a catfish?
I didn't believe that it wasn't one, but it was on the table that it could have been, absolutely.
Okay, and was that something that you discussed in command staff meetings?
I think that evidence and investigative avenues were discussed, but the actual word catfish, no, until later.
So was it discussed in terms of assuming someone's identity, or how would it have been discussed in those meetings before saying catfish?
I think it would have been discussed as, has everything been done to prove one way or the other? Was this a setup or was it not?
And is that something you were bringing to the table, or is this something that...
I think it was a group discussion.
A group discussion? Okay. And so within days, the discussion turned to catfishing? And that's
Not within days, no.
Oh, I'm sorry.
My view, within probably a few days, was a question of what really went on.
So in your mind, within a few days, catfishing was a possibility?
A possibility, yes.
And did you communicate that possibility to the people that were in the command staff meetings?
I'm sure we all were having the same conversations because I wasn't the only one that thought that.
I mean, is that something that you would oftentimes talk about in these cases?
Yes. Well, I don't think we've had a case like this, but I would have a conversation about the case that's being presented, absolutely.
Okay, well, I guess for purposes of your memory, would there be other times? I mean, if this is a pretty big case, and if you had suggested catfishing, that would be memorable.
I think you're confused as far as what I did. Whether I thought it was or not, it's not that I suggested it. There were meetings where plenty of people above me that believed the same thing. It wasn't just a Sally catfish, if that's what you're asking.
No, I'm not. I'm trying to get an idea of when you started talking about it as catfish. And I think you'd said you thought about it within a few days, but when did it become a viable theory to talk about in the command staff meetings?
I think you're confusing command staff meetings. What meetings are you referring to?
The ones that you just described where you're with command staff.
Those are different meetings than just a normal meeting talking about cases in the Major Crimes Bureau.
We'll talk about the normal meetings. In the command staff meetings, when was it that you started talking about catfishing?
Well, it was never discussed in an actual command staff meeting because that's the entire command staff, so it wasn't discussed then.
Okay. Were there breakouts?
Move that. I'm sorry.
Were there breakout meetings of the people that were involved? I'm just trying to understand where we're going.
And I'm trying to understand where you're going. I'm sorry, I really don't know what you're asking me.
So the only meetings that we've talked about at this point were command staff meetings that you said that you're involved with as one of the command staff personnel, correct?
Correct.
Okay. And what I'm trying to get to is when was it that catfishing was a theory amongst the meetings that you were attending, whether they're command staff or other meetings, whatever meetings you're attending?
Again, I think they're ongoing. There's meetings on that floor between the supervisors and the commanders on that floor. That's a different meeting than a command staff meeting.
It's not so important in my question as to what kind of a meeting it is. What my question's really directed to is, when did you start adopting that and talking about this in meetings?
I don't have an actual date for you.
When was it in comparison to the returns on DNA, digital forensics, fingerprints, anything like that?
I think what happened is every single time some piece of evidence came forward that made you question what really happened, then that theory would come back up.
Okay, and do you know the time frame on that?
No, I don't.
Would it be a year?
Again, I think when you have an investigation like this, there's constantly meetings, there's constant conversations about it. So there were times where, hey, could it have been this? Are you looking at this? Versus talking about some other angle.
Okay, would it have been a month after the incident?
Judge asked and answered.
Sustained. And if you could move the microphone a little closer to you, Mr. Carroll. Thank you.
So you don't remember when you would have talked about catfishing in a meeting?
The actual word catfish, no, I wouldn't remember that. I can remember when questions would come up about what happened that day.
Okay,
Yes.
and maybe it's my terminology that's a problem. When was it in meetings that you talked about the theory of what happened that day in the meetings?
It wasn't necessarily me starting those meetings saying that. It would be a meeting for an update on the case or what was going on with the case. And so everybody was having that kind of conversation. It was kind of a give and take.
Okay.
Which is normal in these kind of situations.
Sure, I'm just trying to understand. And so it wasn't, catfishing wasn't a comment, or wasn't a name that it was given, but there were issues regarding the investigation. Is that what you're saying?
Correct.
Okay. And so, and I understand you're saying it evolves into something. When was it that catfishing was brought up as the?
Objection asked and answered.
Sustained. Next
You
question.
don't know?
Next question.
Okay. On the day of the incident, were you involved with Brenden and Christine's daughter being brought to the safe spot?
What do you mean?
To be, it was in a place where an interview took place?
No.
Okay. Were you involved with any sort of discussion about trying to detain my client?
I'm sorry, repeat the question.
Were you involved on the day of the killing? Were you involved with anyone trying to detain my client at that point?
No.
Were you at the headquarters during the
I was, yes.
And were you in the presence of Juliana or Valerie?
Juliana and Valerie were in one of our waiting areas where we have a victim waiting room with the advocate, not me.
Okay. And did you have any say in any sort of interviews of Juliana or the child?
No.
While they were waiting there? Did those occur?
Not that I remember, but I wasn't there for that.
Okay. Was there any concern from you and the people that you work with about my client being released at that
Judge,
time?
objection calls for speculation. She can speak as to what was in her mind, but asking about others.
Rephrase the question.
What, if anything, did you, what, if anything, were you worried about with my client being released that day?
Valerie's safety.
And did you do anything to further that worry that you've just told for the ladies and gentlemen of the jury?
Yes, I had received a call from Captain Bruce and Lieutenant Weeks, who was the homicide supervisor, and they were on the scene, and the concern was
Okay.
that he
Your
would
Honor,
not.
just, that's not responsive to my question, but
You asked her what she did.
and she talked about a phone call.
Okay, all right. well,
What did you do?
I ended up getting a hotel for everybody, so they would all be in one hotel together.
Okay. And including my client?
Correct,
Okay.
and Juliana.
And at any point in that process, did you discuss detaining my client?
No, I have no authority to ask anyone to detain.
I understand, but you have the ability to discuss.
Objection argumentative.
Do you have the ability to discuss that with the police?
No.
So in terms of where you're concerned, you can't communicate to the police your concerns?
I absolutely can.
Okay, and in this case, did you?
I don't understand the question.
Did you discuss your concerns with the police on the day of the incident?
But what concerns are you talking about?
About my client being left out?
Again, I don't understand the question. I want to answer it, I just don't understand it.
Okay, and that's the case with some of my questions, so let me see if I can get it straight. The question of my client being detained or being released, was that a worry for you?
At the time, your client wasn't even in headquarters.
So you didn't have anything to judge that by?
No.
Okay. Did there come a time where you were concerned and you wanted him to be detained?
No.
So there's no communications between you and the police about that?
If I can go back to my conversation with Captain Bruce and Lieutenant Weeks, was where I was going with that.
Well, let's just stay with what we're doing right now. I'm talking about your concern about my client being detained, and I think you've answered that you had no concern at that time, correct?
No, it just wasn't an issue at the time.
Okay, when did it become an issue for you?
It never became an issue.
Okay, so it never really came up in terms of trying to detain him?
No, not
Okay.
that day, no.
Okay,
If that's what you're asking.
Yeah, that day.
Okay, no.
Now, do you know how long it was before he was reunited with his daughter Valerie that day?
I don't know. I know when I went to get everybody a hotel and they were together then.
Okay, and how long after the incident was that?
I wouldn't know the time.
Was it the same day?
It was the same day.
Okay. And were you, so you arranged the hotel so the family could stay outside of the home?
Correct.
And is that normal for your position when there's a crime scene, an active crime scene?
Yes.
Okay. And is it normal for there to be surveillance going on in a hotel like that?
I can't answer that. That's not my wheelhouse.
Okay, so you didn't have anything to do with
No.
having surveillance?
No.
Okay. Court's indulgence.
All right, yes, sir.
Your Honor, I don't have any further questions.
Cross-examination?
Thank you.
Yes, ma'am.
Good afternoon.
Good afternoon.
Just briefly, can you explain what it was that raised the question of Christine Banfield having been set up?
Repeat the question, I'm sorry.
Sure. What was it, so Mr. Carroll went through with you repeatedly about when did catfishing become a topic of conversation? My question was one you were asked, but we're not able to finish answering. What was it that happened that raised in your mind the question of Christine having been set up?
At the hotel. So from my understanding, we had an intel detective in the lobby of the hotel that we had everybody in, and she had asked Juliana, can I call you mommy now?
When you say she, who are we
I'm
talking
sorry,
about?
Valerie. Said, "Can I-"
Valerie, Christine's daughter?
Yes, said, can I call you mommy now? Juliana, again, I don't remember her answer, she said yes. And then she said, are you gonna marry my daddy? And Juliana said, I wish.
Okay, thank you. I don't
Sure.
have any other questions, Judge.
All right, redirect. Or is this witness subject to recall? All right, you're free to go, ma'am. Thank you. Your next witness?
Call Detective Miller.
Detective Miller again?
Yes.
All right, Detective Miller? He's already under oath.
Bear with me, Detective Miller. Sir, you had an opportunity to listen to some of the witnesses today, specifically Lieutenant Giaio, correct?
Yes.
Okay. And he indicated that he reviewed the digital forensics in this case, correct?
I believe he said not in its entirety.
Okay. Well, in his testimony, what did you hear him say?
That he reviewed things with me.
Okay. And the things that he reviewed, do you have any idea what those were?
Off the top of my head, no, there was a large amount of data in this case.
Okay. And in fact, you extracted nearly 60 devices, correct?
It was a large number of devices, yes.
You don't remember whether it was 60 or not?
It was in that neighborhood.
Okay. And so whatever data that you had extracted that you chose to share with him, would that have been the raw data that you extracted?
I believe everything provided was in report form.
Okay. So he didn't get into the level of detail that you get into in your analysis?
I would not imagine so. I don't recall raw data specifically.
Well, let me ask you this. You heard him testify. Did he ever sit down with you and ask you to go through your work?
Judge, at this point in time, I would object. I believe counsel is trying to impeach his own witness, Detective Giaio, with this witness.
I'm not sure, but I'll overrule the objection for now.
Okay.
We'll see where we go.
Could you ask the question again, please?
Did you ever sit down with Detective Giaio and explain your work that resulted in the executive summary?
I don't recall if I did it in its entirety.
Okay. Can you tell the ladies and gentlemen of the jury of the times that you did it? What were you telling him and showing him, and how he arrived at conclusions?
Well, again, it's a summary, and I believe at the top of it, it qualifies that it's not every artifact involved in this case. So there would be times we would go over aspects that there were questions about.
Okay, and did you ever agree with the things that he was saying about it?
Your Honor, objection, it's vague.
All right, if you want to rephrase it.
Yes. Did you ever agree with his conclusions relating to your work?
Objection again, Judge, still vague. There were so many conclusions we've heard testified to.
Give more
Okay.
specifics.
Say, for example, on January 9th of 2023, the analysis of the opening of the email account. You know what I'm talking about?
Yes, sir.
Okay, and did you go into your conclusions and how you arrived there with him in any of those meetings?
Yes, I went through the devices that were involved based on the data extractions and the warrant returns, et cetera.
Okay, and I know you did because you made the decisions, but I'm asking, did you go through that with Lieutenant Giaio on that specific day?
I believe that was one of the items we went over.
Okay, and was that something that he agreed with you on?
There was heavy discussion about being able to attribute activity to a particular person. And I believe I stated that in this field, barring external corroboration, it is difficult to attribute activity to a person. But given that devices were known to travel with somebody, it's logical to look for aspects where dominion and control may have been lost.
Okay, and in discussing that with him, did you find that at that time?
Objection as to form, Judge, find what?
That the devices, I'm sorry,
Okay, that's fine.
did you find what you just described, that the devices were separate from the person during the January 9th?
Again, without external corroboration, I can't determine the actual person behind the device.
Okay, I understand that, but your findings were that there's no evidence.
Objection asked and answered. He just indicated that he could not find.
Objection, next question.
In terms of that specific day, did Lieutenant Giaio end up agreeing with your conclusions?
I would say that there was disagreement over the way I had phrased the document.
The way you phrased it? Okay.
Yes, I'm sorry.
And so not relating to your analysis of the data, am I to understand that?
Can you clarify your question? I'm a little confused.
I'm just following up on your previous answer, and I'm trying to clarify the meeting between you and Lieutenant Giaio relating to the January 9th, 2003 artifacts.
Judge, that's not a question. Objection.
You could phrase it as a question.
Yes. Just what I said. Did he agree with you as to those artifacts on that day?
An objection asked and answered. The witness testified that there was a disagreement over the way the document phrased.
Objection, if you can answer it, that's fine.
I would have the same answer. There were disagreements over the way that I had written that document.
Okay, so on that particular portion of that document, there were disagreements. And my question, I think, that started this all was that relating to the data that you extracted and interpreted, or the characterization of it?
Again, I would say the disagreement was over what was on the paper.
Okay. And so when, in terms of that specific section, was there agreement at any point between the two of you?
There were a lot of things on that document, even on that day, like as far as what the devices were doing, I think we were all in agreement the devices were doing what the devices were doing.
Right. But he wasn't in agreement with your conclusions.
Judge asked and answered.
Sustained. Next question, please.
I appreciate, Judge. I'm not sure that it was.
It was asked and answered, sustained.
Okay. So let's move on to another day that was a crucial day in this catfishing, January 23rd.
Objection to counsel's testifying.
Okay. How about January 23rd? Did you do an analysis of the devices on that day?
I am trying to recall the specific devices done on that day. Again, there were a lot of devices processed on a large number of days.
Do you have your reports with you?
I believe they're...
Is it all right, Judge, if he can retrieve that?
I think it's on the front. They're on the front.
Thank you. January 23rd, what year, sir?
2023.
20. I'm sorry, was the question a device that I processed on that date?
Yes.
January 2023 would
No,
have
I'm
been prior
sorry.
to the
It would have
homicide.
been the artifacts relating to that date.
Do you know which device in particular? I mean, there are a lot of devices.
So I guess as a guide, I was trying to break it down as to specific days, but we can use your executive summary if you'd like to and then go through it that way. Do you have that available to you?
Yes, I have it here.
Okay. I'm just pulling it up. court's indulgence for 1 moment. Do you have that handy, Mr. Detective Miller?
I have one in front of me, yes.
Okay. So let me ask you this. In terms of all the devices in this investigation, did you image all of those?
I extracted data from all the devices, yes.
Okay. And is that essentially imaging, or am I using the wrong term?
Imaging would imply a, depending on the circumstance, a bit for bit copy.
Okay. And in your extraction, did you extract all of the devices in what you deem a forensically sound manner, consistent with your training and best practices?
Yes.
Did you process the extracted data using forensically approved and verified tools?
Yes.
Listening to the testimony before, Lieutenant Giaio testified that he received data extractions from you. Is that correct?
I don't recall his exact phrasing.
I'm sorry, I didn't hear what you last.
I don't recall the exact phrasing of his answer.
Okay. Did you ever give him data extractions that came from you?
Data was provided, no portable cases and Cellbrite reader reports. A lot of data was provided to a lot of people in this case.
Okay, specifically based on what Detective or Lieutenant Giaio said. Do you remember what you had given him?
Not specifically.
And I think in the previous testimony, you had testified that you'd given your data extractions to the lead homicide detective, correct?
Yes.
And is that just part of the routine of making sure he has the full case?
Yes, it's important to pass the data on.
And did you provide data to Lieutenant Giaio and the detectives in the form of a magnet portable case?
Yes.
And/or Cellbrite reader formats?
Yes.
Okay. Did those productions contain the same data you extracted from the respective devices and reviewed during your analysis on this case?
I believe so.
So I'm going to try to show you something here. Sir, do you see something on your screen?
I do.
Okay. Are those examples of the data that you provided to Lieutenant Giaio?
There's screen captures and what appear to be a Word document that appear to have come from those, yes.
Okay. And
Judge, I apologize, it's probably just me, but is there any way we can zoom? I can't read a single word on the page.
Can you zoom that a little?
Let me see if I can do that.
There you go.
Much better, thank
A
you.
little better?
Yes.
Yes, thank you.
Okay. Sir, what is this?
This appears to be a screen capture from a portable case in a Word document.
Okay, are these the things that you provided to the lead detective and Lieutenant Giaio?
These screen captures?
Or what these screen captures contain?
All portable cases and reports generated in this case were provided to Detective Bryant and others.
Okay. And do you know, were these same items provided in discovery? I'm just scrolling down.
I believe they were.
I'm just going to continue scrolling down so you see them. All of those items? These are all the devices that you went through?
I don't believe it's all of them, but these are devices I went through, yes.
Okay, and are those devices that you provided to Detective Bryant and I guess based on his testimony, Lieutenant Giaio?
Yes, these were provided to Detective Bryant.
Okay, but were these the things that you gave to Lieutenant Giaio?
I believe he had access to all of them.
Okay, so you didn't actually give them to him, he just had access as supervisor?
I don't recall what I provided him directly.
Okay. Okay, so he had access, you don't know if you provided it?
Judge asked and answered.
Sustain.
Your Honor, court's indulgence for one moment. Do you have the portable cases for these with you?
I do not.
Where do they reside now?
Right now, I believe they're on hard drives back at headquarters.
Okay. And would you have access to those in order to move them into evidence?
Right now? No.
Or in the future?
I have access.
Objection. I'm not sure.
Everyone approach.
Thank you.
Aaron, you see that on the screen?
Yes.
Sir, can you identify those? Or can you see them?
You might have to make it a little bigger. Or maybe you can identify it as it is, I'm not sure.
This appears to be a screen capture of messages from one of the reports.
Okay. And are you familiar with the data that went into this screen capture?
Is in the data extracted from the device? Yes.
Okay. And what, if anything, do you see in this series of communications?
I see an item number titled Christine phone, and then I see messages below that.
Okay, and this is what date? Sorry. What day is identified in this?
January 9th,
Okay.
2023.
And is that one of the important days in this case?
Yes.
Okay, what's the significance of January 9th?
That was the day the Gmail account was created.
Okay, and do you, what can you conclude by looking at this screenshot?
That messages were sent using this device.
And can you identify who the other device is?
I see a phone number.
Do you know that from your analysis of this case?
Not off the top of my head.
Do you know who was on WhatsApp of the people that were using devices in this case?
Multiple people were using WhatsApp.
Do you know who? Other than Christine, who else communicated with WhatsApp with her?
Juliana.
Okay. In this situation, do you have any conclusions as to who Christine is communicating with?
Objection asked and answered. He indicated he doesn't remember the phone number.
Overruled.
In context, it would appear to be Juliana.
Okay.
And just for the record, I believe you had marked that prior to as defendant's 86.
86. Okay. Thank you, Your Honor. Your Honor, do you see anything on the screen?
If you'd like your expert to help you.
Sir, do you see something on the screen?
Yes.
Okay. Can you identify the communication that you see there?
It appears to be Facebook messages.
And what, have you seen these in your own independent investigation?
I would imagine at some point in the last almost 3 years.
Okay. And when you were looking at these, specifically these, what actually, let me have you look at. What is that?
Looks like a screen capture of details and artifact information.
And how would you extract an artifact like that?
A single artifact?
This particular artifact.
Well, the device would have had data extracted from it, and then that would have been put into a tool.
And this particular artifact, what can you gain from that?
Just what's on the page right now.
That, so can you go through that?
Objection. Who's asking for the witness to testify to the document if he wishes to admit it? That would be the first step.
Your Honor, I'd move to admit this
Do you have a number for me?
as, I do have a number.
The 109, I guess, if that's what you want to do.
109.
Any objection to 109?
Yes, Judge, relevance.
Overruled, I'll allow 109 in evidence.
And Judge, if I may, it's a document from 2021, and we don't know who it's purported to be between.
I overruled the objection, 109 in evidence.
Thank you.
Look now, okay, no. So what number is this one then?
I had this one as 86.
I just want to make sure I get the record clear.
Yeah, why don't we do this, if we can, Judge? Can we make this one 109?
Okay.
And the other one
10?
110?
All right, so 110, subtraction. This is 109. Any objection to 109?
Same objection.
All right, overruled, 109 in evidence. Okay. I think we're
So-
on the same page now.
Sir, do you see the connection between the communications here and the extractions? And I can go to the next page.
Again, these are screen captures from what I would assume would be a portable case, but I don't have the whole thing here.
Okay. And that's 110?
110.
And what do you see there?
Details of artifact information.
Now, when you, do you see the, what appears to be a conversation going on?
Would this be 111 then?
111.
Okay.
Yes, I see messages.
And in terms of the messages, what's the, are any of the devices that you had extracted present on these communications?
I'm sorry, can you ask the question again?
Are any of the devices that you extracted data from present on these communications?
I see an item number and a label.
And are you talking about the yellow or the blue?
The blue, where it says local user.
Okay, and the label on that?
It has an item number and says Christine phone.
Now, did you hear testimony regarding windows today or even days before?
I recall windows being mentioned.
Okay. And in this communication, in your expert opinion, can you conclude a date as to the communication?
Judge, I'm going to object to the witness testifying as to the contents of the
Do
document.
you wish to have this in evidence?
Yes.
Any objection?
Judge, I would object. It's hearsay. We do not have the speaker testifying.
111, Your Honor. This would be for, as an extraction that he's identified.
I understand, but there's still hearsay in it is what the objection is.
Well, Your Honor, I would say that this is an extraction through digital forensics, through sound principles, which he's testified to.
Right, I understand that, but inside that, there is hearsay. So I'll sustain the objection as to the hearsay.
Okay. Sir, do you see what is described as a discussion about windows?
I do.
And when does that take place?
Judge, same objection.
He hasn't moved it in yet.
Correct.
I'll allow that question.
I'm sorry, repeat the question.
Again, Judge, the objection is to the witness testifying as to the contents of the document.
I understand, I'll allow that question.
What date is the, oh, it just went out. I think I have a power issue.
Can you use another computer?
Is yours? The win. Sir, the question was, before we lost power, the date that these communications were taking place?
And Judge, to clarify the objection, he's asking for information contained within the document, which is hearsay. If he's asking about the date they're extracted,
Allow
yes.
the date. Your objection is overruled.
Okay, thank you.
6/28/2022.
Would this be 113 then?
113.
Okay.
Sir, based upon your extractions, based upon the information that you looked at from Christine's phone, do you recall this?
I don't recall doing a dive specifically into Windows.
Into the specific topic of Windows?
Windows came up much later in the investigation.
Okay. And so when the Windows came up was during the initial recant in October, correct?
Yes,
Was that the first time you'd heard about Windows?
I believe so.
Had you been involved, would you have been in a position to advise whomever was there as to what the content was on her phone?
Possibly.
Okay. Were you ever asked about it?
I think later on, Windows came up. I can't recall the exact artifacts that I looked at, though.
And they came up because, well, let me ask you this. Did they come up because they were taken, the orders and things like that were taken off of my client's laptop?
I recall conversations with Detective Bryant about Windows that came up later in the investigation.
Okay, and did you do anything to determine whether that was what Juliana Peres Magalhães had said was true relating to the artifacts that you looked at?
I don't recall specific artifacts that I looked at relating to that.
If you had been involved when she first said that, or been in the room, would that have been an opportunity to inform the questioner?
Judge, objection is to form. I don't think it's clear, inform the objectioner as to what.
Okay. In the room when the recant on October 25th, if you had been in the room, would you have had the ability to inform any questioner as to what the specifics of the window purchases were?
I don't think at that time I would have been prepared to do that.
If you had heard that for the first time, as many did, would you have been able to track that down?
Judge, I object to the form of the question. What is that?
Would you have been able to track down information relating to the window purchase?
Yes.
And what would it take in order for you to confirm or deny what she was saying in the recant?
Going through the devices, keyword searches, things like that.
Okay. And in this instance, do you see the writing on the screen?
I do.
I think that would be 113, Your Honor.
Yes, 113.
Is that what was done in this situation?
I don't recall making this screen capture.
Can you look at it and tell whether or not that's a search for Windows?
I could assume it is, but since I didn't create the screen capture, I don't know definitively how that came to be.
Sir, can you see the communication with what it says is Christine's phone on December 3rd, 2022?
Yes.
And the communication?
Judge, objection is to form.
I'll sustain the objection as a
Okay.
form.
What does this artifact indicate to you?
And for the record, that's 115.
115.
Okay.
Again, it's a screen capture of artifact information. It says summary windows, which is highlighted in yellow.
And is that indicative of a search for windows?
Again, I didn't create the screen capture, so I can't state how that came to be there.
Well, in terms of the standards that you live up to as an expert in digital forensics, is this something that you would require of yourself if you're doing a screen grab?
Objection is to form is what something he would require of himself.
The item that's on 115?
The artifact information here?
Yes.
When going through artifacts, yes, I would look at a breakdown of the data surrounding it.
And what can you opine about what you see there?
That it's a screen capture with a summary of windows. There's an email address associated with the calendar. Time zone is UTC. It's a calendar event.
And do you recognize the email that's being used?
I do.
Okay. And what email is that?
cbanfieldrn@gmail.com.
Okay. And is that her email, her personal email? as far
Objection,
as you
Judge,
know?
is that whose email?
Is that Christine Banfield's email?
Yes.
Your Honor, I'd move into evidence. Sorry. Defense exhibits 110, 115.
110 is already in evidence.
One-
111 was.
110 is admitted, 111 was already offered and
Offered
denied.
and sustained, yes, the objection was sustained. So we're up to, you want 115, which
Yes,
is
Your
the
Honor.
last artifact.
Yes, 115.
115, no objection. 114, objection. Hearsay.
He only offered 115.
Oh, I thought he said 110 through.
I initially said that.
Okay, so 115 is in evidence. We can go there. All right, now, do you want 112? Are you looking for the other ones as well?
Yes, Your Honor.
All right, let's go to 112. I just got to get it on the screen. Can you get 112 on the screen for me? Because I believe that's 109, 110, 111. That's 112.
112.
112.
Objection, hearsay.
All right, the objection's hearsay.
Your Honor, I would, may we approach? Sure.
stay in 112 as hearsay. Okay.
Sir, do you recognize the data from this particular slide, slide 1?
For the record, we'll mark that as 116. Okay.
116.
It appears to be a screenshot of the CPRN920gmail.com.
And what's the date?
January 9th, 2023.
Yes. Now, what are the 3 entries there as best you can tell?
They just appear to be potentially emails with subject lines. One of them is blank.
And the other?
One says pics, the other says pics 2.
And is this the email account that's alleged to have been created by someone other than Christine Banfield?
Yes.
Based upon your investigation? And what is this that you see here?
Screen capture of what appear to be logins with IP addresses and dates.
Okay. And do you, specifically January 9th, do you see that login?
I do.
And what does that indicate to you, and what device does that indicate is logging in?
Looks like a Samsung SMG 991U with Android 13.
And do you know whose device has that identifying characteristic?
If memory serves, 2 devices have that pedigree.
Have SMG991U?
If memory serves, Mr. Banfield's IRS phone also has that same, it's the same model number.
And that was 117.
117.
And now this is 118?
118.
Okay. This would be.
Sorry, Judge.
Is that 119 now?
Yes.
Oh, you went back to 118.
I went back to 118.
Okay,
I think I hit 119.
All right, that's fine. 118.
Detective Miller, what do you see here in this slide?
Again, screen capture with IP addresses with what appears to be login information.
And is there anything you can get from that login information?
The user agent is on the right.
And how is that being logged in?
With a Windows device.
Can you tell whether that's a phone or a laptop based upon what you see there?
From what I see there, it would be a laptop or a computer running Windows.
Okay. Let's look at 119. Oops. Can you identify what that is?
I'm sorry, Judge, I can't even begin.
I don't know if you can make that a little bigger, maybe, so you could see some of it.
I'll give that.
There you go.
We'll just look down the center column.
Okay.
Can you see that, sir?
Yes.
And what does it show? What does it indicate to you?
Again, it appears to be a screen capture with emails and artifacts.
And is there anything there that can identify what device was being used?
Not that I'm picking up from the screen capture immediately.
And is it any information that you can look at that can identify what device is being used?
Judge, I think asked and answered.
The same question you just asked.
Okay. Or what, how the, what email is being used?
I see the email address of cbrn920@gmail.com.
Okay. And what do these appear to be to you?
Email records.
Communications? And who are they from?
I see a lot of FetLife, and then, oh, they moved.
Oh, sorry, were you still looking at that? I was trying to give you something else to look at.
Nope, that's fine, we can.
Do you want to scroll down?
If you would like to. Yes, I see FetLife.
And FetLife?
Yes, FetLife.
And more FetLife? Can you tell from the screenshot whether these, so are you satisfied that they're all FetLife, just based on scrolling around?
Objection, I think that's a mischaracterization of the evidence.
I'll allow the question to be answered.
I can see what's in the screen capture, but again, I did not create the screen capture.
Okay. But if you were trying to create a screen capture from digital forensics, this would be the form in which it would come?
It could be, depends on what I'm trying to take a capture of.
Is there a way for you to determine whether these are still active or they've been deleted, anything like that?
From this screen capture?
Yes. I can move it if you need me to.
I'm not seeing a deletion marker in this.
I'm sorry, what? The location marker?
You asked if I could tell if something was deleted from what I'm looking at.
Yes. Do you need me to move it to someplace where you could tell on this screen grab?
I don't think this screen capture has everything in its entirety.
What makes you say that?
If you scroll back up to the top. So if I were looking at it, like in a portable case or in actual Axiom or something like that, I would be able to see all of the data fields, but since I didn't create this screen capture, I don't recall if there's any data fields beyond what was taken in the screen capture.
What kind of data fields would you include in your screen capture?
What was relevant, and if there were specific artifacts, I would try to tag them when appropriate or make them known.
And in terms of the FetLife account in this case, what would be relevant for categories for a screenshot?
I mean, I would want to look at everything.
What more than what's here?
Again, I don't recall off the top of my head what other fields would be on that. And again, this is a screen capture that I didn't create.
Okay, but if you could create any screen capture, what more would you want?
Objection asked and answered. He said he doesn't know what other fields would have been available.
That's what he stated. I'll sustain the objection. Next
Okay.
one.
And in terms of dates and times, things like that, can you opine about those?
I see dates and times.
And do you recognize a range of dates?
They don't appear to be in chronological order. I see that they're jumping around.
Would these be maintenance records relating to the FetLife account?
Maintenance records?
Yes.
I'm not sure I follow.
Would these be maintenance emails and communications?
They appear to be incoming communications from FetLife.
Okay, from FetLife to cbrn920@gmail.com?
Yes.
And what, if anything, does that indicate to you?
That email address was receiving communication from FetLife.
Your Honor, I'd move, I think 119 was the last one.
This is 119. that we have on the
119,
screen.
so 116, 117, 118, 119.
All right, we want to start with 116. Could you move back to 116?
If we can go back to what that was, I believe it was the screenshot of CBRN with the 1923.
Do you have any objection to 116?
No, Judge.
Okay, 116 is in evidence. 117, which is the next one. If you could, any objection to that?
No, Judge.
Okay, 117, and then 118.
No, Judge.
All right, and 119.
No, Judge.
All right, should, just to clarify, should 119 be under seal since there are names of a lot of individuals that are not involved in this case?
Yes.
Okay.
Thank you.
Is that okay with you, 119 under seal?
Yes.
Okay, 119 is an evidence under seal. We're going to stop right there, Mr. Carroll. I'm going to stop because we're already past
Okay.
5:30, okay? So ladies and gentlemen, we're done for today. We'll start back up at 10 a.m. tomorrow. So don't do any outside research. Don't talk to anybody about the case, okay? We'll see you in the morning. You can stay right there for a second, that's fine. All right. Detective Miller, since you're still in the middle of your testimony, don't discuss the testimony at this point with anybody, okay? All right, thank you. You can step down. All right, so have we worked on jury instructions?
Mine are in my office right now. I'm going
Okay.
to send them to them tonight.
All right, 9 o'clock tomorrow, we're going to go over jury instructions, okay? 9
That's
a.m.
fine, Judge.
Tomorrow, we'll do jury instructions. How many more witnesses do you have after Detective Miller?
Potentially 3.
3 witnesses, so you
Yeah.
should be done tomorrow, is that correct?
I don't know.
Okay,
Could be, I don't know. It could be long.
okay.
I'll try.
All right, we'll see about that. And then you said your rebuttal evidence is not.
Judge, I think, yes, we have 2 witnesses at most.
Okay, so there is a possibility we might be able to get done tomorrow. My goal would be to get done with the evidence tomorrow and then have closing arguments whenever we come back from the snow. Have our jury instructions already done and closing, if we can get there, okay? But I understand your witnesses. If we don't get there, we don't get there.
Right.
But if we have a 5-day break in between something, that's what I'm trying not to do. I want to try to get all the evidence in and then have a 5-day break and then do closing arguments. But,
Right.
I mean, if we can, if we have to stay a little longer tomorrow night, I don't think any of them would mind. So
Right,
keep that in
right.
mind to be ready to finish everything tomorrow, if we can.
Judge, we were ready to finish everything today.
Well, I understand that. Okay, if it can be done.
Judge, as a little update, we just were told that,
I was just saying, there's a nationwide Microsoft outage causing our email to be down.
Causing what down, to be down?
email to be down.
Our email in our office.
I'm, okay, well, you'll figure it out. I'm not worried.
We'll figure it out.
Yeah.
The other thing, not just another housekeeping matter, Exhibits 10 and Exhibit 16 have the included pages.
10
And I can share that with counsel,
let me
and then
go
we can address that tomorrow.
Back to defendants 10?
Yeah, 10 and 16, Judge, they were the letters that it said
That
2
were
out of 3.
truncated. Yes, the letters that were 2 out of 3 pages, and then the other one just stopped after
Okay.
2 pages, and we anticipated that there was more.
All right, so you need to add more to one of these.
They're already done. I'm just going to share them with counsel, and then we'll be ready
All
to.
right, but 10 was never submitted into evidence.
Correct.
Only 11. So we have to update 11. But we need to update 10 as well. 'Cause
We
it's
would
pretty-
Well,
need to
10
update
wasn't
both.
submitted because
It
one,
wasn't, oh,
the one page
They were not
was.
admitted.
So now 10 is admitted.
Once we.
Once you
see
get
the-
I'll share that with them
All right.
if
10
Microsoft Edge doesn't.
and, was the other one, 11?
16.
16, 10 and 16, okay, got it, I got the 2, all right.
And so we
as
can
soon
do
as we
that
get
first thing. Yeah.
First thing in the morning, we can take care of that. I'll see you at 9 o'clock with jury instructions, okay?
Yes, if council wants to send that earlier, I mean, we're still waiting on yesterday's exhibits, so.
Oh, we don't have 82 yet?
I have a video that has been downloaded on the hard drive.
We haven't looked at it yet, reviewed it?
I have, yes. and
Okay,
it's
so that is
correct.
82.
Correct.
So we have 82 and 83.
I don't have 83 because it was under seal.
Okay, that's fine.
But the one that well, actually, I think I do have 83. It was the one that he gave me that was.
Right, I understand that,
82
but you have
yesterday.
all the videos there. But do you need today's video?
I do need today's without audio.
Without
And Judge, what I'm raising is the Commonwealth is still missing yesterday's exhibits that were supposed to be submitted by close of day. We never received copies. We addressed this morning that the link that was shared did not allow us permission. So
Oh, right, 'cause
we
it
still
went
haven't,
back
I
to-
can't confirm.
So
that-
82 and 83, you need, can we email?
I can email it. I can save it and email it to you all if you.
That's
want.
fine.
Well, we'll email 82 and 83 to you. Or
Okay,
Shannon
thank
will.
you. And then anything for today.
And then anything for today. we'll take care of.
82, so to clarify, 82 is the continuation of Beckner's video, the second half?
Correct,
Okay,
yes.
we don't, we need to see what's been submitted. I still don't
Right.
know.
That's fine. 82, you need 82 and 83, and then whatever from today.
Yes.
Okay? All right. We can do that. All right, anything else?
I don't think so, Judge.
Okay, all right,
Thank
9
you.
o'clock.
Thank you.
All the